they have done, they issued a notice stating that the property we have encroached, but not when we search the document. The document relates to the Malad where the property is reserved for Muslim and Adi Karnataka community. In that property Malad, there is no Malad grant being said in favor of the Panchayat is concerned.
How did you get your right?
We have been constructed and we have been running.
How did you get your right?
Possessory right.
Possessory right, sorry, next week.
Right since Monday,
It'll come next week.
right since the year 2007, I'm paying taxes under a consolidated SAS number. Now all of a sudden, DBMP comes and tells they have generated a new SAS number and to pay all the dues in that particular SAS number.
Even after payment.
Property subject matter of auction rate.
Monday.
Grateful, sir.
That is not a grave urgency, madam. Kodi, Monday Bharat.
Vacation bench. They passed order directing the respondent corporation to produce the affidavit within 15 days. Non-filing of affidavit is the 40B registered on the website. Hence my submission is to.
ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಹೇಳಿ ಅವ್ರಿಗೆ
Yes, I submitted.
ಅದು ಅವ್ರದ್ದು ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ನಾವು ಅಲ್ಲಿ ಹೇಳಕ್ಕಾಗಲ್ಲ ಅದು ನೀವು ಹೇಳಿ and how is your construction you verify from your client because we'll order inspection of your client also kodi not tomorrow company day madam kodi
tomorrow is the matter.
Tomorrow is a matter for what?
They are threatened that they are the.
Go file your objections. You have time to file a writ petition. You don't have time to file objections.
They are not the parties.
It won't be listed here. Before it won't be listed. ನಾಳೆ ಹೋಗಿ ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿ ರೆಗ್ಯುಲರ್ ಕೋರ್ಸ್ ಹೇಳಿ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಹೇಳ್ರಪ್ಪ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಅಂದ್ರೆ ಅರ್ಜೆನ್ಸಿ ಏನು ತಗೊಳ್ಳಿ ಅದನ್ನ March 9th ಫಿಕ್ಸ್ ಮಾಡಿ ಅದನ್ನ ತಗೊಳ್ಳಿ ನಿಮ್ 3 ದಿನದಲ್ಲಿ ಬರುತ್ತೆ ಅದಕ್ಕೆ ವೇಟ್ ಮಾಡಕ್ ಚಾನ್ಸ್ ಯು ಡೋಂಟ್ ಹ್ಯಾವ್ ದ ಪೇಷನ್ಸ್ ಸೊ ನೌ ಯು ವೇಟ್ ಫಾರ್ 1 month ಕೊಡಿ 9th ಕೊಡಿ ಅದು if you are moving what is the urgency Mr. Counsel there is no urgency for Khata affecting in 1 day all matters will come in 3 days even all of you know about it if there is a matter of urgency please move it we are not saying no to moving a matter but if you move for Khata for 3 days that is told in these 9th March list ಮಾಡಿ ಕೊಡಿ ಮೆಮೊ ಕೊಡಿ
That's the
ಕೊಡಿ now that you have moved 9th March list ಮಾಡಿ that's what we will be doing now if you move these kind of matters we have not come to you without ಅರ್ಜೆನ್ಸಿ ಏನಪ್ಪ 3 ದಿನದಲ್ಲಿ ಬರುತ್ತೆ ಕೊಡಿ ತಗೊಳ್ಳಿ ಅದು 9th March ಮಾಡಿ ತಗೊಳ್ಳಿ if you keep moving like these matters it doesn't make sense
the matter is this, the GBA has issued a notification and then they're changing the boundaries of the constituency map and it is supposed to be finalized on 16th of February. That's the only limited
Monday.
My lord, officer delimitation.
Demolition order. When is this stated to be? When is the demolition ಅಂತ ಏನೋ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದಾರಾ? ತಗೊಳ್ಳಿ 2:30 ತಗೊಳ್ಳಿ. ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದಾರಾ? ಮಂಡೇಗ ಕೊಡಿ.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಿದೆ ಬಟ್ ಈ ಖಾತಾ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಕೊಡ್ತಾ ಇಲ್ಲ.
ಅದಕ್ಕೆ ಮೆನ್ಷನ್ಗೆ ಏನು ಮಾಡಬೇಕು?
R2 ಅವರಿಗೆ ಡೈರೆಕ್ಷನ್
ತಗೊಳ್ಳಿ 9th March ತಗೊಳ್ಳಿ ಅದು. ಎಸ್. How is it coming before LB? For property tax. OTS for property tax. Next week.
Adjournments, list number 1, page number 2, serial number 3 and 4.
My lord, either for petitioners, pray for time, my lord, there's some difficulties. I have informed all the.
No adjournment will be granted is what we have said last time. 2018 matter remanded by Supreme Court, no chance. If you are not going to argue, you are for whom?
Either for petition.
You are for the petitioner. No adjournment, Mr. Manmohan. Sorry, whatever difficulty, sort it out. Because we have specifically told you last time. The Supreme Court can't do it like this. You get a, you move the Honorable Supreme Court and get a observation. Is Gokarna matter tane? Shri Samsthana Gokarna antidella. There are two matters before us of Gokarna where there is a direction also issued. There is no direction in this. Monday. At the request of counsel for the petitioner, Monday. It's made clear that no further adjournment would be granted if arguments are not advanced. Petition would be liable to be dismissed for non-prosecution. Sorry, it's 2018 matter. We won't give you. Monday. Next. You can appear through VC. Next.
Page number 3,
12th, we have our schedule full. It doesn't mean that whenever you want, then no adjournment, argue today. Next.
page number 3, serial number 5 to 7. Page number 4, serial number 8 to 12. Page number 5, serial number 13 to 18.
Serial number 15, my lord.
ಏನ್ ಹೇಳಿ?
Respondent number 2 authority is making a mention. Respondent number 2 authority is not represented, served ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ.
ಹೌದು.
Ravishankar may be directed to take notice.
ನಿಮ್ದೇನ್ ಸಬ್ಮಿಷನ್?
ನಂದೇನಿಲ್ಲ.
ಏನಿಲ್ಲ. 13 Shri A. Ravishankar is directed to accept notice for respondent number 2. Counsel for the petitioner to serve 2 sets of the petition along with annexures on the said counsel who is granted 3 weeks time thereafter to file his objections. Relist on 4th March. IA 1 of 21 is allowed.
Please.
Kindly, my lord. Serial number 15, my lord. And for respondent, my lord, I inform the petitioner. I place 2 weeks time to file statement of objections, my lord.
15. Counsel for respondent seeks for and is granted 2 weeks time to file a statement of objection. Objections, if any, by 2nd March, relist on 5th March.
Much okay.
Page number 6, serial number 19 to 24. Page number 7, serial number 25 to 30.
Lord, serial number 25 for the petitioner, my lord.
Yes.
My lord, kindly place for a week's time, my lord, or else it may be taken up on Monday or Tuesday, my lord, 10th of February.
Have you informed the respondents?
We have informed, my lord. Yesterday
Request
itself.
of counsel for the petition relist on Monday.
My lord, serial number 29, my lords. The arguing counsel is unwell. If I can pray for a week's time, my lords.
Submitted that the arguing counsel for the petitioner is unwell.
Petitioner is unwell.
Relist on 19th.
The interim protection may be extended.
IO interim order is extended next date.
I'm great.
So, my lord, serial one submission. Serial number 25. Can it be taken up on Tuesday, my lord, 10th of
It
February?
will go to 19th. 19th.
No, my lord. Monday, my lord. Monday.
Page number 8.
My lords, 28, my lords.
Yes.
My lords, we are yet to receive the instruction. This is a Khata transfer matter. I've informed the other
You
counsel.
are yet to what?
Receive the instruction, my lords. So I
You are not getting instruction on CCMS, madam?
No, my lords, not yet updated, my lords.
Are you regularly getting instruction on CCMS? Only this matter?
Generally, it is not updated, my lords. They're yet to upload the information. It's not at.
Yenappa?
Gradual agtide, my lords. It is slowly being updated, my lords. Every day we are giving inputs and they are uploading it, my lords. So it is happening, you know.
So you're getting the documents, you're getting the instructions?
Yes, please, my lords. Now we are getting information through phone, through WhatsApp.
Phone, but CCMS?
Through CCMS. Gradual agtide, my lords. The
Phone-
system is.
Nade they file an affidavit saying that they have not instructed. So that is why CCMS, whatever you want to say, you put it on CCMS, it will come back to you through CCMS.
They're giving us hard copies sometimes. So that we are drafting an objection and uploading it in CCMS. So it's
In
gradually
your
happening.
interest, do CCMS.
Please, agree.
If you do a shortcut,
We'll be in trouble. I understand. My lords.
you, especially with BBMP, you know what is happening.
Please. Understand.
Don't get stuck in all those things.
In a phased manner, it is being implemented. My lords.
And counsel for respond number 1234 and is granted 10 days time to obtain instruction, make a submission. Relist on 19th.
Great.
Serial number 36, my lords. For the petition in this matter, my lords. But we had engaged Mr. Srinivas Raghvan in this matter. His mother is sick and he has informed that he is unable
It's submitted that that there's a personal inconvenience with the arguing counsel. Hence, adjournment is sought for relist on 19th.
interim order may be extended.
Interim order earlier granted is extended till next day.
Serial number 37.
35.
I appear for the respond number 6, my lord. I inform the petitioner, my lord, I seek 10 days, my lord, to file a statement of objection.
35. Counsel for respond number 6 seeks for and is granted 2 weeks time to file a statement of objections. Objections, if any, by 2nd March, relist on 5th March.
My lords, serial number 37, my lords. I am appearing for the petition. I pray for a week's accommodation. I have already informed the other side.
Mr. Counsel for the petition, relist on 19th March, 19th February.
IO may be extended, my lords.
Interim order extended.
Please, my lords.
List number 2, page number 3, serial number 14 to 16.
Not serial number 16.
Hmm.
Serial number 16, the respondent has filed their objection. The other two matters they have.
2020 matter. You not filed objections.
They have filed objections in only one matter, that is serial number 16.
They'll adopt in the other matter.
ಅದರಲ್ಲಿ ಮೊನ್ನೆ objections ಕೊಟ್ಟಿದ್ದಾರೆ ನಂಗೆ. I have to get some instructions from the client.
Let us see if they want to file objection in other matters.
Great.
Page number 4.
My lord, one submission, the matter that was just called out in the serial number 37, that is on cause list 2, my lords.
We are not called out any, we are still in the mentioning list, adjournment list.
Serial number 23, your lordship.
One ನಿಮಿಷ. 17 to 21.
23, my lord.
17 to 21 ಯಾವ್ದು ಇಲ್ವಾ? 23 ಹೇಳಿ.
I appear for petitioner. I seek for 2 days accommodation. I am not keeping well, your lordship.
ಎಲ್ಲ ಇವತ್ತು ಕನ್ಸಾಲಿಡೇಟ್ ಆಗಿತ್ತಲ್ಲ.
ಅದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಪುಟ್ ಅಪ್ ಆಗಿದೆ.
Objections file ಮಾಡಿದೀರಾ?
ಅದರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ನಾಗರಾಜ ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್.
I filed my objections, my lord. My lord, we have identified the place for accommodation of street vendors.
ಇವಾಗ ಯಾಕಂದ್ರೆ ಮಂಡೇ ಆರ್ ಟ್ಯೂಸ್ಡೇ.
ಒಂದ್ ನಿಮಿಷ ಇರ್ರಿ, ಅವ್ರು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಕೇಳೋಣ.
They are obstructing, my lord, day-to-day movements in the traffic also, my lord. We have identified for them.
Now you have identified the property.
Please.
They have been informed of the identified property.
My lord, but they are not vacating or shifting.
I will ascertain that.
You ascertain that. ನೀವು ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ ನಾಗರಾಜಪ್ಪ?
Connected
23.6 for my lord municipality.
ಸೊ ಅದ್ರಲ್ಲಿ ಬಾಕಿ ಇದ್ರಲ್ಲೂ ಐಡೆಂಟಿಫೈ ಆಗಿದೆ, ಓನ್ಲಿ ವಿತ್ ದಟ್ ಒನ್.
None matter.
ಇದು
Only in your matter.
ತುಮಕೂರು ನಾಗರಾಜ ಅಪಿಯರ್ ಫಾರ್ ತುಮಕೂರು. ಇದು ಬೆಂಗಳೂರು. ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಆರ್ ಬೆಂಗಳೂರು.
ಎಲ್ಲ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಕಂಬೈನ್ ಮಾಡಿದೀರಾ?
Police also, my lord, lodge a complaint against me for my lord, they have obstructed the traffic movement.
Trend is not well ante. 23.1 delete Pawan Kumar. 23.1 delete Pawan Kumar. 23.3 delete. 23.4 delete. 23.5 delete. Rest of all of them are BBMP limits.
Yes.
Only 23.6 is Tumkur. Turuvekere. So we'll dealing that matter and we'll take up that matter on Monday. 23.6 dealing and relist on Monday. The rest of the matters, objections hakidara?
They are not filed.
10 days time is granted to the respective respondents to file the statement of objections. Objections, if any, by 20th, relist on 24th. Interim order earlier granted. Aired order, interim order earlier granted is extended.
Page number 6, serial number 24 and 25. Page number 7, serial number 26 and 27. List number 2 for being spoken to serial number 1. R. Shashidhar.
Lords. This case, my lord, for respondent number 3, on the basis of the amendment brought to section 106 of the Act, my lord, my lordship was directed to issue the B Kata, my lord. My lord, earlier I am having the benefit of A Kata. Hence, my lord, I am having the benefit of the A Kata and manual Kata by the respondents, my lord. Thereafterwards, my lord, my application was rejected by them, my lord.
Where is that? Ekata?
Please.
Why did not you mention it?
My lord, sorry, my lord. I have instructed one of my friend to appear and take password, my lord. But respondent submits that, my lord. You have no of the amendment.
Annexure.
Please, annexure.
Our submission to
A and B, my lord.
appears that there is a new notification regarding issuance of e-Kata, my lords. And where it says e-Kata should be given, we'll clarify with instructions. Kindly grant us
If
2
he
weeks
already
time.
has a Kata, you can't change it to B Kata.
No, e-Kata ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದು. A register, B register amendment
A Kata. Earlier A Kata idre, you can't give a B Kata now. You give A Kata only.
It appears that new notification is passed with this aspect. We'll clarify this one. Let's kindly give us 2 weeks time.
2 weeks time. After disposal is being listed for being spoken to, 2 days time can be given, not more than that.
It may be listed on Monday.
The request will and council for respond relist on Monday.
1 and 2.
1 and 2, both. Both same, huh?
Same.
Serial number 3. K. Chandranath Ariga.
On behalf of the petitioner.
Yes.
Petition seeking mandamus to consider representation for a release of compensation. The fact is that the petitioner happened to release his portion of the property for formation of the road for obtaining the plan license, building license.
Who is for TMC Kundapura?
Ajit A. Shetty. Ajit A. Shetty.
So also is direct to accept notice for respond. Council for the petition to furnish 2 sets of the petition along with annexure and said council relist on 24th.
Please, oblige.
Serial number 4. Raja Ramesh.
I am the petitioner, my lord. At the time of widening the road, the respondent authority acquired our land and did not give the actual composition.
Acquired or used? Acquisition notification idea?
Ide, my lord. Gazette notification ide.
How are you filing for mandamus?
I give representation, madam. They cannot give actual composition to the land and.
Where is the notification?
Annexure B, my lord.
Award has not been passed at all.
No, my lord.
My lord, their prayer is that, my lord, tamarind tree was not considered while passing the award. The lordship may kindly go to page number.
Award has been passed, Ms. Pupaya.
That is not, I'm not aware, that I have to verify. But the representation which they have given, that tamarind tree in that 1080 square feet was not considered. That is the frame. The lordship may kindly go to page number 22. In that representation they have given. Page number 22.
22.
22.
22 is a notification.
No, but pagination is not given in this annexure A, my lord.
Annexure A. Annexure A is page 9. Notified final subsequent.
Second page.
Is there an award pass? Either not, in the joint measurement, this has not been recorded and thorough. But is there an award which has been passed? Because if an award has been passed, he'll have to go to.
4-1 notification is 5/3/2014. 6-1 notification is 11/7/2014.
Is there an award which has been passed?
That was,
If an award has been passed, he has to go before the
yes, madam.
reference court.
Reference code.
If there is no award passed, then we'll have to direct you to pass an award at the earliest.
Yes, madam.
So what is the status and the verify mark?
I will verify the state.
My lord, the similar matters was disposed before this honorable court, my lord.
Is there an award passed in your matter?
Yes, my lord. The award passed, my lord, but they cannot.
Early the
give
award
order.
early there. Where is the award?
Annexure B, my lord. Annexure C, my lord.
Annexure C is not the award. Payment list adu bere. Where is the award? And AGA accepts notice for respond number 1, 2, 4. Ole Narsipura, MS Devraj for respond number 5. And AGA is granted 10 days time to obtain instruction, make a submission as to whether an award has been passed post the acquisition. If not, by when it would be passed. Released on 23rd.
Much obliged.
Serial number 5, Varun P.
Lord, I appeal for the petitioner's counsel.
Yes, Mr. Papireddy.
Lord, Annexure K is the impugned resolution passed by the respondent Panchayat, cancelling the kata without notice and without assigning reasons.
Resolution has been passed.
Yes, Lord. Resolution at page number 73.
73 resolution will take action is cancelled.
Yes, my lord. Kata has been cancelled. Civil court has granted a decree for permanent injunction.
Seal number?
Thousands. Lord, at seal number 6, last matter.
Yes.
This has been cancelled without notice.
Hmm.
And the civil court has granted permanent injunction, brought decree for permanent injunction in 2017 itself. Appellate court has confirmed.
Permanent injunction is only as regards not in accordance with law. Active. It can't be said permanent injunction will be for all purposes. If they have done it in accordance with law,
it
will be proper. If
decided
no
on
notice has
merits.
been issued, is not referred.
Resolution is concerned, resolution, any order is concerned, 216 an appeal before the executive officer.
But resolution without notice,
What notice is for violation?
without hearing national justice, without.
Adatra equity, but another, any order.
All these things are becoming a problem for citizens.
Yes, I agree.
You
What is
pass
it?
something without this, go for alternate remedy and theoretically you'll get them stuck there.
Act clear says that any order passed by the PDO, but notice ಕೊಡ್ಬೇಕಾಗತ್ತೆ ಅದನ್ನ
Notice ಕೊಡ್ಬೇಕು. You notice ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ we'll set it aside, then you issue him a notice and then pass orders. Do it in accordance with law.
Yes, I agree.
Verify ಮಾಡಿ notice ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. Shri MS Devraj accepts notice for respondent. The submission learned counsel for the petitioner is that the impugned resolution has been passed without issuance of notice to the petitioner and hence there is a violation of the principles of natural justice. A peril of the resolution at Annexure K does not indicate any notice having been issued to the petitioner and consideration of said notice. In that view of the matter, the resolution dated 10/10/25 at Annexure K is stayed till the next date of hearing. Shri MS Devraj is directed to obtain instruction, make a submission as to whether any notice had been issued and any response received from the petitioners before the resolution was passed. Released on 23rd February.
Serial number 6.
For issue of birth certificate, my lord. I've mentioned the address where I am residing, my lord. But I have birthplace, my lord, I have submitted representation to correct the birth certificate by mentioning the birthplace, my lord, by giving necessary proof, my lord. For that, my lord, I have submitted representation on 14/11/25, ink page number 16, my lord. To consider it and to issue necessary certificate by mentioning the birthplace address, my lord, in the birth certificate under Annexure C.
Your age 60 years.
My lord,
You want a birth certificate
ಅಲ್ಲ
of
ಬರ್ತ್
60
ಸರ್ಟಿಫಿಕೇಟ್
years?
ಇರ್ಲಿಲ್ಲ, ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಅಪ್ರೋಚ್ ಮಾಡಿದೆ.
60 ವರ್ಷದ ಹಿಂದೆ ಅದು you want to take.
ಅಲ್ಲ ಬೇರೆ ಪರ್ಪಸ್ಗೆ ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಲ್ದಿರ ಆಗಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ
ಏನಕ್ಕೆ ಬೇಕು 60 ವರ್ಷ ಆದ್ಮೇಲೆ? ಇಷ್ಟು ದಿನ ಬೇಕಾಗಿಲ್ದೇ ಇರೋದು ಇವಾಗ ಏನಕ್ಕೆ ಬೇಕು? How do they verify what your address was at the time of your birth?
My lord, I have given the proof, my lord.
What have you given?
My lord, school
What proof have
certificates
you given?
ಸ್ಕೂಲ್ ಸರ್ಟಿಫಿಕೇಟ್ಸ್ ಅವೆಲ್ಲ ಇದಾವೆ.
ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
I have produced it, my lord.
So produce the document.
Please, my lord, please, my lord, I produce it.
You
Please,
suddenly changed to 60 years ago andre.
Please, my lord, your lordship kindly have it next week, my lord, I will secure.
Pawan Kumar accepts notice for respondent number 1 and 2. Counsel for the petitioner seeks for and is granted 10 days time to place on record the documents evidencing the address of the petitioner at the time of his birth and thereafter, including school certificates, etc.
Please.
Released on 24th February.
Much.
Serial number 7.
The petitioners approached this honorable court by challenging the annexure A series, my lord, which is order passed by the fourth respondent under section 12 and 22(1) and 3 of Karnataka tank conservation. Yesterday, one matter your lordship was pleased to grant.
The layout formed by
Yes,
the.
my lord. Yes, my lord.
And AGA accepts notice for respondent number 1, 2, 4.
Yes, my lord.
Jaglur MS Devrajal. Yaru? NR Jagdishwara for respondent number 5 and 6. The submission of the counsel for the petitioner is that the layout in question had been formed by the town panchayat and allotment made to the petitioner. The operation of the orders passed by the fourth respondent dated 12/12/25 at annexure A, A1, A2, A3 are stayed till the next date of hearing. Connect with WP.
2797, my lord.
And relist on
2797.
ಬರ್ತ್ ಕೊಡಿ, ಡೇಟ್ ಯಾವ್ದಿದೆ?
ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್ ಕೊಡ್ತೀವಿ.
ಸರ್ ನೋಡ್ತೀನಿ ಸರ್.
ಎವ್ರಿ ಮ್ಯಾಟರ್ ಇಸ್ ಡೇಟೆಡ್.
ನಾನು ನೋಡಿ ಬರೆದು ಕೊಡ್ತೀನಿ ಸರ್.
ಡೇಟ್ ಬರ್ತ್ ಕೊಡಿ ಅದು.
ಪ್ಲೀಸ್ ಮೇಡಮ್, ಪ್ಲೀಸ್.
Serial number 8.
Yes, Balraj.
My lord, appeal for petitioner, my lord. My lord, mandamus to extend the benefit of the order of this honorable court for change the similar matter. my lord.
Similar matter.
Yes, my lord. On
What was that?
17th, my lord. On 17th it is listed.
Number ಹೇಳಿ.
Number I'll give furnished, my lord.
And ಬರೀ ನೋಟಿಸ್ ಆಗಿದೆ ಅಲ್ಲ?
Notice.
And AGA for respond number 1,
To
Ramnagara Urban
Kiran
Development
Kumar, my
Authority.
lord. TL Kiran Kumar.
TL Kiran for respond number 2. Connect with so and so and relist on
17th, my lord.
17th.
Please.
Serial number 9.
I withdraw the petition.
Yes.
Impugned order is at annexure A, my lords. A provisional sanction plan has been issued in favor of the respondent number 2 by the respondent number 1, my lords. That's petitioners are the owners of survey number 71, my lords. And respondent is the owner of survey number 98 and 97, my lords. He has formed a layout. And to reach his layout, he has taken 12.5 guntas of land belonging to the petitioners, my lords.
He has purchased.
He has not purchased, my lords.
ಮತ್ತೆ taken ಅಂದ್ರೆ ಅರ್ಥ?
He came near the property to form the road. Then we protested. Then we lodged a complaint. He went and secured an interim order not to interfere with the peaceful possession. During that time, we came to know there has been a decree obtained behind my back for claiming easement rights on the property. That decree I have produced.
Yes.
Page number 26. In the year 1996, where a fraud has been played against us.
So you have to challenge that decree.
We are challenging the decree. Now we realized, page 30 is the typed copy. Issue suit summons and amendment notice on IA against defendants returnable 27/1996. Then PDM advocate, applicant files an application under section 151.
Even without getting into that issue, even if we're assuming that it's fraudulent, you have to challenge it.
We have already initiated that process, my lord.
Yes.
And we have
Get
also
the order, interim order in that if what you are seeking for here, you have to seek for the interim order there. You cannot say this court should restrain.
No, my lords, only in respect of not to release the site arts, that's all.
That is not
In-
something, don't try to use this for settling your civil disputes. Don't try to use the government departments for that, or this court for that. You file your appeal, if you succeed, you will get it, otherwise no.
In the suit filed by him, he has already undertaken that he will not farm the road. My apprehension is only because this manners, I gave a representation to MUDA, and they say that will not come in the way of releasing the order. That was my apprehension is. That is the
That
only
is not-
concern.
That release of his sites is in his property, not in your property.
No,
The
my lords.
dispute between you is the road. You are not claiming any right in survey number 97.
No, my lords.
So release of sites in survey number 97.
They will use my road, my property to access. This is a landlocked
But
property.
you have to get an injunction in that appeal that you have filed.
Well, if that is the case, sir.
TP Vivekananda, what do you want to do? You want liberty or you want us to
Liberty
dismiss
so that I can approach there. In the meantime, I may be.
TP Vivekananda is directed to accept notice for respond number 1. Notice to respond number 2 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. After arguing for some time, learned counsel for the petitioner seeks for liberty to file necessary applications for injunction or otherwise, injunction and the like reliefs in the appeal filed or to be filed.
To be filed.
In the appeal to be filed by the petitioner. Reserving such liberty, petition stands disposed. It's made clear that this court has not made any observation on the merits of the matter.
Please, oblige.
Serial number 10.
Siddaramaiah. Pasu.
Serial number 11. Vivekananda N.
Petitioner. Lord, the petitioner's application for impleading before the Chief Commissioner, my lord, has rejected. The
Where
petitioner.
do you want to implead yourself?
My lord, I am adversely affected by the illegal construction by the third and fourth respondent, my lord. I made a complaint before the Chief Commissioner, which they didn't take any action. So I filed a writ petition before this court. This court directed the town planning authority to file an report, my lord. In that, the report was filed and the demolition order was passed. Hence, my lord, they have challenged the demolition order before the Chief Commissioner.
And you want the appeal proceedings to be stayed?
My lord, any date may be fixed, my lord, because for arguments, the tomorrow matter is settled down for arguments. I become the necessary party because
we have to allow your petition. We have to issue notice to 3 and 4.
Yes,
we can't pass any orders,
my lord,
without notice to them.
Yes, my lord. Tomorrow it
will
is set
issue
down.
notice and it will come back after 1 month.
My lord, I'll take hand summons, my lord, or I'll serve the counsel who is representing them.
Kumar accepts notice for respond number 1 and 2. Issue emergent notice to respond number 3 and 4. Petitioner is permitted to take out hand summons on respond number 3 and 4, as also on the council appearing for respond number 3 and 4.
My lord, if
released tomorrow, released Monday.
My lord, if orders are passed tomorrow, my lord, let the orders not be passed, my lord. I have serious grievances, my lord, because I am
You
directly.
are only a complainant.
My lord, I'll make out, my lord, because there was a seepage of water, my lord, in my flat due to the illegal construction, my lord.
You
If
are
order
only
is
a
passed,
complainant, Mr. Counsel. You serve it on them and come. Then let us see.
my lord, next. It may be stayed, my lord, because tomorrow it is settled down for arguments.
We won't stay those proceedings.
Great.
Serial number 11.
For the petitioner.
What is this permission you are seeking?
The order passed by the regional commissioner. This is with regards to a contempt petition where they have taken an undertaking that they will agitate their rights before the OS court. And we've also filed an injunction suit where there has also been a similar order that is passed.
What is IA 1 of 26?
IA 1 of 26 is not to interfere, your lords.
1 of 26 permit you to file the above writ petition.
And also there is a writ petition that is already passed by this honorable court here.
Can you answer the question, Mr. Counsel? What is IA 1 of 26?
Not to interfere. Oh, 1 second.
That's a wrong submission. You're not a party to those proceedings.
No, I'm not party to that proceeding, your lords.
Then your submission cannot be considered until note.
But can you pass over the matter?
So what is your grievance now?
that I was not made a party, Your Lords. One is that, and there is similar order passed in the writ petition, Your Lords, as part of Annexure E.
Shri Learned AGA accepts notice for respondent number 1. Shri Pawan Kumar accepts notice for respondent number 225. Issue notice to respondent number 6 returnable by 3rd March. I 1 of 26 shall be considered after service of summons.
Please, Your Lords.
For dismissal, serial number 13. Shivshankar K.
It's appear for the petitioners. That's petitioner as 13. 13. That's petitioner as questioned. The annexure J minutes issued by the Panchayat. That's the
Yes.
action notice.
Auction notice.
Yes, minutes annexure J page 34 dated 8/3/2018. That's prior to that, minutes in the year 2003, minutes the shops have been allotted to the petitioners. They are in continuous possession and enjoyment of the shops are concerned. Minutes again in the year 2015, minutes the fresh rental agreement has been executed and enhanced the rents and shops have been allotted for 3 years. Minutes immediately annexure B has been issued without issuing notice to these petitioners. Annexure B has been issued on 23/2/2018. That's the action notice. Action the shops. That's the date has been fixed on 3/3/2018. That's as per annexure B. That's prior to 3/3/2018. That's annexure C. That's we have given representation that we are in possession of the shops. That's we are ready to pay the enhanced rent is concerned. But consider the
You have
request.
continued for 7 years. Additionally, without doing anything, next auction notification, you can participate or exercise your right to first refusal. Only these two things.
But we are ready to participate.
Participate. You did not participate last time.
No, immediately we have filed this.
Your representation was not required to be considered.
Then minutes immediately.
You had only
again,
to participate in the auction.
We are ready to participate. Let's consider our request.
7 ವರ್ಷ ಆಯ್ತು.
ಎಲ್ಲದಕ್ಕೂ ಏನ್ ರೆಂಟ್ ಮಿಲಟ್ಸ್ ನೌ ದೇ ಫಿಕ್ಸ್ ವಿ ಆರ್ ರೆಡಿ ಟು ಪೇ at least consider this request.
Prakash, you are appearing for respondent number 3. When are you going to hold the,
We are giving them option to participate.
when are you going to have the next auction?
Next action, a date will fix it, my lord, so that I can instruct them in the.
ನಿಮ್ ಪ್ರಕಾರ, you have to do your formalities.
ಇಲ್ಲ, ಆಗೋಯ್ತು, participate ಮಾಡ್ಲಿಲ್ಲ.
ಅದು ಬಿಡಿ, your formalities complete ಮಾಡಕ್ಕೆ
Of March,
3 ವಾರ 4 ವಾರ ಎಷ್ಟು ವಾರ ಬೇಕು?
ಶುಕ್ರವಾರ.
Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner when he had approached this court in the year 2018 is that the petitioner, being in possession or occupation of shop number 3, the said shop being proposed to be auctioned by respondent number 3, the petitioner had submitted representation that he would enhance the rent by 10% without considering the said representation. It was alleged that respondent number 3 was going ahead with the auction of the premises in question. It is in that background that interim order was granted by this court and the matter has been pending for last 7 years. Learned counsel for, there is, in terms of the circulars which have been issued in respect of the properties of the Gram Panchayat and other municipal authorities, the methodology of operation is for an auction to be conducted where the existing tenant could participate. In the event of the, in the event of the tenant, existing tenant, prior to the auction, deciding that he would not participate in the auction, he could decide to exercise right of first refusal after the auction is concluded in terms of the applicable circulars. The only methodology of disposal of public property being through auction and right to first refusal, the question of consideration of a representation for enhancement to arrive at a private treaty or a private arrangement between a lessee and a municipal authority is not permissible. Learned counsel for the petitioner, faced with the above situation, submits that he would participate in the next auction and or exercise his right of first refusal before the auction is to be held. Learned counsel for respondent number 3 submits that given 4 weeks time, the next auction would be held. In that view of the matter, I pass the following order. Writ petition is
Let's let them intimate.
Before participation, whatever the dues went, let him pay.
obviously, without that you can't.
Let's let them intimate with regard to the date is concerned, but auction is.
ಅದನ್ನು ಹೇಳ್ಬಿಡು.
ಇಲ್ಲಾಂದ್ರೆ
In that view of the matter, I pass the following order. Writ petition is partly allowed. The petitioner is permitted to either participate in the next auction to be held by respondent number 3 or to exercise the right of first refusal in terms of the applicable circular. Needless to say, for exercise of any of the above options, the petitioner would have to have cleared all pending dues. The pending dues to be intimated by respondent number 3 to the petitioner within 1 week from today, that is on or before 13th February 2026.
Same connected matters.
Ella same.
Same.
13.1
Different
shop
shops.
number.
First one is 3, shop number. Second one is,
Yes.
Shop number 4. Yes. 13.12 shop number.
4. 4.
13.1 ಅಲ್ಲಿ ಯಾವುದು 13.2 ಅಲ್ಲಿ ಯಾವುದು
13.2 shop number 6.
number 6. 13.2 shop number 6. Yes.
24060 is concerned, but shop number 4. Second one. First one.
B group matters, serial number 14. Devi Prasad Shetty.
ದೇವಿ ಪ್ರಸಾದ್ ನೆನೆಯಿಂದ ಇವತ್ತು ಬಂದಿದ್ದಲ್ಲ. ಎಸ್. ಎಸ್. What is the extent of violation?
Lord, in this case, now in the.
What is the extent of violation, Mr. Devi Prasad?
My lord,
The
basement, my lord, they have constructed 240 into.
File something, file a statement of what it is.
My lord,
Your oral submission we can't take note of. Inspection report ಇದೆಯಾ?
ಇಲ್ಲ.
we have.
In fact, our last time,
C is the document.
last time ತಾವು ಹೇಳಿದ್ರಿ ಅವ್ರಿಗೆ ಫೈಲ್ ಮಾಡೋದಕ್ಕೆ.
Both the council ಅಂತ ಹೇಳಿದ್ವಿ, ನಿಮ್ಗೂ ಹೇಳಿದ್ವಿ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ
What will you do to remove ಅಂತಾನು ನಿಮ್ಗೂ ಹೇಳಿದ್ವಿ.
ಹೌದು ಹೇಳಿದ್ರೆ. ನಾನು ಏನಾಗಿದೆ ಅಂದ್ರೆ 2.41 cents of my land, my lord, we have surrendered for widening of the road. Not at their request, free of cost. Then, my lord, then they themselves said you file an application for regularizing the basement ಅಲ್ಲಿ 2 ಅಂಗಡಿಗಳು ಮಾಡಿದ್ದಾರೆ. ಫಸ್ಟ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ, ಫೋರ್ತ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ ಖಾಲಿ ಎಂದು ಇಟ್ಸ್ ನಾಟ್ ರೂಫ್, ಒಂದು ಶೀಟ್ ಒಂದು ಹಾಕಿದ್ದಾರೆ ಫೋರ್ತ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ. So therefore, they said you file an application, we'll regularize it. In fact, my lord, we filed the application also.
That they can't regularize a basement.
So that not.
If some officer has
TDR
misled
ನಮ್ಗೆ
you,
TDR ಕೊಟ್ರೆ, now we can use those TDR for the not.
Even
ಇವಾಗ
TDR that.
ಏನ್ ನಿಮ್ಮ violation ಇರೋದು basement.
Basement.
Excess construction ಇದೆಯಾ?
Excess construction fourth floor ಅಲ್ಲಿ it's a sheet ಹಾಕಿದ್ವಿ ಅಷ್ಟೇ.
Excess ಇದೆ.
Excess ಇದೆ. Fourth floor sheet. Not the not concrete structure.
If you tell, ಎಲ್ಲಿದೆ violations? Where is the order?
Annexure C. Page number 30. ಅಲ್ಲಿ, there are 3 violations. my lord.
ನೆಲ ಕೆಳಗಿನ ಮಾಡಿಯಲ್ಲಿ ವಾಹನ ನಿಲ್ದಾಣಕ್ಕೆ ಕಾಯ್ದಿರುವ 240 basement shops. 375.18 ಚದರ ಮೀಟರ್ ವಿಸ್ತೀರ್ಣ.
One. Not a translated copy ಇದೆ. Page 27. Basement floor, page 27. 367.18 meters commercial. From the ground floor.
A basement has been converted, parking space has been converted to commercial purpose.
See,
Fourth floor
it is
is
not,
mentioned
you
ಮಾಡಿಲ್ಲ.
showed us this, but it is not clear. One is basement, that is clear, no problem. The 371.18 square feet in the square meters in the fourth floor, that is clear. Third item, ಅರ್ಜಿದಾರರು ಕಟ್ಟಡದ ಮುಂಭಾಗದಲ್ಲಿ ಹಾಗೂ ಉತ್ತರ ಭಾಗದಲ್ಲಿ
ಬಾಲ್ಕನಿಯನ್ನು
How much? How much? So how much is to be removed? See, two aspects we have to consider. They have given a relinquished
2.41 cents.
2.41 cents, free of cost.
My lord, let them make an application, my lord, before the corporation for the TDR, my lord, with respect to TDR.
We'll direct you to issue TDR. You take it free of cost and thereafter say they have
My lord,
constructed
it's a subject to
more.
condition, my lord. The sanction plan as issued, my lord, is subject to condition for relinquishing the land, my lord, that they are claiming. Not,
So 2.41 cents andre, it will be roughly how many square feet?
Almost 100.
in fact, they have not
1
produced the
cent.
relinquishment deed, my lord, here. They have not produced the relinquishment deed.
1050.516 square feet ಆಗುತ್ತೆ 2.41 cents.
They have to execute the relinquishment deed to that effect. They have not produced.
1 cent is 443.
435.6
Into
square.
2 point?
Not 2.41.
01.
That will come to 1050.516.
Yes, and
Square
FIR
feet.
ಎಷ್ಟಿದೆ ಇಲ್ಲಿ?
Please, my lord.
How much is the FIR?
Extend.
Two ಇರ್ಬೋದು maximum. 1.75 ಇಲ್ಲ 2. That is 2,100 square feet. 375 square meters cannot be included in that. That is 3,750 square feet, I think. So that will have to go, depending on the balcony. Maybe only balconies can be saved. Your fourth floor you'll have to remove, basement you'll have to remove. File an affidavit, we'll direct them to consider that whatever is in excess,
Whatever
to
is
the
in
TDR, you will remove. Basement you will remove on first year. Whatever is in excess after adjusting the TDR, you will remove. You file an affidavit. When will you do that?
On the 2 weeks time.
Land Council for the petitioner admits that an extent of 2.41 cents belonging to the petitioner had been given up by the petitioner free of cost for widening of the road, averting the land of the petitioner. And if the TDR for the same is issued to the petitioner, then many of the violations pointed out by the respondent would be saved.
Is not yet issued, no, TDR is not yet issued.
If it is issued, would no longer be a violation. His submission is that after adjustment of the TDR, if issued, after adjustment of the TDR as and when issued, whatever the violations are available thereafter would be voluntarily removed by the petitioner. Insofar as the usage of the basement for establishment of commercial shops, his submission is that the said shops would also be removed within a reasonable period of time. He seeks for and is granted 2 weeks' time to file an affidavit of the petitioner indicating the above and placing on record the time frame in which the above would be done. Released on 23rd February.
Serial number.
Interim order earlier granted is extended next week.
Rahul S. Reddy.
My lords may recollect this matter. This is with respect to an alternate or shop allotment. I am in possession of a shop and I've been paying
You
rent.
only recall that there is a lot of adjournments which have been sought for.
On Monday, the matter had
Finally, we observed that no adjournment will be granted. Really?
On Monday, the matter was listed, my lords. This is a
petition, my lords, wherein the BBMP will pass a resolution wherein they allot an alternate shop for me for an existing shop.
This is that shop number.
Please, my lords. 33C is the shop which is allotted to me. Now I sought for an alternate shop which was vacant, that is shop number 51.
Yes,
BBMP will pass a resolution.
Would it be the same thing and that?
My lords, the BBMP is explaining why the other alternative sites were allotted. They have produced two documents where alternative sites have been allotted without auction. And my lords asked us to verify how can that. So
If they have done it for them, why not for him?
Yes.
My lords? Yes, my lords. My lords,
Because
before that,
the same size will still be available for you to auction.
my lords,
The same size of a shop will still be available for you to auction.
not really. He's asking for a shop which is bigger than the shop which is already occupied.
Size is different.
How the? Of course.
As per my instructions,
that-
my lords, it's the same size.
No. The size which he's occupying, my lords, is 120 square feet. The alternate shop is 210 square feet.
Double.
Almost. My lords,
ಆ ground ಅಲ್ಲೇ ಹೋಗ್ಬಿಡತ್ತೆ.
I have produced a memo on 3/11/2025, my lords. If that can kindly be taken up. This is not the first round of litigation in this matter, my lords. This is the fourth round. Use all those judgments. Madam, 3/11/2025.
Yes, we have got it.
Yes, ma'am. Kindly turn to document number 5, document number 6, which is at page 19, my lords. This encaptures all the rounds of litigation so far. Page 19. This is a judgment by Justice Rammohan Reddy, my lords.
2009.
Yes, my lords, it's been going on since then. I'll read out the fact. It's a short judgment. The petitioner has been in possession and occupation of an open space measuring 10 into 12 feet in Jayanagar shopping complex pursuant to a license issued by the respondent BBMP since the year 1992. And in the previous writ petitions and writ appeals filed before this court directions were issued to consider the petitioner's application for renewal, which when complied with, the license was renewed for a period of 3 years from 1/11/1999 and thereafter on 3/2/2005, having made an application for yet another renewal, the standing committee by resolution dated 13/1/2006 permitted the renewal of the license for a further period of 3 years therefrom. That resolution was referred to the government by the commissioner. A show cause notice was issued on 10/1/2007 under section 92(2) of the KMC Act. For short, the act, despite the reply, the state government by order dated 12/11/2007 cancelled the resolution of the standing committee, which was called in question in writ petition number so and so and writ appeal so and so. Whence the division bench by order dated 14/11/2008 directed the government to consider the petitioner's application for renewal, entitling the petitioner to the benefit of interim order. It appears that on 15/5/2008, the government cancelled the resolution dated 13/1/2006 and hence this petition. The grant of the state largesse must appropriately leasehold rights of the property belonging to the BBMP. It is elsewhere said it must be in conformity with the rule of law. Leasehold rights in public property must be put up for public auction, entitling every citizen to participate and offer bids so that the BBMP secures higher revenues. Apparently, in this case, such is not the procedure adopted by the BBMP. The petitioner has been successful in squatting over the public property for almost 2 decades. The period of 3 years commencing from 13/1/2006, the date of the resolution of the standing committee having since expired, the order of the state government cancelling the resolution is frustrated. Be that as it may, the learned counsel for the petitioner on instruction submits that if the shops which are vacant in the vegetable market of Jayanagar shopping complex belonging to the respondent BBMP are put up for public auction, this is the undertaking which he gives, the petitioner would participate and secure one of those shops on lease and shift his business, and if not successful in the auction, would vacate and deliver possession of the open space. This has not yet been done so far by him, despite this undertaking which is given to the
Auction
court.
happened, he did not participate.
Yes, he has not done so. Learned standing counsel for BBMP submits that the leasehold rights of the 2 shops bearing number so and so in the basement floor of the vegetable market would be put up for public auction, and if the petitioner is or not a successful bidder, must vacate and deliver vacant possession of the open space in question. The writ petition is accordingly disposed of, reserving liberty to the BBMP put up for auction the leasehold rights of shop number so and so in the vegetable market of Jayanagar shopping complex within 2 months from today, and the petitioner is granted 3 months time to vacate and deliver vacant possession of the same in the open space. Having given this undertaking, he is still sitting over the property since 2009, my lords, and he is asking now for a property in exchange which is twice as big as the property which is already in his name. Other fact, my lords, is this: the lease which was given to him was last renewed till 2020, and it has not been renewed since then. He claims to have been paying the rents to the BBMP I'm producing a memo right now. He's produced the checks which he produced before this court has bounced. He's not been paying any rents.
I should verify with that
Yeah,
aspect.
please.
What verification? These are all misleading the court.
No, my
No,
lords.
this is the bank endorsement
the
which I'm giving.
process.
I have
You're
produced a
seeking to
memo.
abuse the process of court. You can't be doing this kind.
My lords, I have, with respect to this judgment, my lords, the vegetable
Did you
market,
even mention that judgment in your petition?
please, my lords.
Did you bring it to notice of this court that that judgment had been passed?
No, my lords, that this said aspect has not been.
Why did you not bring it to notice? Why have you suppressed it?
Lords, in fact, there was no auction of the vegetable market.
Why have you
itself.
suppressed that order? Your basic duty is if there are any orders passed between the parties which has relevance or no, you have to produce it. Where it's in your favor, when it's in your favor, you'll produce it. When against you, you will not produce it.
This aspect has not been.
That itself is a good ground to dismiss your petition.
But however, my lords,
We'll
as
be
per-
dismissing your petition only for that reason. You have suppressed this material fact and you are trying to mislead. First thing that you said is the same size. That is why we asked madam, verify with the same size, what is there, this shop or that shop you can go. But even that shop also is not there.
that shop number 51 is vacant.
So what? Your 33C is already, your lease is expired.
But till date, we have been paying the rents, my lords.
Continue paying rent. We are not worried.
We are in
You
possession.
vacate and continue paying also, no problem. Corporation wants more money.
And with respect to this judgment, my lords,
Just because you pay rental doesn't mean you are a tenant.
my lords,
Take action against them.
Grateful.
if my lords may kindly see.
You don't take action, your officers there don't do anything.
No, I've instructed him to send a notice under the Negotiable Instruments Act already because it has been dishonored.
My lords may kindly.
Who is worried about deny act?
No, even that and then action to
It's a
vacate.
property of the state. It's a
Yes, ma'am.
property of the
Yes,
public.
my lord. They were only wary about the fact that the matter is seized by the court and should we take any matter will be exposed to
You
contempt.
should
My
file
lords,
an
now this
application
calling
to
out from my
seek for
process, I'll ask
action.
them to take. Yes, my
It's in Jayanagar shopping complex.
Yes, my lord.
And you are coming and saying 2009 the order was passed. What have you been done paying from 2009 till now?
There was no auction at all, my lords, with
The
respect
license
to
which
the.
was given until 2020 is what my instructions are. But now that my lordship wants us to take action, I will instruct them accordingly.
It is for you to discharge your
Yes, my lord.
statutory obligations, not for the court to tell you.
Grateful, my lord.
Everything need not be said by the court.
Yes, my lord.
If my lords
Petitioner
may,
is before this court
Ma-
seeking for the following leave.
may I seek kind indulgence of this.
No
my-
indulgence when you suppress.
No, my lords, my memo, my lords, my memo dated 10/11/2020. I'll just point out two documents, my lords. At page number 16, my lords. Before that, my lords may kindly turn to page number 18. Till 2020, my lords, there's an agreement. What is the procedure which happens for the renewal of the license, my lords? We will have to
Asking
issue.
for change of this one, that cannot be granted. Especially the size is different. You can shift from one shop to the other without even paying the rentals.
No, but my
And
lords,
increasing the size of your shop.
we would undertake that whatever the market price of that
Sorry,
shop-
Mr. Counsel, you want to do it, you participate in the auction for that shop.
Please.
Don't try to do all these things. We will be dismissing it by imposing costs. Petitioner is before this court seeking for the following reliefs. The petitioner claims to be in possession of shop number 33C in the Jayanagara shopping complex, who is stated to be in possession of the said shop for a long period of time, measuring 12 into 10 feet. The petitioner had submitted a representation seeking for exchange of the said shop with shop number 51 since it had fallen vacant, and contending that the respondents had agreed to hand over the said shop number 51. The petitioner is before this court contending that the said shop had not been handed over, and in that background, the subsequent cancellation of the earlier allotment stroke resolution allotting 51 instead of 33C has been challenged. The submission of the learned counsel for the petitioner initially was that shop number 33C and shop number 51 being the same size, shop number 51 would be better suited for the petitioner to carry on his business. And it is in that background that a request had been made. Notice having been issued, response have entered appearance. Today, the counsel for respond number 3 and 4, by relying on an order passed by a coordinate bench of this court way back in the year 2009. And page number
19 minutes.
Way back on 27 July 2009 in WP number 8595 of 2008 submits that the petitioner had then sought for continuance in open space measuring 10 into 12 feet, which is what is now being numbered as 33C, and for renewal of the license for a further period of 3 years by setting aside the resolution of the standing committee calling upon the petitioner to vacate the premises. By relying on the same, he submitted that the petitioner was permitted to participate in a public auction, which the petitioner has not participated, in spite of an auction being held. And further, that the rentals, due rentals, month on month have not been paid. Even the check which has been issued, two checks which had been issued in respect thereto, have been dishonored for want of funds, as regard which the respondents are proposing to take action. Para. Okay, perusal of the, he further submit that there are 2 other rounds of litigation which has happened between the petitioner and the respondent, which have not been brought to the notice of this court when the petitioner has filed the above petition. A perusal of the writ petition only indicates that the petitioner has sought for change of allotment from shop number 33C to shop number 51. The earlier round of litigations have not been mentioned by the petitioner in the writ petition, which is a clear and categorical abuse of the process of this court by way of suppression of material facts. It being material on several accounts, more so on the account of the said lease of the petitioner having expired, there is no lease in currency in respect of shop number 33C as on date, the lease having expired in the year 2020. The petitioner has also chosen not to mention anything as regards the payment of the due rentals and the defaults committed by the petitioner in respect of the payment thereof. Lastly, it was sought to be contended that shop number 33C and shop number 51 were of the same size, and as such, that the exchange would not be prejudicial to the interest of the BBMP. In the present matter, when the lease/license of shop number 33C has expired in the year 2020, the question of the petitioner seeking for an exchange with shop number 51, which is of a higher size, would not arise. The suppression of the earlier litigation going to the root of the matter and being material to the facts and circumstances would clearly establish that there is an abuse of the process of court resorted to by the petitioner, requiring that this court does not exercise any equitable indulgence to the petitioner. Be that as it may, even on facts, there are no facts made out for exercising equitable indulgence of exchange of a shop in favor of the petitioner. In that view of the matter, I pass the following order. Writ petition is dismissed. Liberty is reserved to the respondent to initiate such action as is permissible under law.
Serial number 16. Chandan K. Connected matters.
Petitioner in this case.
Yes, what were you submitting, Chandan?
Lord, in 16, they have filed their objections.
16 objections have been filed.
The other two matters, 1 and 2 objections are not.
16.2, I filed an
16.1 and 2?
16.2, I appear for BBMP, my lord. I filed my objections.
No,
Allah,
16 is
16 you appear.
You appear in
SN
16.
Prashant Chandra appears in 16.1 and 2. Why does BBMP give two different councils when they are connected matters? How many times we have asked you?
What happens, we will never be knowing.
They know, alva.
ಅದೇ ಅವರಿಗೆ ಏನಂದ್ರೆ ಅಲ್ಲಿ ಮಲ್ಟಿಪಲ್ ಲೀಗಲ್ ಆಫೀಸರ್ಸ್ ಇದೆ ಅವರದ್ದು ಏನೋ ಒಂದು ಲೆಕ್ಕಾಚಾರ ಕೊಡ್ತಾರೆ ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ ಇಲ್ಲಿ ಬಂದಾಗಲೇ ಗೊತ್ತಾಗಲ್ಲ.
In lot of matters when it comes up, we have batch matters.
ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂತ
5-6 ಜನ ಇದ್ದಾರೆ BBMP. ಒಬ್ಬರಿಗೆ each one doesn't know what is happening in the other.
My lord, all these days, my lord, probably it was like that. Now that the CCMS has come into place, my lord, probably.
Oh, is it 20 matters?
In future, my lord. Basically, because what happens is one petition would be filed 6 months earlier, subsequent petition would be filed after.
Yes, but
So
you should
it is
try
only
and
for
see
this
that the
reason.
same council is given so that
Please, it would always be desirable, my lord.
all the
Convenient for
documents
all.
are available. Otherwise it creates confusion for each of you. So again, what do you want to do, Krishna?
annexure A may kindly be seen.
In 16, there is objection filed by Mallikarjun Reddy.
Yes.
You have not filed objection in 16.1 and
We have not filed them.
you want to file, you don't want to file.
But I may permit one sentence and if it is helpful to them, already your lordship can take it. 1.5% my lord interest on compounding basis ಹಾಕಿದ್ದಾರೆ.
What is it? So you are ready. You are ready?
My lord, they have filed certain notifications along with the objections of 2013 and 16. I need some instructions on that, my lord.
So now what do you want?
It is left to my land friend.
He wants time. ನೀವು objections file ಮಾಡಬೇಕಾ ಬೇಡವಾ?
I may not, it doesn't require.
It doesn't require. Land Council for respond number 2 and 3 in 16.1 and 16.2 submits that he does not wish to file any written statement or objection. He'll address arguments on the basis of the document, pleadings and documents on record.
ಒಂದೇ ಪಾಯಿಂಟ್ ಇರೋದು ಅದು.
ಏನ್ ಹೇಳಿ?
But 1.5% ಮೇಲೆ your lordship may kindly take page 13.
ಯಾವ್ದ್ರಲ್ಲಿ 16.1 ನಾ? 16.1 ಕೊಡಿ. Page 13.
Final notice dated 22/2020.
Page number?
Page number 13 ಮೇಲೆ.
13 ಏನಿಲ್ಲ. 13 is the verifying affidavit.
ಅದೇ ಇದೆ.
Annexure?
Annexure A.
Okay, annexure A, page 14.
14, please.
Yes.
But your lordship may kindly take the third para. ಆದ್ದರಿಂದ ಈಗಾಗಲೇ ಖಾತೆ ನೋಂದಾಯಿಸಿಕೊಂಡಿರುವ ಅಟ್ಟೂರು ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ಸರ್ವೆ ನಂಬರ್ 77 ಸ್ವಾನ್ಸೋ ಅಲ್ಲಿ 2,36,313 ಚದರ
ಇಲ್ಲಪ್ಪ ಎಲ್ಲೋ ಥರ್ಡ್ ಪ್ಯಾರಾನೇ ಇಲ್ಲ ಇಲ್ಲಿ.
ಅಂತಿಮ ನೋಟಿಸ್.
ಅಂತಿಮ ನೋಟಿಸ್
16.2 ನೋಡ್ತಾ ಇರ್ಬೇಕು.
16.1 ನಾ 16.2 ನಾ? Yeah, what is the writ petition number?
8324 of
16.2 it is.
16.2. ಇದ್ರಲ್ಲಿ ಪೇಜ್ 13 ಕರೆಕ್ಟ್ ಆಗಿದ್ದೀರಾ? ಆದ್ರಿಂದ
ಆದ್ರೆ ಈಗಾಗಲೇ ಖಾತೆ ನೋಂದಾಯಿಸಿಕೊಂಡಿರುವ ಅಟ್ಟೂರು ಗ್ರಾಮಕ್ಕೆ ಡಿಡ್ ಯು ಲಾರ್ಡ್ಶಿಪ್ ಗೆಟ್ ಇಟ್ ಮೇಡಮ್?
Yes.
ಗ್ರಾಮಕ್ಕೆ ಸೇರಿ ಸರ್ವೆ ನಂಬರ್ 77/1, 78, 79 ಮತ್ತು 80ರಲ್ಲಿ 2,36,313 ಚದರ ಅಡಿಗಳಿಗೆ ಸುಧಾರಣಾ ವೆಚ್ಚ 1 ಚದರ ಅಡಿಗೆ 250 ಅಂತ ನಿಗದಿಪಡಿಸುವುದರಿಂದ ನೀವು 54,99,544 ಉಲ್ಲೇಖ 3ರ ಆದೇಶದಂತೆ 1/4/2013ರಿಂದ 1.50 ಬಡ್ಡಿ ಗಳನ್ನು ಪಾವತಿಸಬೇಕಾಗಿರುತ್ತದೆ. This is under challenge. Your lordship may kindly.
So 1,24 lakhs was the demand made in the year 2020.
Can I kindly see the relief, my lord, sort in page 10. ಹೌದು, very relief is this 1.50 per month is incorrect.
Insofar as the interest.
Yes, my lord.
So you're not challenging the demand.
No, we are only challenging the interest. What we are saying, my lord, if I am paying these betterment charges.
That buddy itself is 69 lakh 18,086.
That may be modified in view of section 465.
2020 Municipal Corporation Act was approved.
Or at least a right may be reserved to the commissioner to act in terms of section 4. That's all.
That is, it will be hanging in my head forever, my lord.
ಅದು ಅವರೇ ಕೊಡ್ತಾರೆ ಅಂದ್ರೆ melody.
465 ಏನ್ ಹೇಳಿ?
Power of commissioner to agree to receive payment of expense in installments. ಇದರಲ್ಲಿ ಒಂದು ಅವರು ಒಂದು 9% ಗೆ ಹಾಕಿದ್ದಾರೆ. But this applicable to everything. Instead of recovering such expenses as aforesaid in the manner provided in section 470, 470 deals with.
So instead of 18%, you are saying it will be reduced to half of it, 9%.
If it is agreeable, not we can finish.
Mr. Krishna is giving you a settlement offer.
My lord,
because this notification has been cast, I am told by the division. So it doesn't. He demand notice ಕೊಟ್ಟಿರೋದು on the basis of one notification. And that notification has been already rejected in one written.
Then how can the demand be sustainable? ಏನು ಕೊಡೋದು?
But is in so far as interest only. But still my right is so far as 465 still there.
my lord, actually, if I am paying in installments, then the corporation is eligible to collect interest on that. But if I am paying it completely, then charging interest on me is not proper, my lord.
You non ಹೇಳ್ತಾ ಇರೋದು let them make whatever that we will take an action.
Why should they file a representation when you don't have the authority?
ಅವರದ್ದು ಪೂರ್ತಿ ಕೊಡ್ಲಿ interest anyway they have to pay the interest because they did not pay anything.
No, their demand itself is in 2020 and I have paid that betterment charges.
54 lakhs you have paid?
Yes.
You have paid?
That I have paid.
That will be considered. But what I am saying.
Even considered.
Please.
As your lordship, if they have paid, can you levy interest? If they have paid, can you levy interest? You can't. And this 465, what you are referring to, is if they want to pay in installments, 9%. If they want to, if they wanted to pay 54 lakhs in 1 year, for 1 year you have to pay 9%.
No, even that, my lord, interest will be leviable if I am not paying within 1 year.
ಅದನ್ನ ನೋಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇರೋದು.
1 year ಒಳಗಡೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ interest at 1.5%. Otherwise, if I am paying the complete amount or then there is no interest at all.
If you are paying complete amount on demand, no interest.
Exactly.
If you ask for installment,
yes.
Even if it is 6 months,
yes,
for 6 months you will have to pay interest at 9%.
Yes. But here I am saying I will pay the complete amount. I have paid that amount also. And interest
Bill pay na, I have paid.
I have paid that amount, my lord.
ಯಾವಾಗ ಪೇ ಮಾಡಿದೆ ಅಂತ ಗೊತ್ತು ನೋಡ್ಬೇಕು ಅಷ್ಟೇ.
Give us those details.
I will produce this detail.
Lord Counsel for respond 2 and 3 submits that interest could be levied in terms of section 465 of the Karnataka Municipal Corporation Act 1976. Lord Counsel for the petitioner submit that the petitioner has already paid.
Yes.
Sure, Allah? We are recording.
And say, my lord, because pay ಮಾಡಿದೀವಲ್ಲ ಅಲ್ಲಿ.
Lord Counsel for record ಆದ್ಮೇಲೆ next problem ಆಗುತ್ತೆ. Lord Counsel for the petitioner seeks for a week's time to verify if the payment has already been made. Since the submission is, if the payment is made, the question of payment of interest would not arise. Hence, to enable the counsel for the petitioner to place on record the details of the payments made of the demanded amounts,
will verify
released on 23rd February.
Great.
If you have paid, no interest.
Yes, ma'am.
If you are not paid from the time of the demand till now,
yes,
Mr. Krishna's offer is much. You should take that offer.
I will. Grateful. Interim order to be extended.
Interim order earlier granted is extended till next day.
Grateful.
Yes. Yes, Mr. Rajaram.
R1 to R4, my lord. My objections are ready, my lord. Highly sure.
What do we do if it is ready? You have to file.
On the last occasion,
they
have stated that
file ಮಾಡ್ತಾ
they
ಇದ್ದೀರಾ?
will argue for the final matter, my lord.
Are you filing or what? Today you'll file it. Copy kottidira?
No, my lord.
Then it is fine to decide whether he wants time to go through or not. You file it. If he doesn't want time, we'll hear you. Pass over. Copy. If you want time after going through it, we'll give you time.
Please, my lord. In this regard, my lord, let them file the objection. Stay may be granted.
Stay in Kodaka after 23. They're filing the objection, we'll hear you.
Last time final ಮಾಡ್ತೇವೆ ಅಂತ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ ಅವರು.
Argument. Ready na ನೀವು ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ ಅವ್ರು ನೋಡ್ಲಿ ಅವ್ರು. If he is ready, we'll take it up.
Objection ready ಮಾಡಿದ್ದೀನಿ ಬಟ್ objection ready ಇದೆ ಮಗ.
ಹಾ ಸೈನ್ ಆಗಿದ್ಯಾ? ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬೇಕು ನೀವು.
ಪಿಡಿಒ ಸೈನ್ ಆಗಿದೆ.
ಆಗಿಲ್ಲ.
ಆಗಿದೆ. ಸೈನ್ ಆಗಿದೆ.
ಮತ್ತಿನ್ನೇನ್ ಪ್ರಾಬ್ಲಮ್?
ಅಲ್ಲ ಎಸ್ಟರ್ಡೇ ಸೈನ್ ಮಾಡಿದ್ದು ನೈಟ್ ಬಂದು ಸೈನ್ ಮಾಡ್ತೀನಿ. ನೈಟ್ ರೆಡಿ ಮಾಡಿದ್ದೆ.
ಇವತ್ತು ಅಜ್ಜನಾರ 19th ಹೋಗುತ್ತೆ ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇರೋದು. If you are ready, ಕೊಟ್ಬಿಡಿ or we'll hear both of you. Pass over.
19th.
ಅವ್ರಿಗೆ ಅರ್ಜೆಂಟ್ ಅಂತಾರೆ, ಇಂಟ್ರಿ ಮಾಡಿ ಕೇಳ್ತಾವ್ರೆ.
ಇಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಬಿಡಿ ಸ್ವಾಮಿ, ನಿಧಾನಕ್ಕೆ ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ ಅವರು.
ಇಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಬಿಟ್ರೆ 2 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿ ಅಂತಾರೆ.
ಸ್ವಾಮಿ OS ಬಗ್ಗೆನೇ ಏನು ರೆಸ್ಪಾನ್ಸ್ ಬರ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ ಅವರೇ. It attained finality, my lord.
Pass over.
Serial number 18.
My lords, this is the matter which is covered by the judgment of this honorable court, wherein the municipality has issued a notice.
Kiran Chitra Mandira.
Please, my lords.
They have no right.
Please, my lords.
Yes.
Yesterday, we have.
My lords, peruse
Only the deputy commissioner can do it, not you.
If my lords peruses annexure D, my lord, at page number 39.
39.
It is sought for obtaining trade license. License is different from trade license.
Under which provision, what is the license?
256 of.
Does it come? Adರಲ್ಲಿ ಇಲ್ಲ ಅಂತ already there is a judgment of the coordinate bench. ನೋಡಿದಿರಾ judgment?
The facts of the judgment which they have relayed and the facts of the case are different. But we are not charging any fee for trade license. We had only asked them to obtain the trade license. In that judgment.
Under which provision?
256, my lord.
Any of the purposes, part 1 of schedule 13.
Schedule 13.
There's cinema commander, part 1 of schedule 13.
Please, my lord.
2 and 3.
2 and 3.
Cinematograph. Cinematograph films shooting off, which is 2. We are not conducting any
schedule
shooting. Schedule
13 ಎಲ್ಲೋ ಇತ್ತು.
3.
Is 365. Shooting off.
It is not.
Shoot ಮಾಡ್ತಾ ಇಲ್ಲ.
ಇಲ್ಲ.
Filmed by any process treating off. They are not treating.
He is the private responsibility.
Which head will it come under?
Cinematograph films.
ಅದಕ್ಕೆ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಇದೆ, ಶೂಟಿಂಗ್ ಆಫ್ ಅಂತ.
It is not a shooting.
ಮತ್ತೆ how do you raise this?
But we had only sought for obtaining trade license.
Only sought for, power ಇರಬೇಕು. Only if you have the power to.
But in order to run any business, my lord, within the premises.
Not in order to run any business. A business which has been qualified to be so run.
Please.
Under the provisions. If that particular provision requires a license, yes.
But the judgment which they had relayed, in that case, my lord, the municipality had sought to pay license fees.
ಆಯ್ತು, ನೀವು ಫ್ರೀ ಆಗಿ ಕೊಡ್ತಾ ಇದ್ದೀರಾ.
Here, my lord, we are not asking them to pay the fees. We are only asking them to obtain a trade license.
Under which provision?
256.
Not applicable. Petitioner.
In the theater premises, my lord, there are certain shops wherein, my lord, they sell snacks and
ask them to
cool
take.
drinks.
Ask them to take. This
Under,
won't apply
under
to
that
cinema.
circumstance, my lord, under section 256, my lord, we had sought for obtaining trade license.
See, you are asking them for cinema cinematograph. Cinematograph is different from food vending business.
But
If
it
there's
is
a
within
food
the,
vendor,
it is within the premises of that cinema theater.
for that we'll observe that in respect of those, they'll have to take license.
Canteen is also running within the premise.
For that, they'll have to take license.
That apart, my lord, they have not even paid the taxes.
Taxes have to be
Auction
paid
the
by the
property.
owners of the property, my lords.
Issue a
They have
notice
not
for
paid the rents to us, we are the owners of the property.
auction the property.
My lords,
If they are
there
not
are
paid tax.
other dispute with respect to the rents that are payable.
They
There are
may
civil
have
suits that
dispute,
are
my lord, they are
pending, my
supposed
lords.
to pay taxes to the
There is an
revenue
order, my
department.
lords.
When will you pay the taxes?
My lords, I am only the lessee of the property. They are the owners of the property.
Whoever
my
is
lords.
in occupation is required to pay if you want to continue to be in occupation.
My lords, I have been, the dispute between the owners and the petitioners,
We will direct them to auction the property.
auction, my lords, I am not the owner. Auction ಮಾಡಿದ್ರೆ
ನೀವು ಇರಲ್ಲ ಅಷ್ಟೇ.
ಅಲ್ಲ, there is a civil suit that is already pending
That
with
is
respect
between
to.
both of you.
Yes, my lords, between,
Are you going to pay the taxes? Adjust it among the rentals.
adu taxes have to be paid by them, my lords.
Whoever is in occupation, madam, please see the provision.
Your lordships may,
The owner or a person in occupation,
that agreement which is there, my lords, between them, I understand.
your agreement may be whatever. For the corporation, you have to pay the taxes.
Let them make a demand with respect to the taxes.
But we
Already
need
made.
not demand, we need not demand. They have to pay the taxes,
ಕೊಟ್ಟಿಲ್ಲ and demand ಮಾಡ್ರಿ.
please.
If they have not paid, you have to demand that and say you will take action in terms of the law.
That
What
is-
is the action that you can take? You can auction the property. Bring it for auction. They won't be having any business then.
If the tax is not paid, that would not
For obtaining a
give
trade
them an
license,
option
my
to
lord, it's a simple
issue a
process
notice
of,
under 256.
This
my
we are
lords.
striking down.
Please, my lords.
We'll reserve their liberty to
My lords,
initiate
they can
such action.
independently do it, my lords. They don't have to have an
Then the submission
observation
is
to
made,
that
we'll
effect.
reserve that liberty.
Please, my lords.
And insofar any other activity of food vending, in terms of anything that you are doing, you will have to take separate trade license for that if you are doing it.
There are
If you
other
are-
people who are running those
If
shops.
your
in premises.
contractor or vendor is doing it, they'll have to take that. FSSI, everything has to be taken.
That may be observed, my lord.
Petitioner is before this court seeking for the following reliefs. The petitioner has challenged
Hmm?
the notice which had been notice which had been issued by respondent number 1 on 9/12/2024, calling upon the petitioner to obtain a trade license in terms of section 256 of the Karnataka Municipalities Act 1964, seeking for the aforesaid reliefs. Submission of learned counsel for the petitioner is that there is no trade license which is required for the purpose of exhibiting cinematographs, and as such, merely because the petitioner is a theatre exhibiting cinematographs, the respondents cannot seek for call upon the petitioner to obtain a trade license under section 256. Learned counsel, and in this regard, she relies upon the decision of a court bench of this court, reported in 2012, ACC Online, Karnataka 6600, more particularly para 5 thereof, which is reproduced here under for easy reference. Relying on Kiran Chitra Mandira, she submits that under the Karnataka Cinemas Regulation Act 1964, it is only the Revenue Deputy Commissioner who can grant permission for exhibition of a cinematograph. There is no license, trade license or otherwise, which is required for such exhibition once a license from the Revenue Deputy Commissioner is obtained. On that basis, she submits that the demand now made is not sustainable under law and is required to be quashed. Notice having been issued, respondents have entered appearance. Respondent number
Section 120.
1, Chintamani, respondent number 1, Municipal Corporation, submits that in terms of item number 2 and 3 of part 1 of schedule 3 of the Karnataka Municipalities Act 1964, the respondent number 1 is authorized to call upon the petitioner to obtain a trade license, since the same mentions and relates to cinematograph films, the petitioner exhibiting cinematograph films would also be covered thereunder. Secondly, he submits that apart from exhibiting cinematograph films, the petition, in the premises of the petitioner, there are food vending businesses and the like which are carried on, which would require
Also a canteen, also a canteen.
a food vending business. Theatre lane food vending ashte.
This is what it's.
Food vending business and the like which are carried on, which would require necessary licenses and permission not only from the corporation but from other authorities. And it is in that background that the license has been called upon to, the trade license has been called upon to be obtained by the petitioner. Lastly, he submits that the petitioner has not paid payment of property taxes, then that property taxes have not been paid in respect of the said premises, and in furtherance of the same, action is proposed to be taken. Learned Counsel for respond number 3 to 6, being the owners of the premises, submit that rentals have also not been paid by the petitioner to respond number 3 to 6. And as such, a suit has been filed by respond number 3 to 6.
No, they have filed restraining us not to disturb them.
They have
Pen
also
ಮಾಡಿದ್ದೀರಿ.
filed a suit, my lords, for eviction.
For eviction, we have filed. They have
They have
filed one
filed.
suit for.
Recovery file ಮಾಡಿದ್ದೀರಾ?
Yes.
Recovery
And
kartilla.
eviction.
They 30 lakh advance was paid, my lords. What was understood as per the agreement.
Rentals, is they filed a recovery.
They have not filed for recovery in the sense 30 lakhs only they were supposed to adjust the rentals which were not paid as per the agreement itself. Despite
Has
that,
not
they have
been
filed the
paid.
suit.
So you are basically sitting there paying nobody anything and
Oh, my
running your
lords, I
business.
have paid 30 lakhs.
And you are
They
making use of the loopholes
My
in the law.
lords,
for
they are
that.
not letting me run the theatre at all. Constantly, there are disputes that are being raised. And now, even now, this tax issue is also coming up only for the first time.
Good.
My lords, there are other people who are squatters over the
We
property.
are not concerned about other people. If you don't pay your landlord that rents and you want to continue your business,
My case is that, my lords, I have been paying rents in
we are,
cash.
we are
and
not
there is-
saying anything about it, but we can only say it's highly
lords.
immoral and
Oh, my
unethical.
lords.
Legally,
we
you are
have-
succeeding in the matter.
No, my lords, we have been paying rents through cash. There is an entry in a book, but that would not constitute sufficient
That
evidence.
is
the
for
only-
your client's lookout. You are making use of a loophole now. That's all. Your client knows what it is that he is doing.
Please.
So no equities for that kind of an activity. Heard counsel for the petitioner and the respondents. Section 256 of the Karnataka Municipalities Act 1964 is reproduced hereunder for easy reference. A perusal of section 256 would indicate that a trade license is required to be obtained for, indicates that no person, no premises shall be used or no person shall be permitted to use any premises for any of the purposes indicated in subsection 1 of section 256 and that indicated in part 1 of schedule 13 of the said act, Roman 13. In terms of clause B of subsection 1 of section 256, if the municipal commissioner or chief officer is of the opinion that the purpose is dangerous to life, health or property or likely to cause a nuisance. And in terms of clause C, if horses, cattle or other quadruped animals or birds are for transportation, sale or hire or for sale of produce are retained in the premises, or if any articles specified in part 2 of schedule 13 except for domestic use are used placed in the premises, license is to be obtained. Item number 2 and 3 of part 1 of schedule 13 are reproduced hereunder for easy reference. Now, a perusal of item number 2 and 3 would indicate that though cinematographic films have been included, they are qualified. Item number 2 qualifies the same by using the words shooting off. That would mean that only if a premises used for shooting of cinematographic films, such a license is required to be obtained. Item number 3 qualifies the same by using the words treating of cinematographic films. So treating of, which would mean that if a premises is used for treating of cinematographic films, license is required to be obtained. Neither section 256 nor item number 2 and 3 of part 1 of schedule 3 deal with exhibition of cinematographic
13.
films.
13, schedule
13 deal with exhibition of cinematographic films, and as held in Kiran Chitra Mandira's case, that would be covered by, that would have to be dealt with by the Revenue Deputy Commissioner who has granted a license to the petitioner. Hence, insofar as exhibition of cinematographic films are concerned, section 256 and the schedules referred thereto, thereunder, therein would not be applicable to the present case, requiring a trade license to be obtained. As regards food vending businesses or any other business apart from cinematograph films is concerned, if any of those businesses are covered by part 1 or part 2 of schedule Roman 13, it would be required for the petitioner to obtain such trade licenses before indulging in such businesses. Unless, needless to say, unless such license is obtained in respect of such business, the petitioner cannot carry on such business either by itself or through any of his vendors, contractors, or the like. As regards the payment of property tax, that is not again something which is covered under section 256 of the Municipalities Act, inasmuch as there are other remedies which are provided to the municipality to seek for recovery of pending property taxes, including by issuance of notice of distraint and or the like, and bringing the property for action. Liberty is reserved to the corporation to do so. As regard the contention of learned counsel for respond number 3 to 6 that the rentals have not been paid to respond number 3 to 6, proceedings being pending between the parties, it is for respond number 3 to 6 to agitate the same in those proceedings. In that view of the matter, I pass the following order. Writ petition is allowed. The requirement, the notice dated 9/12/2024 at Annexure D, insofar as calling upon the petitioner to obtain trade license for exhibiting cinematograph films is concerned, is squashed. Needless to say that the same would apply only to exhibiting of cinematographic films. Any other purpose or any other business carried on the premises would require the petitioner, its vendors, contractors, or the like, to obtain such trade license as are required.
19, Archana Murthy.
Yes. In the mic, madam, mic is there.
My lords, one Farooq Ahmad, my lords, Takirunisa, Mayorunisa, and Najamunisa, my lords. They were the absolute owners of the property bearing 7.
They are not parties.
No, my lords.
Yes.
They are the absolute owner of the property, my lords, bearing number 174, 174/1, 174/2, and 174/3, my lords. They filed an affidavit for amalgamation of all the kata, my lords. And here what has happened, my lords, later, my lords, respondent number 4, that is Najamunisa, the respondent number 4A and B, my lords, their mother, she filed an affidavit by forging the signature of all the 3, my lords. She filed an affidavit requesting to separate the kata, my lords. Based upon the forged document, my lords, she obtained the separate kata number bearing 174/5, my lords. So we filed an appeal seeking for the cancellation of the separate kata given to her, my lords. Here, my lords, the respondent number 2 herein cancelled the joint kata made, my lords. But in so far as respondent number 4 is concerned, that is 174
So who
by
are the petitioners?
My lords, petitioner
Further
number
connected.
1, my lords,
Hmm.
she is the daughter of Zakirunisa, my lords. And petitioner number 2, she is the GPA holder of Meherunisa, my lords.
They are alive?
Meherunisa, she is not alive, my lords.
What about
Actually,
Zakirunisa?
both of them are, my lords,
Nazumunisa is not alive.
here what has happened, my lords,
No, he is Zakirunisa and Merunisa.
Meherunisa, my lords, she expired on 2/1/2019, my lords.
Yes, what about
But the
Zakirunisa?
respondent number 4 herein filed an affidavit on 18/1/2000.
Madam, first answer the question,
Please,
then
my
you
lords.
can make your.
Not alive, Lord.
So Merunisa has expired.
Please,
What
my
about
lords.
Zakirunisa?
Even she is expired, my lords.
So, okay, then now you continue.
My lords, here what has happened, my lords. Meherunisa, she expired on 2/1/2019, my lords.
Hmm.
But the respondent number 4, my lords, Najamunisa, my lords,
Hmm.
she filed an affidavit on 18/1/2021, my lords.
Of Merunisa.
Please, my lords.
Hmm.
Of Zakirunisa.
For all, my lords.
No, Merunisa expired on 2/1/19. Zakirunisa expired on?
That time.
Zakirunisa expired on 2nd January 2019, according to their own record.
We are confusing the whole thing. Who expired? Merunisa
Page number
expired on
5, Lord.
2/1/19
My
or
lords,
Zakirunisa?
Meherunisa, she expired on 2/1/2019.
Who
my lords.
expired?
Meherunisa, my lords.
Merunisa. Tahir, what do you say?
It is there, para number 4, Lordship. Kindly see. The fact that Zakirunisa passed away on January 2, 2019. According to their own facts.
You are also getting
Lordship,
confused.
here what is a very simple issue, Lordship. This is a family property,
Hmm.
belongs to Sayyid Yusuf Sahab.
Hmm.
He is the original owner.
Hmm.
He has three daughters, Lordship. Zakirunisa, Meherunisa, Nazumunisa. These three daughters, the property was divided in according to their shares. What happened? These three sisters, they decided, even children, they decided to develop a property jointly.
Hmm.
They amalgamated their khata. Then what has happened after that? Some dispute arise in respect of development. Who will acquire what kind of flats and on all those things. Then one person, Nazimunisa, according to her own case, Nazimunisa filed a application for separating the khata, and khata got separated, and her khata got separated. Then she has taken a construction license. Then she has built up the building. So this
The joint development did not happen.
joint development did not happen. Then subsequently, according to then, Nazmun Nisa has filed an application for separating a khata.
Hmm.
That application was filed and khata got separated. She has taken a construction license and she has constructed the building. But in respect of other property, other portion of the property, no development has happened.
So 1/3 she took.
She got 1/3. Then what has happened, Lordship? Subsequently, they came to know about that this khata has been transferred by providing a certificate by affidavit where the false signature was there. Based on that, they have agitating before
Consent for bifurcation
Yes.
is bad.
Yes, so that is their contempt. But Lordship, my contention is, Lordship, my submission is, Lordship. Kindly see, Lordship, according to their own case, this Zakirunna is passed 2nd June 2019.
Hmm.
Their amalgamation, Lordship, kindly see the para number, page number 5, Lordship. 6th line. Amalgamation happened on 6/1/2020.
Para 5 or page 5?
Page 5, Lordship. Page 5, continuation of para 3rd.
Hmm.
Para 3, 7th line, Lordship.
All the four owners.
Amalgamated the khata bearing number so and so 6/1/2020. So the amalgamation is also happened, which is according to this consented amalgamation after the demise of 2nd June 2019, after 1 year. So Lordship, actually what has happened is this entire family were together. All the petitioner number 1 and the other legal heirs were together. They want to develop property.
Hmm.
Behind the back of the elders, the petitioner number 1 forged the signature of her own mother and get the property amalgamated. Then subsequent dispute arise. And dispute arise.
Do we refer you to mediation?
No, Lordship, there is already I offered. There is one more small aspect. What has happened is petition number 1 has usurped one Karnataka Housing Board property, which is not usurp is property. There, this petition, the petition number 4 children, they sought some favor against that because they came to know about the illegality. From there, all the dispute has started. Then he is filing all the cases. Even they file a criminal case. In criminal case, what has happened, Lordship? Charge sheet has filed. To ascertain who has for the signature, FSL report is required. That has not been obtained. Our contention is that the forged document
is done, forgery is
How many litigations are there?
6-7 litigations, they only filed it. Even they came to
Who has filed is not made.
petition. Within family, 6-7 litigations are there.
So if these are the things, everything has to be sorted
And
out.
simply the judicial forum getting disturbed because of this.
We are here only for that, what to do?
Lordship, even those, if they succeed.
When people fight only, we have work.
But you cannot force the signature.
If people don't fight, we don't
They
have work.
themselves as for the signature. When the things got open, they are blaming us. I'll leave
Are
it
you
on this
agreeable
honorable
for
court.
mediation?
Yeah, Lordship.
If all of them are there, they're what, 62, 66, 69 in 25. Okay,
Yes,
60. All of them are old people. At
Yes,
this
sir.
age, why should they be in litigation? If all of you are agreeable, both of you are agreeable, we'll refer you to mediation.
Fair
Try
enough.
and sort it out. And close all the disputes which are there.
But my client is not at all.
Your client is not willing. No problem. Then argue the matter. Yes.
I will, Lordship, Lordship, he's supposed to brought some facts before the court. In
You
respect of-
let her argue, then you argue.
No, about the KHP property and all, from the where the issue has germinated. So the issue is that Lordship, I was not in the station from past 4 days. I came in the morning.
Where did you go?
I came in the morning only. I will bring everything in the court. If they wanted to wash the dirty linen in the public, I will also do that. That's that or I have no options.
My lords, I will try, my lords.
I
Kindly
am
refer
unable
this
for
matter to mediation.
amenable for everything, Lordship.
Everything.
For compromise, Lordship, there is a, it's not the case we have
don't
taken
know
the share
whether-
their
We
property.
don't know whether that's a compromise or a threat. So you take it as to how
No,
you
Lordship,
want to.
it is my humble submission. There is
He
no
is re-
dispute of
he is
title.
ready.
Lordship, there is no dispute of title.
Madam, it is advisable
Please, my lord.
that it is settled amicably. Ego, if is there at this age, doesn't help.
I do agree, my lords.
Ego is killing
And-
everyone, Lordship.
Please, my lord.
That
Kindly
doesn't
refer
help.
this matter to mediation.
So what do we record now? That you want time. That counsel for respond number 4 and 5, 6 fund is granted 10 days time.
And mediation also may be some possibility.
Refer this matter to mediation.
With consent, are you sure?
Please, my lord.
Then your client should not say no consent. Please, your client is here.
I'll just
Then
ascertain.
we'll pass it over. Please get his consent because we'll be recording your statement.
Please, my lord.
We don't want any litigant to make any allegation against any lawyer. So
Please, my lord.
please get that this one. He is very clear that he is ready for everything. So, including
even,
mediation.
even I advised, they wanted to file a case in respect of, I said, no, all those things should not drag it in the public and all this. There is no point of, there is no issue in disputing titles. Why simply all these sundry matters?
Yeah, unfortunately, what happens is, especially this roster, it is neighbor issue.
Family issue.
Neighbor, neighbor, neighbor. If we go in this, it is the family. What we fail to realize is, firstly, you can't change your neighbor. Secondly, you can't change your relatives. You will be there. And most important are your neighbors and relatives. You're not fighting with
People
third
don't
parties.
understand that actually.
You're fighting with your own. What is the point in fighting with your own?
Correct.
That is where some give and take has to happen. You want to fight with third party if they have disturbed you? Yes.
My lords, kindly refer this matter to mediation, my lords. I'll convince them.
Convince Allah. Get actual consent, please.
Please, ma'am.
Pass over.
Okay.
We don't want to embarrass you later, so get it.
Serial number 20.
I appear for the petitioner, madam. I'm
Yes.
seeking a writ in the nature of mandamus. That's what had
You
happened
read
is,
down. Yes.
the subject lands were a subject matter of litigation, my lords, whether that certain extent of land was under a lake bed area. Now the Tahsildar has prepared a report and found out that the 12 acres of land is not under the lake bed and it is separate. He's passed an endorsement at Annexure A, my lords, at page number 22. The last paragraph at page number 23, my lords. ಅದರಿಂದ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಯಶವಂತಪುರ ಹೋಬಳಿ ಲಗೇರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ಕಸ್ತೂರಿ ಕ್ಷೇಮಾಭಿವೃದ್ಧಿ ಸಂಘರವರು ಸಮಕ್ಷದಲ್ಲಿ ಪ್ರಸ್ತಾಪಟಿ ಸೋ ಅಂಡ್ ಸೋ ಜಮೀನದ ಗಡಿ ನಿಗದಿಪಡಿಸಲಾಗಿರುತ್ತದೆ. ಸದರಿ ನಕ್ಷೆಯನ್ನು ಪರಿಶೀಲಿಸಿಕೊಂಡು ಮುಂದಿನ ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ತಮ್ಮ ತಮ್ಮಲ್ಲಿ ಈ ಮೂಲಕ ಕೋರಿದೆ. They sent this endorsement to the BBMP, my lords, to
What
issue
is 20888? Where is that order?
my lords, at annexure B, page number 24, my lords.
That is 1110. That is not 20888.
No, my lords, that is with respect to the earlier litigation, that is the PIL, my lords. That was cleared, my lords. Now the Tahsildar has said that our lands do not belong to any of the lake bed, and they have told the BBMP to issue e-Khata, my lords. Subsequent to which, my lords, I send representations at annexure C, my lords.
Yes, my lords, my instructions are, my lords, this 12 acres land, my lords, the schedule that the boundaries are unable to be identified, though with the map that has been produced by the Tahsildar. My request to this court, my lords, is could my lordships direct the DDLR to fix the boundaries, my lords?
Fix the boundaries.
Please, my lords. That is all is the request.
The issue in the present matter is whether the lands of the members of the petitioner association in a layout formed of 12, an extent of 12 acres in survey number 120, Lagere village, Yashwantpura Obli, Bangalore North Taluk, would come within the, which lake is it? Which lake is it, Adit?
My lords, Egganalli is the.
Egganalli.
Egganalli
There's no
lake.
lake, my lords. Now it's a dry.
Their claim.
Please, Egganalli area. Egganalli area, my lords. This is the jurisdiction of Egganalli, my lords. Egganalli zone.
Which tank, lake or tank? You said tank bed. So which tank bed are they claiming? You have to give us a name at least.
My lord, in this
They are
case,
saying nothing is there.
my lord, in this case, they have not served copy to us. Let them serve a copy. Copy is not furnished to the government.
You are not a party.
They're not the party, my lords.
Party.
State is not a party. It's only BBMP who is a party. AGA for R2. Revenue officer BBMP ಗೆ appear ಆಗ್ತೀರಾ?
No, but they have made AGF for R2 ಅಂತ ಇದೆ ಅದಕ್ಕೆ.
The appearances is crazy. Registry is directed to correct the appearance of the councils. As Sri Karthik K. BS is that appearing for respond number 1 to 3.
Basappana-Katte Lake, my lords. Basappana-Katte Lake, my lords.
Birth ಕೊಡ್ತೀನಿ. Basappana-Katte Lake. The Tahsildar has given a report that the same does not, the 12 acres over which the sites layout has been formed is not part of any tank bed. And in that background, the petitioners are before this court seeking for issuance of Khata, for the respondents to act on the said report and issue Khata. Sri B.S. Karthikeyan, learned counsel for the respondents, submit that though such a report has been received, it would be required for marking out the boundaries of the properties to ascertain and mark out the boundaries of the properties so as to be clear that the properties claimed by the members of the petitioner are not part of any tank bed area.
Just not the tank bed area, my lords. Also government property, my lords. Lords, if my lords may, I'll just intervene, my lords. The larger extent is a government land, my lords, out of which 12 acres was allotted to an ex-serviceman, Air Forceman, my lords. He created a 12-acre layout in that, my lords, and sold the properties. Lords, my instructions, my lords, is beyond the 12 acres also, my lords, the sites have come up and there has been encroachment of the government area, my lords. So the land that was allotted to the ex-serviceman of 12 acres, if that boundaries are marked, my lords, for the houses falling within that, my lords, we will be able to give the Khata, my lords.
So you give us your memo of instructions as to what are to be done.
Please.
We'll make it part of the order.
Please.
Otherwise, the ADLR will not know what to do.
Yes, please. Please.
My lord, that is already been decided, my lord.
Decided.
That's already, that is what the
Where is
Tahsildar
it?
says. My lord,
But what is this gadi nigadi ಆಗಿರ್ತದೆ ಸದರಿ ನಕ್ಷೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿರುವುದು ಮುಂದಿನ ಅಗತ್ಯ ಕ್ರಮ ಕೊಡಿ.
My lords, the
ಗಡಿ
paragraph-
ನಿಗದಿಪಡಿಸಲಾಗಿರುತ್ತದೆ ಅಂತಿದೆಯಲ್ಲಪ್ಪ, ಮಾಡ್ಬೇಕು ಅಂತಿಲ್ಲ.
Then, my lords, in the next.
See the last line, Karthikeyan.
ತಿಳ್ಕೊಂಡು ಮುಂದಿನ ಅಗತ್ಯ ಕ್ರಮ ನೋಡಿ ಸರ್, ಸದರಿ ನಕ್ಷೆಯನ್ನು ಪರಿಶೀಲಿಸಿಕೊಂಡು ಮುಂದಿನ ಮೆಲಾಡ್ಸ್, ಬಟ್ my instructions are boundaries are not marked melodies. It is a
ಮತ್ತೆ
rough
ಗಡಿ
sketch
ಅಂದ್ರೆ
that-
ಬೌಂಡ್ರೀಸ್ ತಾನೆ.
It is a rough sketch that has been given is my instructions melodies. We are unable to identify the exact boundaries, east, west, north, south. ಇಲ್ಲಿಗೆ ಈ ಕಲ್ಲಿಂದ ಈ ಕಲ್ಲಿಗೆ ಅಂತ ಅವ್ರು ಕೊಟ್ಬಿಟ್ರೆ.
Is there a survey sketch prepared?
Yes, my lords, that was the.
You have a copy?
No, my lords, that was a part of the 1011, they had given the
1110.
1110, my lords. On that basis only.
Page 1110 said
26.
no survey was conducted, so survey was directed to be conducted.
No, my lord. Survey was conducted that time. Kindly see page number 26, paragraph 2.
Paragraph 2.
This action is accomplished by the respondent number 3 Tahsildar. The same is evident from the endorsement dated 2011-2025.
You thought it was not done, but Tahsildar said it's been
Tahsildar,
done.
it's done. That's how it was disposed of, my lords. So it's already been done. Boundaries are also
Rough
marked.
sketch is what I have been instructed melodies. Our DDLR site ಬಂದು will also be there at the site melodies. They also can be there at the site melodies at a date and time given by my lords.
If it's already done, why should it be done again?
May I request,
Because this court has noticed that it is done.
Please.
See page 26.
The petitioner is agreed by the inaction. The action is accomplished by the respondent number 3 Tahsildar.
In not conducting the survey and place it before the BBMP, is there this one?
Endorsement dated
The court has observed that the action is accomplished by respondent number 3 Tahsildar.
It's an endorsement that has been given my lords, but
On
not the map.
21-1.
Either-
That is Annexure A.
20 this is the endorsement my lords. But what they say my lords, here in 20888 of 25 nalli we have given it anta of 2005. Two zero triple eight of 2005 ನಲ್ಲಿ ನಾವು ಕೊಟ್ಟಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ my lords in that writ petition.
That's been
It's about 20 years old.
See item number 3. Ullekha 3.
That's it. May I only request that the petitioners, if they have a copy, my lords, if that be given, I'll give it to my officers and seek instructions as to what more they would want. My lords. They're not averse to giving the e-khatas, my lords. They're only being careful in issuing e-khatas for
We
government
understand you
property.
can be careful, but if there is already a report,
Done, my lords. I'll, if
My lords,
my
it's
lords-
been
the
around
officers cannot
12
be saying, giving you instruction, do it once again.
My lords,
But that was the instruction that I got, my lords, that they are unable to identify the exact boundaries, east, west, north, south.
That is their problem. The survey has happened already.
Please, my- if my lordship could
I'll-
direct the petitioners to give a copy.
You will have to give it. You make the Tahsildar a party, we'll make the Tahsildar a party because he has issued this.
Yes, please,
We'll direct the Tahsildar to issue this because he has referred to it.
please.
They may or they may not have it. The authority will have it.
Yes, please.
Let them make a party and survey copy.
Being of the, being of the considered opinion that the Tahsildar, ಯಾವ Tahsildar ಅಪ್ಪ ಇವರು? Tahsildar Bangalore North Taluk, Bengaluru. He is required to be made as a party to these proceedings since he is the one who has issued the endorsement dated 21/1/2025 at Annexure A, which resulted in disposal of WP number 1110 of 2025. The Tahsildar Bangalore North Taluk is brought on record as respondent number 4. Then AG accepts notice. In copy ಸರ್ವಾಗಿಲ್ಲ ಅಂದ್ರೆ ಇವಾಗ ಬರತ್ತೆ ನೋಡಿ. Accepts notice for respondent number 4, counsel for the petitioner to carry out necessary amendment and file amended cause title as well serve 2 sets of the petition along with annexures on learned AGA. Learned AGA is directed to secure instructions, obtain copy of the survey sketch referred as serial number 3 in the subject of the endorsement dated 21/1/2025 and file a copy thereof with this court after furnishing a copy to the counsel for the petitioner and respond number 1 to 3. Pre-list on 23rd February.
Correct.
21, HS Vivekananda.
Delete
For the
Pawan
petitioner,
Kumar.
my lord. My lord, the matter was mentioned yesterday. My lord,
End of the list you are taking. Yes.
what has happened, my lord, the proclamation and sale notice has been issued in spite of 2 interim orders by this honorable court not to do so, my lord.
Where is the interim order?
Interim order, my lord, your lordship may kindly see at page 2 and 3, in the compilation that I have filed yesterday, my lord, list of dates and events. Page number 2 and 3, my lord.
It's a different matter.
It's the same. The lordship may kindly find it page 3, my lord. There was an interim order.
Interim orders are not passed in this matter.
This matter, my lord. This matter.
27488. Okay, yes.
And what happened, my lord? The demand notice came to
That's the
this case,
first
my lord.
order. Where is the
This is the
second
first order. The second order, my lord, can be found at page 5, my lord, annexure D. Page 5, where there was a clear direction to them, my lord, to initiate steps to recall the attachment order that came to be passed. And there was an undertaking from the BBMP council that will be initiated. And my lord, your lordship may kindly see, we also intimated at annexure E, page 6, my lord, to the BBMP, that such a order has been passed. 2 orders have been passed. Please don't take steps. My lord, in spite of it, my lord, annexure G at page 9 has been, my lord.
Yes. Instruction, lordship, waiting for
Not
instruction.
inside, this is not a stray case. We are getting so many other matters also.
Kindly give us 2 weeks time.
Your system will keep on sending, your system should also cater to orders passed by the court. So we'll direct you to do that.
But the date is fixed on 21st, my lord.
We'll stay there.
Please.
But have we filed amendment? What have we done? Have we filed an application?
I will do so, my lord, because yesterday that it came to be passed.
From yesterday, you could have filed it by till.
I'm sorry.
File it, pass over.
Yes. Grateful.
22.
My lord, in this case, your lord,
During delimitation and allotting votes to the wards, my lord. See, during the allotment of
One
votes.
nimsha. Yes, Vinod.
Yes, my lord. During allotment of votes to the wards, my lord. For all the
Allotment of?
votes to the
Votes.
votes to the wards. Only for this particular ward, allotted only 19,000 votes. For all the other wards, my lord, they have allotted 27,000, 28,000. 30% reduction in the votes allotment, my lord. My lord, my submission is if they consider my representation, and BBMP Act says, Section 7 of BBMP Act says that it must be equal in all. May I read practically equal.
30%
Consider-
difference.
Page number 24, your lordship may kindly see
Why
page
do you
number
want
24.
them to be so less?
First thing, my lord, they have not shown what is their interest in this. Absolutely.
Who are you? You are a resident of that ward?
Residents,
Say that they are the residents
ma'am.
and voters. It is
Of-
public interest in nature, probably. That is what I feel.
Not public
One.
interest, madam.
Well, if they are voters of ward number 38, which has been.
But they are not voters also. They have produced their other cards before your lordships as a annexure A series. None of them, my lord, except for.
My lord,
Kindly
voter
see-
list printed before.
Where is the
what?
address of annexure A?
My lord, your
Annexure
lordship.
A, addresses are entirely different.
My lord, previous ward. Now they have created after BBMP.
Kindly see this, page 9.
Unless you show that you are in the same ward,
Yes.
you have no personal lists.
Yes. Same ward, we are on same ward.
Illappa.
No.
Nandini layout, my lord. Nandini layout, Anche
ಇದರಲ್ಲಿ
Bengaluru.
A1 ನಾವು ತಾವು ನೋಡಿದ್ರೆ ಸಂಜಯ್ ಆರ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಅದರಲ್ಲಿ ನಂದಿನಿ ಲೇಔಟ್ ಅಂತಾರೆ, ಬಟ್ ಇಲ್ಲಿ ಸಂಜಯ್ ಆರ್ಸ್ ನೇಮ್ ಇಸ್ ಶೋನ್ ಆಸ್
ಇದು
ಸಮಥಿಂಗ್.
ಯಾವ ವಾರ್ಡ್ ಇದು?
Nandini
This is Nandini layout.
Nandini layout.
Nandini, ward number 38, Nandini layout.
Ward number 38.
Within Mahalakshmi layout assembly constituency. So, A address illa.
ಎ ಅಡ್ರೆಸ್ ಇಲ್ಲ. ಆಮೇಲೆ A1 ಅಲ್ಲಿ ಸಂಜಯ್ ಆರ್ ಅಂತ ಹೇಳ್ತಾರೆ, ದಟ್ ಇಸ್ ಥರ್ಡ್ ಪೆಟಿಷನರ್.
This is Nandini layout. 90/1 Bangalore Nandini layout post, Bangalore BBMP North.
Nandini.
90/1 ಅಂತ ಇದೆ. Kindly see the address, my lord, at petitioner number 3. Something else has been written there. 17 10th cross Nandini layout 38 ward. And then A2 ರಂಗಸ್ವಾಮಿ ಅಂತ ಹೇಳ್ತಾರೆ, Rangaswamy's name is A2, P2 rather.
A2 ಮಾಡ್ಬಿಡಿ. ನಿಮ್ಗೆ A2ನೇ.
P2 rather. Lord, second petitioner, there is no
They're
address.
all residing in Nandini layout from what they've.
Jai Maruti ಅಂತ ಹೇಳ್ತಾರೆ. Jai Maruti is a
Others.
separate ward itself. No.
ಯಾವುದು?
Jai, that is A2.
A2 is Nandini layout, Mr.
ಅಲ್ಲ,
Satyanand.
Jai Maruti is a
Jai
separate
Maruti
ward.
Nandini layout.
Now kindly see,
ಮನೆ ಹೆಸರು ಜೈ ಮಾರುತಿ ಇರ್ಬೇಕು.
no. Kindly see annexure C for a minute. It is ward number 39. Jai Maruti Nagar, ward number 39, fourth item. Nandini layout is 38. Jai Maruti Nagar is 39.
Okay, we'll dismiss it against two of them.
Then my lord, Bhaskar also Jai Maruti Nagar. That
Three
is
of them.
First petitioner.
Three of them. Two will survive.
No, only 4 are there before your lordships.
Rangaswamy and Sanjay will survive. Anjanappa will go.
Rangaswamy also Jai Maruti Nagar.
ಎಲ್ಲಿ ರಂಗಸ್ವಾಮಿ ಜೈ
A2
Okay, Rangaswamy also
Jai
goes.
Maruti Nagar. And then Bhaskar is also Jai Maruti.
Sanjay survives.
Then Sanjay, my lord, Sanjay survives. And then Anjanappa, no address at all. Petition survives insofar as one person is concerned.
One is enough for the petition.
But how is he aggrieved of? Nowhere has he stated. This is one aspect. How is he aggrieved of? Lord, basically, when they are asking for a relief, my lord, before your lordships, Lord, they should say how they are aggrieved of. Is it that they
Reduction,
are
how does-
contesting this matter or
Reduction, how
contesting
does
the?
it impact them? Yes. Let him argue. Your main contention was that is gone. A preliminary contention. Main contention will come to later.
My lord, in this case, my lord, connected matter is posted on 23/2. In that
For the
case,
same Nandini.
no, different.
Different word.
We are in that matter.
There's so many issues. You keep saying club it anta. ಬೆಳಗ್ಗೆ matter ನೋಡಿದ್ರೆ ತುಮಕೂರು is club with Bangalore.
That matter pertains to delimitation.
We'll consider that. This is a different issue.
My lord, I'm only.
How are you agree?
My lord, the number of votes, your lordship, can you see page number 24, my lord? Table uploaded by the BBMP, wherein your lordship, serial number 3 is Nandini layout, my lord. Only 19,000 votes. And for other wards, my lord, it's 28,000, 25,000, 27,000. This has been published on 1911, my lord.
See, but Nandini layout, if there are people lesser staying, then you'll have to add Jai Maruti Nagar to Nandini layout.
My lord, they have to reallocate some votes from the other wards.
How are you affected by having
My
lesser?
lord, major is that the income, my lord, because for my ward, the Nandini layout police station, Nandini layout branches of all the banks, Nandini layout club, all those have been added to other wards, my lord. That's therefore it will affect the income.
That is not something that you can address here. Your contention is different, your grievance is different. That doesn't work. Your contention is as regard the
BBMP Act says, section 7, I may be permitted to read section 7 of BBMP Act, my lord.
These layouts are proper. Nandini layout is different, Jai Maruti Nagar is different, Mahalakshmipuram is different, Nagapura is different.
Yes, madam.
Correct?
Yes, they are different.
So if a change is to be made for Nandini layout, then something will have to come from Dr. Puneet Rajkumar ward or Jai Maruti Nagar or Mahalakshmipuram.
Yes, madam.
So that will be disturbing that.
It will not be
In terms
disturbed.
of a area.
Yes.
Administrative efficiency requires each layout and.
My lord, just 1 month ago back, they had created, wherein they had allotted 21,000 to this ward, my lord. Lordship, kindly see, I produced it at page number 26 here. 26. If they continue that, without any reason, they have changed it, my lord. 26.
They'll have to see how many people are there and on that
Well,
basis. they'll
let them
come for
consider based on section 7 of BBMP Act.
So prayer A you are giving up.
Yes, yes. Well, consider and pass orders.
They are giving
Well,
prayers.
as per section 7 of BBMP Act.
ಅದು ನಾನ್ ಮಾಡೋದಿಕ್ಕಾಗಲ್ಲ ಗವರ್ಮೆಂಟ್
ಅಲ್ಲ government concerned authorities. let them.
File a memo.
Yes.
And counsel for the petitioner submits that he does not press prayer A. Hence prayer A is deleted from the petition. Counsel for the petitioner carry out necessary endorsement to that effect. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that insofar as ward
My
number
lord, your
38
lordship-
Nandini layout is
Lord, Your
concerned.
lordship, before passing the order, my lord, before passing any order, it may be passed over. Additional advocate general wants to argue.
He's only asking for a mandamus, reject it if you want, give reasons.
ಅಷ್ಟೇ ಅದನ್ನೇ ಹೇಳ್ತಾರೆ.
Ashte. Prayer A is given up.
This is deleted.
The grievance of the petitioner is for ward number 38 Nandini layout. The number of voters as per the list are stated to be 19,639, and in respect of the other wards, the number of voters are in excess of 25,000. And in that background, he submits that the representation which has been submitted by the petitioner to increase the number of voters in Nandini layout ward be considered by the respondents. A representation, I mean, given by, where is your representation? How many people have signed it?
These 4 petitioners have signed it. Representation at page 27.
Then we can't direct this. Each one will come and give some representation.
No, my lord.
Each one will come and give a representation, cannot be like that. There's considerable number of people, yes. And as Mr. Satyanarayana said, there's public interest litigation.
My lord, Rangaswamy has given, my lord.
Aste Ibro.
Yes.
Tomorrow another 2 people will say, reduce Nandini layout to 10,000.
My lord.
How many representation should they be considering?
My lord, annexure G.
ಇಲ್ಲಿ ರೆಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಇನ್ನೊಬ್ರು ಬಂದ್ಬಿಟ್ಟು ಅವ್ರು ನಮ್ದು ಯಾಕೆ ರೆಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಇಲ್ಲೊಂದು ಪಿಟಿಷನ್.
We can't do that.
I will give fresh representation. The petitioners will give
For
fresh
19,
representation.
and in that background, the representation dated 1/12/25 had been submitted by the petitioner for increasing the number of voters in the ward. I am unable to agree with the learned counsel for the petitioner to issue a mandamus for such a direction of consideration of the representation when there are 19,000 voters in the said ward, only 4 of them are before this court. And even as regards that aspect, it's in dispute as to whether 3 of them are residing within Nandini layout or outside in other wards. Be that as it may, such representation by few persons to the state to increase or decrease the number of voters cannot be directed to be considered, since there is no vested right in the petitioners, and it is not clear from the petition or from the submission as to how they are affected by a reduced number of voters. Hence, no grounds being made out, the petition stands
My lord,
dismissed.
if we give proper representation, otherwise, my lord, I may be permitted to withdraw the petition.
ಎಲ್ಲ ಆದ್ಮೇಲೆ withdrawal ಬೇಡ.
ಅಲ್ಲ, otherwise it will.
Next.
Serial number 23 adjourned. 24. Telecast.
For the petitioner in this matter, my lord.
Yes, Giri. Yes.
I've sought for passing of annexure E, my lord, page 19. The attachment order.
Senior of inconvenience, my lordship, 2 weeks time.
You have an interim order.
Yes, my lord.
Delete Pawan Kumar at the request of counsel for counsel for respondent 1 and 2 seeks for and is granted 2 weeks time to file a statement of objection and get ready to address the argument. Statement of objection by 3rd March, released on 9th March. Interim order earlier granted is extended till next.
Please.
25. Sachin BS.
For the expert number 4, my lord. My lord, kindly see the photographs of the
Where's Pavan? Cell number 25.
Section is done. I have asked for 10 days time.
Because it's 440 square feet.
Small size.
My lord, kindly see the photographs, my lord. In the wall, the petitioner wall, there is no windows or
They don't want a window. What's your problem with them not having a window?
Allah. My lord, in this case, my lord, mutually discussion with both the parties, expert number 4 and petitioner, my lord, they are demolishing the building. Thereafter, my lord, the sewage water comes to the expert number 4 property, my lord, and discuss with retaining wall of retaining wall ಹಾಕಿ ಅವ್ರ ಗೋಡೆಗೂ ಸಹ ಏನು ತೊಂದರೆ ಆಗಬಾರ್ದು ಅಂತ ಮಾಡ್ಕೊಟ್ಟಿದೀವಿ.
ಇವಾಗ ಏನ್ ನಿಮ್ಮ
ನಾವು ಸೆಟ್ ಬ್ಯಾಕ್ ಬಿಟ್ಟಿದೀವಿ ಈ ಬ್ಯಾಕ್ ಸೈಡ್ ಅರೌಂಡ್ 3 feet.
ಇವಾಗ 5126 regulation ಪ್ರಕಾರ whatever the setbacks are, now it's been reduced to the minimum, and for insofar as property is less than 600 feet, left and right there is no setback which is required. Front so ಇದೆ ಬ್ಯಾಕ್ ನು ಬಹಳ ಕಮ್ಮಿ ಇದೆ.
Front to back.
Left and right ನಿಮ್ ಪ್ರಾಬ್ಲಮ್ ಇರೋದು. There is no setback required as per the bylaws.
ಅವರು ಬಿಟ್ಟಿಲ್ಲ ಸರ್, ಅವರು ಸಹ ಬೇಸ್ಮೆಂಟ್ ಇಲ್ಲ ಏನಿಲ್ಲ.
ಇಬ್ಬರದು ಅದೇ ಇಬ್ಬರು
ಇದು ಓಲ್ಡ್ ಬಿಲ್ಡಿಂಗ್ ಮೇಲೆ. ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಮೈ ಲಾರ್ಡ್. ಪ್ಲಾಸ್ಟಿಂಗ್ ಎಲ್ಲ ವರ್ಕ್ ನಾವೇ ಮಾಡ್ಕೊಟ್ಟಿದೀವಿ.
ಅದಕ್ಕೆನಪ್ಪ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಕರೆದು ನಿಮ್ಗೂ ನಿಮ್ ಬೆನಿಫಿಟ್ಗೆ ಹೇಳಿರೋದು.
ಓಕೆ.
ನಿಮ್ದು 600 ಫೀಟ್ ಕಮ್ಮಿ ತಾನೇ ಇರೋದು.
440.
600 ಕಮ್ಮಿ ಇದೆ ತಾನೆ. ನಿಮ್ ಬೆನಿಫಿಟ್ಗೆ ಹೇಳಿರೋದು. Monday.
Because I thought the date is 10/2.
Learned counsel for respond number 1 and 2 seeks for 1 to 3. Submit that inspection has been carried out. Given 2 days time, the inspection report would be submitted. Read list on 9th.
26, Narasimha Raju.
A4 second respondent, Annexure A challenged. Placed a memo with orders passed by the division bench, my lords. As per that, we have no right to give them, grant them permission. Act does not provide, and there is strict direction by the
Give us
first
the order.
court.
Who is the authority now?
I produced that as annexure note, I produced before this honorable court, the order of the division bench, page annexure E, page 51. Page 15, referring to that order only, not the learned single judge is accommodated already, but kindly come to the order of the learned. 51 division bench order. Kindly come to page
29107.
29107.
ಅವ್ರು ಕೊಡ್ತಾರೆ 38401 ಕೊಟ್ಟಿದ್ದಾರೆ.
No, club ಆಗಿತ್ತು. In club ಆಗಿ main, this is the main writ petition. ಅದರಲ್ಲಿ page 59. Kindly come to page 60 for a moment. There is a permission, the page 60, the fourth. The authority shall ensure that Kalyan is cleaned immediately after the festival of Ganesha, Durga, and the traditional rituals of the puja, and ensure that the in the water tank shall not merge with the water in tank or vice versa. The authority shall ensure that granting permission of immersion of Ganesha and Durga idols and performance traditional rituals of Chitta Puja shall not constitute.
Is the authority to grant permission?
But second respondent, they have accommodated. Referring to this order, a single judge not kindly for a moment come to page 39 for a moment. Rank considering authority.
Just one. You were saying as per division bench order, you are not the authority to
My lord, we are the authority.
They are
We have
the-
refused the permission, my lord.
You are the authority.
Yes, yes, my lord. Based on
Page
the
39 for a
Your
moment.
refusal, whether it's valid or not, is what we'll see.
Please.
Page 39 for a
Your
moment.
initial submission was you are not the authority.
I'm this authority.
Yes.
Page 39 for a moment.
Hmm.
Referring to this order, this honorable court already granted by page 39.
Correct. That you have shown us the other day.
Please note, page 46 is the observation, no? Internal para 7, page 46. Para 7. These submissions from the circumstances card, the division bench order dated 14/3/2023 in writ petition number so and so, Perus. The division bench, while observing that section 12 of the KTCD Act does not bar the authority from granting permission to construct temporary structure to install an
Now, why
idol.
have you refused?
Refused and referring to the
Okay,
division
now,
bench order.
why have you refused?
My lord, based on the annexure may A kindly be seen, my lord.
Yes.
We have stated that these two orders, which I have produced with, along with the memo,
Hmm.
prohibits us giving such permission to conduct any celebration within the lake area. My
Where
lord.
does it say that in that order?
My lord, lordship may kindly take my memo filed by me,
Yes.
and lordship may come to page 9 of my page 9, my lord. Lordship will get that contempt order, my lord. This order passed in the contempt proceedings arising out of the very same issue, my lord.
Yes.
Lordship may kindly come to page 9.
CCC 245.
Yes, my lord.
Yes.
Page 9. In that, my lord, clause 2, the court by its order dated 14/3/23 has passed the following order on IA number -2023. The second in that, my lord, the authority shall not permit any individual, any group or any political party to use the tank area for recreational or celebration.
Yes.
So also to ensure the protection of the tank.
This is not recreational.
My lord, it's a celebration, my lord. The very same subject matter was before the contempt court.
Even the court permitted, I shall ensure that the Kalyani is cleaned immediately after the festivities. Festivals are allowed to be,
No, no, no. May I clarify, my lord, this?
and this is restricted as regards political parties.
Political parties only.
Political party.
Different from religious festivities.
No, my lord.
Subsequently, they were permitted
A
24.
single judge is also
Individual
dealt with it
or any
already.
group. Individual or any group. Yes.
Mr.
Page 61. Adadmele, they are permitted 24,
Raghunath.
25, they are permitted.
There's already an order passed by a single judge in 6395 of 24, Annexure D. After observing all your submissions, permitting them to celebrate for the last year.
My lord.
You are not challenged that order.
My lord, we were not a party to that. We were not a party in that. Only the BBMP was arrived as a party. We were not a party to proceedings.
But we brought to the notice of the authority.
So
Authorities.
BBMP has argued all those things and it's been
My
rejected.
lord, they are the custodians of the lake, my lord.
Yes.
We are the authority, controlling authority.
So if BBMP's contention on these very aspects has been rejected by a coordinate bench, we are bound by the coordinate bench's order.
My lord, I have placed the.
You should have
orders-
challenged that. If
Liberty, your
you were
lordship.
aggrieved
I
by
have
it.
placed the contempt order. I have placed the division bench order.
That order has been interpreted and this is what the single judge has held.
Liberty, your lordship.
We can't differ from the
We are,
single
we
judge.
are, my lord, we have no powers to grant, even the
Page
act very
61
clear.
only, authority
The act is
after
very
the order
clear,
only
my lord.
twice.
He'll pass the same order as that.
Please, please.
No powers.
Have you challenged that order? That order is.
So by the time,
There is
my
no
lord,
charge.
I don't think we are challenged, but I will check once.
by the time, my lord, the function was got over, my lord. The celebration
ಅಲ್ಲ,
was over.
ಅದಾದ್ಮೇಲೆ 2
Have
ವರ್ಷ
you
ಕೊಟ್ಟಿದ್ದಾರೆ.
That's simple. There's already an order against you. You can't re-argue that matter. Only thing that you can do is you can take it up on appeal. You can't re-argue that matter.
Section 12 of the act, my lord. we
That
have
is
no-
only on appeal, not before this court.
I have placed,
We are coordinate benches. If you want, you have not challenged it.
I leave it to your lordship. I have placed the
Yes.
contempt order, division bench order, which
Yes,
prohibits,
that
there's
was
a
for a
direction.
political party, Mr. Raghunath. That has been
My
interpreted.
lord, any individual, group of individuals, it's very clear, my lord. Lordship, the learned friend read that order.
You have made that submission enough.
From 9 years. we are
Petitioner
telling.
is before this court seeking for the following leaves. The petitioner,
But one submission. ಅದರಲ್ಲಿ annexure ಏನ್ 16 ಏನಲ್ಲಿ second representation ಅಲ್ಲಿ that we are not concerned to second representation.
the petitioner association claims to be celebrating Mahashivratri festival at Malathalli Tank Bund area. An application for the last 9 years. An application having been submitted this year for purpose seeking permission. The same came to be rejected by the respondents. Respondent number two on 24/11/2025, which is under challenge in this proceeding, at Annexure A, which is under challenge in this proceedings. The submission of learned counsel for the petitioner is that though there was an order passed on IA number 1 of 2023 in WP number 29107 of 2019 and other connected matters, preventing any use of the tank bund area for the purpose of celebration and for recreational or celebrations, the same would not apply to festivities. And this aspect, having been raised by the BBMP in earlier round of litigation in WP number 6395 of 2024, has been rejected by a coordinate bench of this court by the order dated 4th March 2024. And this court had permitted the petitioners to carry out the festivities in the Malathalli lake by imposing certain conditions. His submission is that the very same conditions could be imposed in the present matter, which the petitioners would abide by. Sri Raghunath Learned Counsel, appearing for respondent number 2, would submit that in terms of the orders passed in WP number 29107 of 2019, there is embargo on use of the tank bed area for the purpose of, for any purpose, including the purpose of the petitioner to have their festivities in the said area. His submission is also that a contempt proceedings have been filed in CCC number 245 of 2024. The said contempt petition came to dispose on 6th March 2025. Which came to be disposed on an affidavit filed by the Chief Commissioner that even the amphitheater will be used as a Kalyani. And on that basis, he submits that the petitioner cannot be granted permission and the rejection made by the respondent number 2 in terms of Annexure A is proper and correct. Para. Having heard so and so produce papers. Having heard all the counsels and having gone through the orders passed in WP number 29107 of 2019, WP number 6395 of 2024, and contempt proceedings in CC number so and so. It is clear that a coordinate bench of this court dealt with what was the order of the division bench and came to a conclusion that the Kalyani could be used for the purpose of Mahashivratri festival and allowed the petition. By directing the respondents to grant necessary approval to put up temporary structure to erect the idol of Lord Shiva using biodegradable material in the area reserved only for the Kalyani. The petitioner to remove all the litter at their cost and not damage any existing structure. Apart therefrom, this coordinate bench of this court had reserved liberty to the Karnataka, then a tank
Conservation and Development Authority.
Tank Conservation Development Authority, that is respond number 2, to impose such other condition as may be necessary to ensure that there is due superintendence over the use of the Kalyani on the said occasion, and that second respondent shall not delay in issuing such approval. These aspects, having been considered by a coordinate bench of this court, have been implemented by the respondents on the earlier occasion. The said order has not been challenged and has attained finality. Even in the orders passed in the contempt petition, what the contempt court has held is that the amphitheater will not be used as an amphitheater, but will be used as part of the Kalyani. And as such, the use of amphitheater for any other purpose has been prohibited, which the petitioner would not be entitled to make use of as an amphitheater. In that view of the matter, the use of the Kalyani having been permitted for the use of festivities by the contempt court as also by a coordinate bench of this court, I have the considered opinion that the petitioner cannot be denied that opportunity for this year. As such, I pass the following order. Writ petition is allowed. The certiorari is issued. The order dated 24/11/2025 at Annexure A is quashed. A mandamus is issued directing respond number 2 to consider the representation of the application of the petitioner in terms of the order dated 4th March 2024 in WP number 6395 of 2024 by imposing such conditions as were imposed in the said order and any other condition that the second respondent chooses to impose for the proper maintenance, upkeep and return of the area used for the purpose of carrying out the festivities.
Great. Soon, 15th is the celebration.
Such
Late
permission to be issued by end of day 9th February.
Great.
57. Poonam S. Patil.
This is the matter concerning.
The other matters are also there today?
No, my lords, only the interim order was not recorded, hence I had moved it. Once. I had passed on the order passed in the connected matter, my lords.
17332. Connect antiದೆ.
Connect agide, but the order was, the interim order was not reflecting.
ಏನು interim order ಏನಿದೆ?
Let's, order says no prescriptive action for all the assessment years as it is.
Learned counsel for the petition submitted by inheritance, the interim order which had been granted on 31/2026 has not been recorded in the order sheet. Submission is accepted. This court had connected the above matter with WP number 17332 of 2025, and the benefit of the interim order therein was to be extended to the petitioner. As such, the mistake is rectified by directing the respondents not to precipitate the matter against the petitioner till the next date of hearing. Relist on, when are those matters?
18-2 minutes.
18-2.
Let's,
Not been served.
we've served, my lords. In fact, the other government council appeared on the last occasion and
For me, for second respondent.
we will serve, my lords, nonetheless. Let's the interim order records
For
in
the
the earlier
petitioner
matter.
undertakes to furnish 2 sets of the petition along with annexure and counsel for respond number 2 by end of day 9th February and file an acknowledgement thereof in the registry, failing which the interim order will stand automatically.
We will do that. Let's the interim order in the earlier matter records as no response received from taking coercive steps against the petition in respect of any of the assessment years. If the same order could be passed.
In respect of any of the assessment years.
Just may I request for hand delivery, because there is some urgency because
Very order.
grateful.
Why are you going there and troubling them?
They have coming to the site, my lords.
This is not ನಿಮ್ಮ ಇದಲ್ಲ ಎಲ್ಲ ಪಂಚಾಯತ್ ಅವರು ಹೋಗ್ಬಿಟ್ಟು ದುಡ್ಡು ಬೇಕು ಅಂತ ಟ್ಯಾಕ್ಸ್ ಅಂತ.
No, in fact, in the neighboring
You have
plant,
the power
yes.
to do it. It's already been held.
Neighboring plant yesterday.
Don't create a, you are elected representative, don't create a law and order issue.
Yesterday, they manhandled the security, my lords, in the neighboring plant. An FIR has been registered in the Panchayat Development Officer.
Law and order issue
I will instruct them that.
not be done. When there is an order passed, you should not be done.
Grateful.
Hearing on IS, serial number 28. M.E. Chandrasekhar Reddy.
Respondent. Here for the petitioner.
Yes.
Respondent number 3 is Somayaj. I will accept notice and respondent number 3 Panchayat PDO. Somayaj is earlier.
Mandamus ಏನಿದೆ?
Really for mandamus, my lord, the representations given
What
by
is
me
your representation
for
for?
affecting Kata in my name.
Kata.
Since 2017 have been,
Petitioner is before this
11 point.
online application you have to file accompanied by necessary documents.
Also ಒಂದೇ ಒಂದು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಏನಂತಂದ್ರೆ ಇವ್ರು ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಇರ್ತಕ್ಕಂಥ ಮೆಜರ್ಮೆಂಟ್ಗೂ ಅಲ್ಲಿ ಸ್ಪಾಟ್ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಮೆಜರ್ಮೆಂಟ್ ಟಾಲಿ ಆಗಲ್ಲ ಬಟ್ ಅವ್ರು ಹೋಗಿ ಇವ್ರು ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮಾಡಿಸ್ಕೊಡ್ಬೇಕು.
my lord, I have two permanent injunction suits. In both the suits, with regard to the very same measurements, it has been clearly held that, my lord, the measurements are proper as per the sale deed in 1980, which is
A permanent injunction suit, not a declaration suit.
my lord,
So in a permanent injunction suit, it cannot be held like that. It will be a, now you, when
My
the
lord, my
survey
nine-
happens, you will have to show that.
my sale deed clearly shows the measurement, my lord. And as per the measurement, the injunction
You
suit
want
has
to
been
buy
done.
Vidhan Soda, I will execute a sale deed in your favor.
ಆಲ್ ನೆಸೆಸರಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅನ್ನ
You take the risk of that. That is not the way. You will have to establish that the procedure will have to be followed. Now you file an online application accompanied by documents that they will do. Offline,
My lord, the petitioner is suffering from throat cancer and since 2017.
you can file a writ petition, you cannot file a online application.
I can do that, my lord.
File it. Shri M.S. Devraj, who has appeared for respondent number 2, accepts notice for respondent number 3 also. Registry is direct to delete name of Shri B.J. Somyaji as that appearing for respondent number 3. Petitioner is before this court seeking for the following reliefs. The petitioner claims to be the owner of, what is the property number? Property number 34.
Old number 32/3, new number
Bommasandra,
34.
Bidralli village, Bengaluru East Taluk, which had been allotted Kata number 32/3. The petitioner sold a portion of the said property to his purchaser and had retained
1952. The father-in-law of the petitioner had sold it in 1952, which was reconveyed back to the petitioner's husband in 1980, my lord.
33, 14. The father-in-law of the petitioner had during his lifetime sold a portion of the property to one Mr. Munikalappa, who subsequently reconveyed the same to the husband of the petitioner. The husband having expired in the year 1980, the petitioner there were certain disputes between the petitioner and the purchasers.
Not purchasers, my lord. Third-party claimants.
ಇಲ್ಲಿ ಯಾರು ಮುನ್ನಿಕಾಲಪ್ಪ.
Third-party claimants, my lord.
Who is Venkatana?
My lord, he claims to be one of the sons of the father-in-law, my lord.
And your brother-in-law.
Brother-in-law.
Why do you have to go all around the place? He's not a third party.
He is not a third party. However, he claims one portion of.
There being a dispute among the family members, there were proceedings which were filed, which the petitioner claims to have ended in favor of the petitioner. The petitioner thereafter made an application for issuance of a kata on 3/10/2017, which was followed up with a representation on 13/4/22 and 7/11/2022. The petitioner is before this court contending that despite long lapse of time, the applications have not been considered and orders passed. And in that background, the aforesaid reliefs have been sought for. A perusal of the papers indicate that the applications which have been filed by the petitioner have been done in an offline manner. Now, as per the extent rules, it being required that applications are filed in an online manner accompanied by necessary documents. The said application filed in the year 2017 cannot be considered in the manner filed. As such, liberty would have to be reserved to the petition to file a fresh application in an online manner accompanied by necessary documents. As such, I pass the following order. Writ petitions
also-
allowed.
Boundary demand.
Writ petitions allowed on the application filed by the petitioner for issuance of, in an online manner for issuance of kata accompanied by necessary documents. Respondents are directed to consider the same and pass necessary orders within 60 days of the receipt of the said order, of the above order. Since there is a dispute as regards the boundaries and the measurements, the same would have to be verified in accordance with law before issuance of the kata.
Grateful.
I have 1 of 24. Does not survive.
29.
I'm appearing on behalf of the petitioners in 29.1, my lord.
Yes.
My lords, if I may invite my lord's attention to the order dated.
For 29, where's Mr. Rajkumar? You are okay.
Please, my lords. My lords,
Mallikarjun Reddy and Vattegowda.
please. My lords, this is the matter, if I may mention the facts. This is the matter in which.
Which one do you want to argue? 14129?
My lords, not arguments. On the last date of hearing, Learned Counsel on behalf of the BBMP has filed a memo along with the inspection report.
Violations.
Please, my lords. And they have also made a submission that if those violations are, if the deviation, the demolition is done, then they will consider my plan in accordance with law. My lords, I've already consulted, and I've also made a submission saying that I'll file an affidavit to that effect. I've already consulted with the structural engineer, my lords. Towards one side, there is a little bit of difficulty because a column has been raised. However, despite that, I need only 2 days more time, and I will file an affidavit on Tuesday, my lords.
The counsel for the petition seeks for 2 days' time to file his affidavit. Relist on
Tuesday, my lords.
10th February.
I'm grateful. Within that time, I'll file my affidavit. Interim order may kindly be extended.
Interim order earlier granted is extended till next.
I'm grateful.
Serial number 30.
Serial number 30, I appear for the petitioner.
Correspondent
May I
to file
seek
this
one
matter.
short pass over, my lord, in this matter?
Modification you asked.
Please, I've asked for
It
modification.
can't be by this court. It'll have to go before same judge. IA 2 of 26 has been filed for modification of the interim order dated 11/12/2025. Hence, registry is direct place the matter before the concerned judge.
The date may then be fixed, my lord. There's some urgency. I've
We
sought
can't
for-
fix a date for that court.
And I've asked for.
And this file will have to go to Kalburgi for it to be listed.
My lord, then may I just make one small submission, my lord? I had sought for occupancy certificate, my lord. They had raised a demand. I said I will pay the money, collect this thing in 4 installments, which they acceded to, my lord. Even before the division bench, they've said that we are offering 4 installments. I'm only saying, let me pay the money in 4 installments. An order was passed saying that pay the 4 installments from the date of this order. I'm now approaching them repeatedly, my lord. They're not accepting the first installment.
Then what modification do you want?
I'm only seeking a direction, my lord, that.
That's not a modification.
My lords, in this regard, we have filed an appeal. Kindly I have this next week, my lord. So
Lord, no, I don't think so. I've checked the online.
I have filed
What is the number?
in this matter. On that.
What is the number? What is the number?
I'll let you know.
If you don't give the number, it's not filed.
No, I filed, my lord.
He's saying it's not filed.
Okay, I'll verify this on Monday, my lord.
You give us a number, then we'll adjourn it.
For my instructions, we have filed.
You give us the number, we'll adjourn it. Not
Give in the
otherwise.
afternoon.
If they want only 4 installments, you give them 4 installments.
I have this matter on Monday, my lord. So
Pass over.
Great.
31. SP Leela, connected matter.
Petition, madam. Last date of hearing, madam. Seen for date for mediation, madam. Opinion for senior.
Now you shifted this side.
I mean,
Mr. Leeladhar was on this side the other day.
I've been shunted this side and that side.
Mr. Satyanand wants exclusive
It is not like
respondent
that.
role.
No, since he is appellant in that connected matter, my lord, so I requested him
Yes,
to
but
shift
you are
himself.
agreeable for settlement, for mediation?
I mean, there should not be a problem, my lord. After all, agreeable for a mediation, certainly, my lord, any matter we are agreeable for a mediation.
No, you are not, your colleague was there the other
Yes,
day.
yes, certainly, my
You are
lord. We can
busy
give
in
it a
court hall
chance.
number 1, so he said.
Yes. Only thing is, my lord, having an open mind on this.
Both of you should have open mind.
I have an open mind.
Otherwise,
But,
both of you are going to be in trouble.
yeah, several opportunities earlier we explored. I mean, I'm not using
Was
that.
it referred to mediation earlier?
Yes.
Has
And
failed.
various means and ways of trying to solve this problem was including engineers who would try to find a solution for this problem.
Then commissioner was appointed,
Oh.
report is placed on record.
So we've gone a full length on this.
So then there's no point in wasting time again. Then finish the argument.
In
I mean,
fact,
I
survey was
just brought it to
conducted.
the notice of the court.
If you have made all attempts and it's not been successful in mediation.
Still, if an opportunity request to be given, my lord, let it be done. Absolutely no
If
problem.
there is
If there is any sort of
possibility,
possibility,
if there's no possibility, why should we waste the mediator's time?
That's right, my lord. In fact,
Our
we were
mediators
willing-
are
we were not
very
sitting
much
on
busy.
In fact, my lord, we came down trying to solve the problem for both sides, irrespective of the legalities of the issue involved. We were trying to find a win-win situation for both sides. And
You can't have a win-win, you will have a little lose-lose
lose-lose
also.
situation, correctly said. And therefore, my lord,
Because if we were to pass orders from
yes,
what
yes,
we have heard in brief,
yes.
not that it may be that, but from what both of you argued or
Yes.
you started arguing, it appears both of you will lose.
So, my lord, we were prepared to lose something. The other side, subject to correction, was not prepared to move an inch. So that was the way it ended up last time.
If you don't move an inch, you may lose everything.
Have to make one attempt for mediation.
Because once Mr. Satyanand's people come with their bulldozers, everything will go.
Well,
They won't mind, they'll just barge in.
Well, may I suggest this, since the Corporation Council also is keen to explore the settlement, and we are not averse to a settlement, my lord, may I refer it to mediation for one final chance. And I hope that they would have weighed their options and coming out with something new. If they're not coming out with something new, then it's a waste of time.
It's a waste of time and
Yes.
Leelathar was
So
also
they'll have to-
interested. Leelathar was also interested. Last time he made a submission
was
to your lordships.
making-
He was very much interested.
No, no, you
You
were quite right. I mean, I
He was,
acknowledge.
not to use that word in that context, but he was vehement on mediation.
Yes, yes, that is all.
Vehement on mediation is okay, my lord. But if they're coming down to some extent, I will certainly welcome that, my lord.
He was saying
I
that
suggest
you are
that
not
date may
Because
be
if both of you don't settle, then the only option is for Mr. Satyanand, which he won't demolish that small portion.
And my lord, though may I make the submission, my lord? The deviations are on every side. We are only concerned with the side abutting our side, and we are really not vindictive on, it's between the corporation and them so far as the other violations are concerned. It's only the one which is abutting my property.
That is
And
why we
not
are
really
saying
vindictive about.
it's a very small area to be removed.
Correct.
If you remove it voluntarily, then well and good.
Right.
If it goes involuntarily,
Yes.
they
Certainly, my lord.
you can
Certainly.
employ structural engineer, everybody, and
Right,
cut
right.
properly, use diamond cutting tools and do that. They use only bulldozer.
I understand the message coming from the bench, my lord. I completely appreciate that. And my lord, I am deeply conscious of the fact that I have examined the property on my side, and with a deep sense of conviction, I am, in my respectful submission, safe in that. I'm not trying to blow the high moral order here, but I feel comparatively, I seem to be in a.
If you are coming from that side, then you will never do the lose-lose. It won't settle.
No, my lord. Despite that, we have come down a great distance, my lord.
So now what do you want? Last opportunity for
Yes, my lord,
mediation?
what
Or
we
you
will-
want to argue? Whichever, we are fine with it. This, we have to be passing orders in
Last word
matters.
is his.
This is also one more.
Last word is his.
You have to make one attempt for last chance.
Okay, may I make the submission, my lord? If that is the case, the date may be fixed next week or any time. my
We'll
lord.
fix that one.
And a date may be fixed for the matter to come back to the court.
Yes.
I'm grateful.
We'll fix a date in between also to ascertain what's happening.
I'm grateful.
So it is not just a adjournment.
No, because there's an order from the Supreme Court, my lord, fixing a time for the disposal, notwithstanding that.
In this?
Yes, yes.
Yes, yes. 6 months time
6
was
months,
granted.
Then argue the matter, why should we refer?
As against rejection of the interim order, they went up to Supreme Court. Supreme Court has requested for disposal within 6 months, 2024.
Then
That is where, my lord, the coordinate benches also try to persuade them to settle the entire thing.
Yes. May I suggest this, my lord? A final date may be fixed. In the meantime, in the interim, not too long, my lord, maybe in 2 weeks, a final date may be fixed. In the meantime, a date may be fixed to see if we can close the matter.
After arguing for some time, both the councils appearing for private parties submit that they will try and make one more attempt at settling the dispute. And as a request for the matter to be referred to mediation. Taking into consideration that there are serious issues which are involved, and if amicable settlement is not arrived at, the possibility of demolition orders being passed. I am of the considered opinion that an opportunity is required to be granted to the parties to try and resolve their disputes amicably in terms of the applicable building bylaws. In that way of the matter, as such, the above matter is referred to mediation. Both the parties to appear before the director, Karnataka Mediation Center at 2:30 p.m. on 9th February 2026. The director, KMC, is directed to appoint a suitable senior mediator to try and mediate the dispute between the parties.
In the
He
premises.
list on 24th February to ascertain the progress in the mediation. If the mediation is going on successfully, the file need not be sent back. If mediation were not to be going on successfully, the director is directed to send back the file to this court.
It's within the premises of the High Court.
No, center. Mediation center.
Your mediation will take some time. Go there properly in the mediation room. Here is for the mediation drive, what we are doing here.
Yes.
Is for matters which could be settled immediately. Yours, you will have a lot of discussion to happen.
Can it be done here, my lord? No.
Here we are cannibalizing 3 courts where there will be 6 mediation going on in each place. There won't be any privacy on that.
Certainly, grateful.
You will require a lot of venting to be done.
Yes, I am completely in agreement.
Yes.
Please.
Serial number 32. Please take.
I'm appealing for petitioners, my lord. This honorable court has directed me to file affidavit, my lord. That is already on record. We have complied the direction of respondent number 2, my lord. We have constructed the drainage system.
My lords, I've received the copy. I'll take instructions, my lords. And my learned friend for the authority also has filed something. Can I take instructions?
Two is concerned, Lordships have directed me to ascertain as to why there is a slight change of alignment of the road from that of the master plan. That I am filing a memo, my lord, enclosing
Counsel for the petitioner has filed an affidavit. So also learned counsel for respondent number 1 and 2 has filed a memo enclosing certain documents. The same are taken on record. Learned counsel for respondent number 3 seeks for 10 days time to obtain instruction, make a submission, relist on 19th February.
Interim order may be extended, my lord.
Interim order earlier granted is extended till next day.
Great.
20th, 21st Agala, 23rd.
My lords, before 19th, my lords, next week
Before
only.
19th, we don't have time, madam. 19th or 23rd?
23rd.
23rd.
Grateful.
33.
Let us appear for the petitioner.
Appear for the respondent.
Respondent 678. The first matter.
Sixth respondent in second.
Yes, you are appearing in both the matters, Mr.
Petitions, my lord.
Yes.
Connected matter ಅಲ್ಲಿ objection ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
ಯಾವುದರಲ್ಲಿ 33.1 ಅಲ್ಲಿ. Anyway, we'll come back to this.
Then ಈಗ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಕಾಪಿನ
ನೋಡ್ಬೇಕಾ?
ಸ್ವಲ್ಪ ಶಾರ್ಟ್ ಡೇಟ್ ಮೇಲೆ ನನಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಸ್ವಲ್ಪ ಸೋಮವಾರ ಲಕ್ಷ್ಮಿ
First
ಮಂಡೇ
matter I
ಮೇಲೆ
am the party,
ಮಂಡೇ
in second matter I am not the
Urgent
party.
ಆದ್ರೆ when we have to start in some small matters ಅಂದ್ರೆ Monday, Tuesday we are giving. But if you have to start hearing, it will go to 19th or after 23rd.
19th ಮೇಲೆ.
ಇಲ್ಲ appearance correct ಆಗಿದೆಯಾ? Yes. Lord Counsel for respond number 3 to 5 is filed as 3, 4 and 7 has filed a statement of objection in 33.1. Same is taken on record. Counsel for the petitioner, having received a copy thereof, seeks for and is granted 10 days time to go through the same and make his submission. Relist on 19th. It's been filed. Serial number 30. Learned Counsel for respond number Shri Delete Pawan Kumar. Shri Learned Counsel for respond number 3 to 5 submits that a writ appeal in WA number 187 of 26 has been filed, challenging the interim order dated 11/12/2025. In that view of the matter, relist on 16th March.
Not list number 2.
Until writ appeal is disposed, liberty is reserved to the respective councils to move the matter after disposal of the writ appeal.
Not list.
You go there and move the matter.
List.
Go clear it.
Not list number 1. Seal number 5. ಅದೊಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಬೇಕಿತ್ತು.
5. ರೆಸ್ಪಾಂಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ?
ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ತೀನಿ ನೋಡಿ.
ಮಾಡ್ತೀವಿ ಬೇಡ, ಮಾಡಿದೀರಾ?
ಇಲ್ಲ ಹೇಳ್ತೀನಿ ಈಗ ಶರತ್ಗೆ ಐ ಲೆಟ್ ಹಿಮ್.
ನೋ ಎಕ್ಸೆಪ್ಷನ್.
ಒಂದು ಮಾತು ಹೇಳ್ಬಿಡಿ.
27. ಎಸ್. ನೀವ್ಯಾರಿಗೆ? ಪೆಟಿಷನರ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ? 27. ಅದರ ಏನಕ್ಕೆ ನಿಮ್ ಟೈಮ್ ಬೇಕಾಗಿರೋದು? Counsel for response seeks fund is granted 2 weeks time to file a statement of objections. Objections, if any, by 26th February, relist on 3rd March. IA 1 of 25 is allowed.
List 1.
34. We'll find out. It's not a matter to be mentioned.
List 1 serial number 2 ಮೇಲೆ.
List 1?
List 1 serial number 2.
2.
Dismissal.
Dismissed.
ಮಂಡೇ ಮೇಲೆ.
ಇವತ್ತು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳಿದ್ರೆ ಇವಾಗಲೇ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀವಿ. ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಇದೆ, ಮತ್ತೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳ್ತೀವಿ.
ಅಟೆಂಡ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದು.
ಇವತ್ತು ಅಟೆಂಡ್ ಮಾಡಿ ಟೈಮ್ ಕೇಳಬೇಡಿ.
ವಿಲ್ ಮೆನ್ಷನ್ ಟು ದಮ್.
ಇದ್ರೆ ಆಗುತ್ತೆ ಆಟೋಮೆಟಿಕ್.
ಇದಕ್ಕೆ ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ ಒಬ್ಬೊಬ್ರು
ಅಲ್ಲ, ಫಸ್ಟ್ ಕಲಬುರ್ಗಿ, ಆಮೇಲೆ 230 ಮ್ಯಾಟರ್ಸ್,
ಇದು ಲಾಸ್ಟ್
ಎಲ್ಲ ರೀಚ್ ಆಗಿ
ವೀಕ್ ಬಂದಿತ್ತು. ಇದ್ರದ್ದು ಇನ್ನ ಹಾಕಿಲ್ಲ.
ಯಾರು ಎಷ್ಟೊತ್ತು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರೆ ಗೊತ್ತಾಗಲ್ವೇ? ಟೈಮ್ ತಗೊಂಡೋದ್ರೆ ಬೇಗ ರೀಚ್ ಆಗುತ್ತೆ. ಯಾರು ಎಷ್ಟೊತ್ತು ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರೆ ಅನ್ನೋದು ಗೊತ್ತಾಗಲ್ವೇ ನನಗೆ?
ಇದು 12 ನನ್ಗೆ
ಇಲ್ಲ, ಫಸ್ಟ್ ಕಲಬುರ್ಗಿ, ಆಮೇಲೆ 230 ಮ್ಯಾಟರ್ಸ್, ಫಾಸ್ಟ್ ಅವರ್ಸ್.
ಲಾಸ್ಟ್ ವೀಕ್ ಲಾಸ್ಟ್ ಫ್ರೈಡೆ ಥರ್ಸ್ಡೇ ಬಂದಿತ್ತು ಸರ್.
ಲಾಸ್ಟ್ ರೀಚ್ ಆಗುತ್ತೆ.
ಅದು ಎಲ್ಲ ಅವಾಗ ಇದಾಗುತ್ತಲ್ಲ, ನಿಮ್ಗೆ ನೋಟಿಸ್ ಆಗುತ್ತಲ್ಲ. ಅವರು ಕೇಳಿದ್ರೆ
ಫಸ್ಟ್ಗೆ ಕಾಯ್ಬೇಕು.
ಇಲ್ಲಾಂದ್ರೆ ಅವರು ನಮ್ದು ಏನು ಇರಲ್ಲ ಅಲ್ಲ ಪಂಚಾಯತ್.
ಯಾವ್ದು ಲಿಸ್ಟ್? 20 ಇದೆ ಇದೆ ಇದೆ. ಅಡ್ಜರ್ನ್ ಆಗಿಲ್ಲ. ಡಬಲ್
ಅದು
5
ಆಗಿಲ್ಲ.
ಅದು ವಿಡ್ರಾವಲ್ ಹಾಕಿದ್ದಾರೆ. ವಿಡ್ರಾ ತಾನೇ ಆಗ್ಬೇಕು. ಇಲ್ಲ ಆರ್ಡರ್ ಆಗುತ್ತಲ್ಲ, ಅವಾಗ್ಲೇ ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಲ್ಲ. ಅದೆಲ್ಲ ಅಷ್ಟ್ರಲ್ಲೂ ಸೇಮ್ ಪ್ರಾಬ್ಲಮೇ, ಅವ್ರಗಳಿಗೂ ಗೊತ್ತು. ಅವ್ರ ಹತ್ರ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಎಲ್ಲ ಶೇರ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. ಯಾವ ತರ ಮಾಡಿಸ್ಬೇಕು ಅನ್ನೋದೆಲ್ಲ ಅವ್ರ ಹತ್ರ ಶೇರ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಮಹಾಂತೇಶ್ ಶೆಟ್ರು, ನಿತ್ಯಾನಂದ ಅಲ್ಲ, GM ಅಲ್ಲ, LB ನೂ ಇತ್ತು ಒಂದ್ ಕಾಲದಲ್ಲಿ. ನಿತ್ಯಾನಂದ, ಸಂತೋಷ್ ಕುಮಾರ್ ಅವ್ರು ಬರ್ತಿದ್ರು. ಅವರೆಲ್ಲ ಇಲ್ಲ. ಓಹೋ, ಸರಿ ಸರಿ. ಏನಪ್ಪ ಯಾವ್ದು ಇವತ್ತಾ? ಅದೇ PL ನವಸಾರಿ ಇವತ್ತಿದ್ದ ತಾನೆ. ಅವ್ರೆ ಯಾವ ತಲುಪಿದ್ರಂತೆ? ಇಲ್ಲ, ಅದೇ ಡಾಕ್ಟರ್ ಹತ್ರ ಹೋಗ್ಬೇಕಂತ ಇವತ್ತು. ಅದೇ ಮಲಗಿದ್ರೆ ಹೋಗ್ಬೇಕಂತ. ಒಳ್ಳೆ ಚುಸ್ತಲ್ಲ.
ಸ್ವಲ್ಪ ದಿನ ದಿನ ಕ್ಯೂರ್ ಆಗ್ತಾ ಇಲ್ಲ.
ಒದಕೆ ಬರ್ತಾವಲ್ಲ ಒಂದೊಂದಕ್ಕೂ
ಕಳಿಸ್ಬಾರ್ದಾಗಿತ್ತು.
ಆಚೆ ಕಳಿಸ್ಬಾರ್ದಿತ್ತು, ಅಲ್ಲೇ ಹಾಲು ಕುಡ್ಸೋದು ಅಲ್ಲಾಂದ್ರೆ ಅವರೇ ಹೆಲ್ಪ್ ಮಾಡಿ ಹೆಲ್ಪ್ ಮಾಡಿ ಹೋಗಿಟ್ಕೊಳಕ್ಕೆ ಎಲ್ಲದಕ್ಕೂ ಅವನ್ನೇ ಬೇಕಾಗುತ್ತೆ. ಒಂದು ವಿದ್ಯೆ ಇದಕ್ಕೂ ಗೊತ್ತಾಗ್ತಿಲ್ಲ, ಸಾಕಾಗ್ತಿಲ್ಲ. ಸ್ನಾನ ಮಾಡ್ದಿರ ಚಿಡ್ತಾ ಇದೆ ಅಂತ ಒತ್ಕೊಂಡ್ರೆ ಸಮಾಧಾನ ಆಗಲ್ಲ. ಸ್ನಾನ ಮಾಡೋದು ಅದು ಡಾಕ್ಟ್ರು ಇದೆ ಸರ್, ಇದೆ. ಇಲ್ಲ ಸರ್, ಇನ್ನೂ ಇದೆ. ಇವತ್ತು ಸ್ಲೋ ಆಗಿ.
submission, my lord. First is serial number 9.
Hmm.
3 days ago, they have served the statement of objections.
Have you informed them that you're moving?
ಹೇಳಿದೆ 130 ಹೇಳಿದೆ.
Counsel for the petition seeks for and is granted 10 days time to file his rejoinder and get ready to address his arguments. Relist on 23rd February. It's made clear that no further adjournment would be granted.
Serial number 8, infraction ಆಗಿದೆ ಸರ್ ಮ್ಯಾಟ್ರು.
Serial number?
Serial number 8.
ಏನು?
Serial number 8, register number 1, infraction ಆಗಿದೆ ಸರ್. miscellaneous
Serial number ಏನು?
close ಆಗಿದೆ.
Serial number 8.
8. Petition is before this court seeking for the following memo has been filed dismissed as infructuous.
This one item 5, we have informed the other side. Sharat Gaur.
Hmm. Huh. Any objection? It will go only after 19th if it gets adjourned today. 5, at the request of counsel for respond number? 3. Relist on, ಇವಾಗ ಯಾರು ಅಪಿಯರ್ ಆಗಿರೋದು ಬತ್ತೇಗೌಡನ ಚೈತ್ರಾವತಿನ? Request of respond number 3, relist on 23rd February.
List one serial number 2, my lord. Kindly have it Monday, my lord.
List 1, serial number 2.
Oh, please.
Despite the matter being listed for dismissal on account of, for non-prosecution, counsel for the petitioner once again seeks for an adjournment. Such adjournment cannot be granted. Petition is dismissed for non-prosecution. Yes.
Kalburgi bench matter. West party.
Payment made by the petitioner to the farmer. Page 2 is the communication lot. The last paragraph number 3, Milord. Accordingly, so no arrears are reported in respect of Karnataka for SS 2019-20 and the mill is registered in Karnataka. It is presumed that the mill has made the cane payment to the farmer.
That is not the presumption that we want. You have to tell us whether it's been paid or not because they are not filing anything.
We have filed CA certificate and the RTGS payment statement.
Verified that.
Milord, this is after verification of that, they have said so, Milord.
Can't say presumed after verification.
Your Lordship may observe that, Milord. To that extent, I'll get.
Yeah.
Milord, this is not, Milord, if your Lordship could recollect, Milord, this is not.
This is from Sudhir Singh has not.
Milord, I've got this, Milord, after your Lordship directly.
We are not about you, Mr. Shanti Bhushan. We are about your client saying when they are asked to examine, they say it is presumed. And what is the verification?
Milord, the reason is this, Milord, because the table says, Milord, there's no dues. Therefore, Milord, they worded as that, Milord.
So what do we do? They are cleared and we'll accept your report.
Para 2 also says so, Milord. Para 2, if your Lordship could kindly see, Milord. Further, the mill has submitted any document in this department regarding payments made to the farmers. However, as per status of cane price payment, in respect of Karnataka provided by the cane commissioner Karnataka, no arrears are due for the sugar season 1920. The details of cane price payment are
A memo enclosing the letter dated 28/1/2026 has been filed, which reads as under. A peril of the in the peril of the above letter would indicate that there are no arrears which are due for the sugar season 2019-20. There are no defects which have been pointed out with the filing made by the petitioner. In that view of the matter, the certificate which has been filed is accepted. Compliance with the interim orders.
13/6/2019.
13/6/2019. 19 is held to be made. No further orders are required.
Please.
Then what is IA 1 of 25?
My lords, NBW was issued, my lords, I had filed that for recall. After that, we have
We have the disposal of the matter earlier. IA 1 of 25 also stands disposed.
much of.
230 matters. List number 2, serial number 37. Prithvi Wadia and connected matter.
Milords,
Yes.
Milords, arguing counsel is on his legs, Milords. Milords may kindly pass over, Milords.
Paso. Who is, really?
Last occasion, I made a submission, my lords.
You will try and resolve it.
In this regard, came with a reply that legal committee, not only state legal committee, and with all concerned, all stakeholders will summon. Take some reasonable time, 2 weeks time will be granted. I have also produced the email communication that sent by MD.
So you convened a meeting. How much additional time?
2 weeks time may be granted. 2 weeks time may be granted.
Look, this is one factor, Manoj, which I want to bring to your lordship's attention. This was a contract that we were supposed to execute from last year. We made an investment of 30 crores. We are, Manoj, incurring expenses every month.
What do you want? You want them to resolve both your issues?
No, they've already taken a stand, Manoj. I'll take your lordship through that. They've already stated what their position is in writing.
See, if you are taking that stand, we'll record it and they don't need to do anything. Why should we trouble them? Because both of you said they have to take a stand.
But
Now they have said that we'll have to have a meeting to take a stand. Then you cannot say that KMF has to take a stand. That argument will go.
Yes. Because I'll show my lords that they've already taken a stand.
But then you have been arguing the other way around.
No, my lords.
That is why they said.
They said that they wanted to take some time, my lords, because your lordship asked them what is their position on this matter. They said that they wanted some instructions. I won't take more than 10-15 minutes.
Yes. Anyway, that contract is going to come to an end on 30th.
I wouldn't have objected, Milords. There's just one aspect, Milords. This company is on the verge of becoming an NPA. So, Milords, this is really.
You won't get the order before 30th. As simple as that.
But at least, Milords, if we know that, Milords, we can operate this contract that we've obtained. And in fact, Milords, as far as that is concerned, Milords, there are 2 aspects of this contract. One is a co-packing one. Milords, we've made an investment of 30 crores, built a plant.
Their contract will come to an end on 30th. After that, how they function is their lookout.
But Milords, there is another contract, which virtually is a contract in perpetuity.
Come, there's no need of piecemeal.
Grateful, Milords.
Yes.
38.
Petitioner in this matter, Madam. This matter pertains to section 57 of CRPC.
20 years.
20 years, my lord. The prisoner convict has spent 21 years, 1 month, my lord, as of today.
Yes, Pradeep.
And without remission, my lord. I have received the objection, my lord.
Argument and objection.
Last time we sought time to file objection.
Short time to file objections.
You argued twice already, then.
My lord, in the
one small thing you said you'll need a clarification.
My lord, in the recent judgment of Supreme Court, all the aspects of all the recent.
Let him make a submission. You can reply. You have already argued. He has argued and he wanted to clarify that.
I wanted to clarify. But the clarification, my lord, here. I want to read the operative portion of the order once again. And then, my lord, I will come to the
order in which one?
Order page number 42, my lord. Criminal appeal.
Yes.
Page number 41 to the end of it. Accordingly, the death sentence awarded by the trial court is modified and accused number 1 to 3 are sentenced to life imprisonment. It is further directed that accused number 1 to 3 shall not be given commutation after completion of 14 years of imprisonment as a matter of routine. But this relates to section 55. Section 55 not reads like this.
IPC.
commutation of sentence of imprisonment for life.
Hmm.
In every case in which sentence of imprisonment for life shall have been passed, may without the consent of the offender commute the punishment for an imprisonment of either description for a term not exceeding 14 years.
Hmm.
So the minimum that he has to serve is 14 years, but not beyond that it cannot commute. Commutation cannot be done. Is what 55 says, not. So that is what is reiterated here. Manoj is saying that as a matter of routine, he is not eligible for 55.
In
No,
55,
the
as a
next-
matter of routine, it can be done.
No.
Here it's saying that don't do it as a matter of
Don't
routine.
do it as a matter of routine. And in this case, especially not to be done, because that is what further reiteration says. Further says the accused have to serve life sentence and they should be in jail in terms of section 57. Now, section 57 now says
20
that,
years.
20 years. So that's the minimum sentence that they have to serve.
Yes.
No, my lord, it does not say that after completion of 20 years, that is in accordance with 57, that he should be released for prison. It only says that he has to serve his sentence of 20 years.
That is what the judgments say.
Yes, sir.
Judgments of the apex court say.
Correct.
After 20 years, he has to be released.
No, but it doesn't say.
The exceptions
It
are
says-
only where the judgment says that he should not, he should undergo for life, natural life,
Yes, that is the actual.
no remission.
That is the
If
actual
those conditions
interpretation.
are imposed, yes.
That, I'll come to that. That's the actual. See, when we say imprisonment for life, it is for the entire lifespan till he is alive. Yes. But then what happens is not there is remission and commutation of sentence. This is why not commutation of sentence and remission. Section 55 says fractions of terms of punishment. And when we do all this, the minimum term to be served is 20 years.
Yes.
That's in accordance with this, the order also. That's the minimum term that 57, in terms of section 57, 20 years has to be served. But that doesn't say, like here it does also, it doesn't say, right, that he has to be released soon after 20 years. No, my lord.
There can be a dispute, but what about judgments of the apex court?
That's the order.
Really?
Even the apex, yes, that there, my lord, there is a difference between that order and here is because here, my lord, there is no, it is not a fixed term. A fixed term is not when an imprisonment, it is, he has to, he is imprisoned for a term of 5 years, for a term of 10 years. Like that, my lord, if it is a fixed period, then, my lord, he has to be released soon after that period is over. But here, since it is a death sentence which has been commuted to life, and it is in terms of section 57 that he has to serve his sentence, that doesn't make him, that doesn't entitle him for release after 20 years. Because here, for such purposes, there is a separate chapter not under the prisons manual. After such term, what has to be done? After such term that he has served for 20 years, according to section 50,
Prisons manual, Kodi.
chapter 43, not
Ilva.
the prisons manual.
Inna on the extra copy idea.
Isn't it?
Copy. Nimatra man.
I don't mind, I'll manage.
You'll remember the comma, full stop, everything.
No, not that. Not. I may not remember everything word by word, but
When you're interpreting, you'll need it.
No. That is constitution of the advisory board. No,
Yes.
constituting the advisory board. That is for purpose of premature release in case where he has served his sentence. My lord may come to rule 819. That
Functions.
subsection, the subclass 3. There, my lord, the last line. My lord may kindly read the entire thing. But then-
What is your submission?
But there, see, my lord, here, this advisory board, my lord, it constituted for the purpose of release of such prisoners.
Correct.
And my lord, an application has to be made that he has served the sentence here. I should be recommended, or the jail authorities could sumoto recommend them for to the advisory board, where they can it has to be placed before the board, and they will go into the directions of the court or whatever, not say subclause 3 by Lord says. It says, in accordance with the, under the directions of the Honorable Supreme Court or the High Court, there, my lord, they will go through it and they say, okay, fine, we will abide by it and release him forthwith. The advisory board has to do it. So there is a board constituted, and my lord, when they produce this, the order before the advisory board, my lord, it was earlier constituted, it used to be constituted twice in a year, according to the, now, my lord, by virtue of the judgment of the Honorable Court. Every 2 months, my lord, the advisory board is constituted. There, my lord, the matter has to be taken up, and they'll go into the merits of the case, and they decide, and they'll forward it to the state government that state remission has, or commutation has to be awarded to this
This
person.
applies and the 55 after 14 years.
Even to 57.
Come to the judgment.
Even to 57.
Come to the judgments, Pradeep.
Judgment very clearly says.
Come to the judgment.
The other judgment which my learned friend is relying upon.
Page number 100, my lord.
101, my lord. We can start it at page number 100 itself, my lord. Paragraph number 15.2.
Yes.
In the instant case, so my lord, it is not a judgment in rem.
Right.
In the instant case.
ನೋಡಿ
I
ಆಮೇಲೆ
have already
directions.
noted. Pardon, my lord.
Directions ಬರುತ್ತೆ no?
I have already noted the life imprisonment being 20 years of actual punishment. This is what I was trying to tell my lord. Because there it is 20 years of actual punishment. It is a fixed period. Was without consideration of remission. Soon after the period of 20 years is completed, in our view, the appellant has to be simply released from jail provided the other sentences run concurrently. The appellant is not under any obligation to make an application seeking remission of his sentence on completion of 20 years. This is simply for the reason that the appellant has completed his 20 years of actual imprisonment. And in fact, during the period of 20 years, appellant was not entitled to any remission. Thus, in the instant case, on completion of 20 years of actual imprisonment, it is wholly unnecessary for the appellant to seek remission of his sentence on the premise that his sentence is a life imprisonment, that is till the end of his natural life. On the other hand, learned appearing for the respondent state and complaint contended that once the period of 20 years is over, which was without any consideration of remission and seeking remission of the sentence, by making an application to the sentence review board, which would consider in accordance with the applicable policy and decide whether the remission of sentence imposed on the appellant has to be granted or not. Such a contention cannot be accepted for the reason, firstly, because the instant case, because the instant case, the sentence of imprisonment for life has been fixed to be 20 years of actual imprisonment, which the appellant herein has completed. In our case, case on hand, there is no fixed period.
What does 57 say? 20 years. That is a fixed period.
That is the minimum period, while they fragment the computation of sentence. That doesn't entitle him to say that he has to be released, because that is not a
So
fixed period.
according to you, what is the imprisonment term for the
But
petitioner?
if that was the intention of the Honorable Court, it would have been mentioned as actual imprisonment in according to so and so.
Right. Now, according to you, he can't claim remission for life.
No, it's not that.
Or the imprisonment is for life.
That's the reason.
What is your submit? What is the sequitur? If you say it is not 20 years, it is more than that.
No, it is actually more than that, because when we say imprisonment for life, it is for the entire lifespan. But now, since there is a direction that the minimum sentence has to be in accordance with section 57, we would say the minimum sentence is according to 20 years only.
Yes.
But that doesn't entitle him to be released soon after 20 years, because it has to go before the board.
There is no concept of minimum sentence. Sentence is sentence.
No, that is when fixing of.
Only the statute will say minimum or maximum.
Let me try to
Judgment
convince
can
my
only be particular.
It's a very thin line of distinction, my lord. I've tried to convince.
Very thin.
Very thin line of distinction. I tried to convince. Here, my lord, what has happened?
In this case, there was actual imprisonment for a fixed term. So, my lord, soon after the term is over, it was fixed for 20 years, 20 years. Soon after the term is over, he has to be released. Question of section 57 doesn't arise at all. Now, when section 57 arises, it is for computing, my lord. It is for computing. 57 reads as such. Fractions in terms of punishment, in calculating fractions of the terms of punishment. So what happens here, my lord? When they are calculating the remissions and things like that, it has to be reckoned that 20 years is the minimum
We
sentence.
understood that. We are only
So there is
testing.
no question of fixing of the sentence.
We are only testing your submission. If you say section 57 is minimum, then what is the maximum here?
Lifespan, entire span, and until his natural death. That is the sentence when we say imprisonment for life. But now, my lord, here they have to compute the remissions and so all these things. So by virtue of that, order says you have to take the recourse of 57, saying the minimum should be 20 years. But after that, for a premature release, there's a board constituted.
He has to file an application.
He has to file an application.
I'm
He has
getting
to go before the board.
That is the submission you have to make.
Yes, that's what.
Otherwise, you are saying there's nothing.
No. That's what I am saying.
So
No,
your contention is
819 subclass 3.
Your contention, from what we understand now, Victus, is that he is normally not, he is not entitled for after 14 years. He is now entitled after 20 years. If he wants to claim remission, he has to file an application.
Application before the board.
That will be considered
Yes,
by
ma'am.
the committee
In accordance with 819 subclass 3.
as per the applicable rules.
Yes, ma'am.
It's not an automatic release.
It is not automatic.
As was held in this matter.
Yes.
Where there was a fixed term of 20 years.
Fixed term.
That's your submission.
Yes.
My lord, rest of the prisoners are getting released at
Pardon me.
ಇನ್ನೇನ ರೀತಿ ಹೇಳಿ.
ಅಲ್ಲ ಅದೊಂದು 819 ನಲ್ಲಿ ಆ subclass 3 ಅಲ್ಲಿ ಅಲ್ಲ
Or ಕೊಟ್ಬಿಡಿ, or you will have the benefit of that.
where there are directions issued, what is the procedure? 819. Upon completion of review by the advisory board, may recommend the government for not the one on top. I'm sorry, not subclass 2. It shall be duty of the chief superintendent or the superintendent of prisons to make a list of all eligible prisoners for premature release as per the rules framed by the government from time to time, as well as other existing legal provisions and directions issued from the Honorable Supreme Court and the High Court. Here, my lord, there is a direction from the Honorable Court saying he has to be released after in accordance with section 57.
Yes.
They have to make an application before the chief superintendent of the prisons, who will recommend it to place it before the advisory board, and they will follow the directions, my lord. Here, what happens, my lord? Now, if it is an order by this honorable court that 57 has to be interpreted in such a manner, my lord, the entire it will open floodgates.
Be automatic.
Yes, ma'am. So it has to go. There's a procedure fixed. The state government has made certain rules. And my lord, further reading, my lord, the next orders 820, my lord, with KNDC. In such situation, the state government thereupon shall consider the recommendation of the advisory board and may direct that the prisoner be released forthwith, or the prisoner shall be released in the ordinary course on the expiry of sentence, including the remission. So, my lord, here what has happened, they only calculate, that's the fragmentation of our computation of all the remissions and whatever that they have earned remissions, everything. And they say, okay, this is the minimum term, this is what it is. And in there, the order of the honorable court, so he has to be released. They have to pass it. It's the state government which releases convicts. Now, the courts, my lord, going into that shoe. I don't think, my lord, this probably, if we interpret and see it in this line, my lord, that would be the right way of
You file an application.
to file an application. That will be placed before the advisory board. That is recommended the state's prerogative, not that the state
releases the prisoner in accordance with the orders passed by the court. A shortcut taking
Automatic illa.
automatically release. This is my submission.
That is the first submission. Fell in application. ನೀವು ಇಲ್ಲ ಅಂತ ಹೇಳ್ಕೊಂಡು ಬರ್ತಾ ಇದ್ದೀರಾ.
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ. ನಾನು ಇಲ್ಲ ಅಂತ ಹೇಳೋದಿಲ್ಲ.
My
ಈ ತರ
submission
ಮಾಡಿ
is
procedurally ಹೋಗಿ ಅಂತ ಅಷ್ಟೇ.
all rest of the prisoners are getting released, including remission, 14 years. Without remission, after 10 years, they are taken decision. This prisoner, including remission, 26 years almost he has spent, my lord.
21 years.
That is excluding remission.
So you make an application. That is what they're saying. Make an application. They're not saying we won't consider.
ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ತಗೊಳ್ಳೋ ಮೆಕಾನಿಸಮ್ ಇಲ್ಲ ಅಲ್ಲ my lord.
ಏನ್ ಮೆಕ್ಯಾನಿಸಮ್?
ಅಲ್ಲಿ ಇವರು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿರ್ತಾರೆ, they don't receive it.
They're not receiving your.
ಅದು payroll, that's the reason we are filing payroll matters here in the high courts, man.
Payroll ಅಲ್ಲಪ್ಪ ಇವಾಗ.
ಅಲ್ಲ ಪ್ರೆಮೆಚೂರ್ ಮೇಲೆ ನಾವು ಇಲ್ಲಿ ಫೈಲ್ ಮಾಡ್ತೀವಿ, ಅಲ್ಲಿ ಅವ್ರ ಹತ್ರ ಏನು ಇಸ್ಕೊಳ್ಳೋದೇ ಇಲ್ಲ, they are not accessible.
ಯಾರಿಗೂ ರೆಮಿಷನ್ ಆಗಿಲ್ವಾ? ಯಾರಿಗೂ ರೆಮಿಷನ್ ಆಗಿಲ್ವಾ?
ಅಲ್ಲ ರೆಮಿಷನ್ ಆಗಿದೆ.
Every 2 months, my lord, it's being considered. Every 2 months. By virtue of the judgment of the honorable our court, my lord.
I'll go down, my lords can pass necessary orders so that I'll insist.
We'll deal with your point and pass order.
Yes, my lord. Based on that, I'll insist my client to file an application.
You file an application, it will be considered. Yes. Automatic is you. That's why we told you that day. You're placing the bar too high on automatic. Bar that high. ಇವರು 2 ಸತಿನೂ ಹೇಳಲಿಲ್ಲ, ನಾವ್ ಹೇಳಕ್ಕಾಗಲ್ಲ ಅವ್ರ ಬಾಯಿಂದ. ಅವ್ರಿಗೆ we have to keep on asking questions for him to make submission. Maximum is life. Minimum is 20 years.
According to me,
maximum is life. After 20 years, you will be entitled to. You file an application, that will be considered. That's the only point here.
Yes, according to me, not beyond 20 years, I feel.
Then what is the point in a court passing a sentence for imprisonment for life?
That's the reason I leave it to my lords.
Reserved.
Obliged.
That's also reserved.
Serial number 39.
Obliged.
Kumar Shetty.
Sir.
Yes, madam, you are appearing now.
Burial ground. Allot ಮಾಡಿರೋದು burial ground. My lords, where is that copy?
Yesterday I received the property.
The copy.
Received?
My lords, this is a case. My lords had asked us 2 queries. One pertaining to burial of a body in front of a private property. Their prayer is exemption
in a private property.
In a private property, and their prayer is quashing of the endorsement issued by the assistant commissioner, where he has refused their representation. My lords, on the point of whether there is any burial ground available in that village, yes, my lords, there has been allotted. There is a burial ground available. And my lords, for the query of whether an exemption of the body can be done, my lords, there are 2 things, my lords, I'd like to bring to my lords' notice, that under the CRPC, my lords, under section 196, there is
a. We'll come to examination next. The
Please.
First question, if you have to answer, is if can anybody, if there is a location which has been identified for disposal of the dead bodies, either by way of burial or cremation. It can be, can it be done in any other place other than that place which has been designated? If it can be done, fine, that's a call that you can take. If it cannot be done and it is violated, what is the action?
My lord, section 93 of the Karnataka Panchayat Raj Act.
Come to the conclusion, Lordship. After arguing 93, 94, 92, so what is the procedure is concerned, last occasion order, right? A procedural is concerned, last occasion I filed the memo along with the documents. ಏನಾಗಿದೆ 20 ಗುಂಟಾಸ್ ಆಫ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಅವೈಲಬಲ್ ಇನ್ ದಿ ಸ್ಮಶಾನ ಜಾಗ ಮ್ಲಾಶಿಪ್. ದಟ್ ಜಾಗ yesterday ಹಸ್ತಾಂತರಣ ಮಾಡಿದ್ದಾರೆ ನಮಗೆ, ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ. ಸೊ ದೇರ್ ಆಫ್ಟರ್ ಈಗ
ಹಸ್ತಾಂತರ ಇವಾಗ ಆಯ್ತಾ?
yesterday ಆಗಿದೆ ಮ್ಲಾಶಿಪ್.
ಇಷ್ಟು ದಿನ ಇರ್ಲಿಲ್ಲ ನಿಮ್ಮದು?
The lands have been allotted long back, my lords. The transfer of land is just a mere formality for the panchayat to maintain it. But the lands have been granted long back, my lords.
But is that land being used?
As of now, my instructions are nobody is using it as a burial ground. People in that village are burying the bodies in their own private lands, though the land is allotted.
Is it permissible?
Please, that is the reason I wanted to read section 95. It can't be, they cannot do that without permission.
Yes.
Section 96, my lords, a notice of burial has to be given to the Gram Panchayat. Gram Panchayat has to grant a license.
It becomes a big issue.
Yes.
Anybody will bury anywhere andre.
That the Panchayat will have to look into the matter of their deaths in that particular village, my lords. And without license, if somebody is burying.
You'll have to give instruction as to what it is. And if they have to look into what are the, is there SOP for this? What are the things to be done, not to be done?
Please.
Tomorrow if somebody buries
I follow.
after 302,
I understand.
what happens?
Every death has to be reported to the Panchayat or any local body, my lords. That is why the registrar of deaths, births and deaths.
That is why, that's on the basis of which a death certificate is also issued.
Yes, please.
Everything is connected to each other.
Please, my lords.
But first there was no place ಅಂತ ಹೇಳಿದ್ರು, ಇವಾಗ place ಆಯ್ತು, ಇವಾಗ ಹಸ್ತಾಂತರನೂ ಆಯ್ತು. Every day the matter comes, there's one step at a time ಆಗ್ತಾ ಇದೆ. If this is the thing which is happening in this panchayat, then we don't know about the other panchayats. You'll have to probably look into that.
No, but revenue, my lords, normally every village for a particular area, my lords, burial grounds are allotted.
But what
Irrespective
about
of
95 and 96 implementation?
that, my lords, any guidelines is there, we'll have to verify if there is.
They don't know answer. ಪಕ್ಕದ ಊರಿಗೆ ಹೋಗ್ತಾರೆ. ಇನ್ನ ಒಂದು ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಬಂದಿದ್ದು wherever.
There is a prohibition, my lord. Section 95 prohibits it. If my lord sees section 95.
Now that there is a prohibition.
Please.
And they buried the body without the consent of the landowner in the landowner's property.
Please.
The body cannot be there.
My lords, even for exemption of the body, my lords, there has to be a procedure. So under which provision of law is he claiming for the exemption? Because there is, if my lord sees right to life, right to death, the dignity of death, all those things will come into place.
If we go by this thing of your submission.
No, there should be a procedure in place. Of course, he cannot be left remediless.
Yes.
There should be
The
some
procedure. You'll have to tell us what is the procedure.
Please.
If the law permits in their own property is one part of it.
Please.
But even then 96 has to be followed.
Please.
This is not their own property.
Yes, it's that her husband's house is what they say. There was a dispute between husband and wife. She is the daughter-in-law and
But
she,
that family is not ready for
I
that.
follow. She has the,
If
what we see
everybody
from the,
consent and it is permissible, that's a different issue.
please. From the facts, what we follow is there has dispute between husband and wife and she committed suicide. There was a FIR lodged against the husband and the, then there are some people, the father of the girl has gone and.
In such circumstances,
Yes. We need to,
it is, maybe the circumstances are not right in this case.
yes, please.
But it is
Generally, we need to have a guidelines in such
third
cases.
party coming and burying.
Yes, that circumstance, there should be some, I follow, my lords.
ಏನ್ ಮಾಡ್ಬೇಕು?
I will verify, my lords, whether under section 75, 95
There are
of that,
other provisions also.
is there any rules
That
or
a dead body
guidelines
cannot be
prescribed?
buried near a water source.
Yes.
All those things are there.
Yes,
Now what they have done is they have come and buried near the
next
water
to the
source.
house,
Water source.
house also.
House and water source.
ಅದೇ ಪಕ್ಕನೆ ಮಾಡಿದ್ದಾರೆ.
More particularly, water source is a problem.
Just meter.
And other two neighbors, my lord, petitioner cousin's house also there nearby. Petitioner's cousin's house also nearby is there.
We are more concerned about this water source.
What about
Which will trouble not only you but other people in the village.
That is also there, madam.
Prohibition ಗೆ.
Section 88.
My lords, I will.
I'm not able to
say-
use my house, my lord, from 1.5 years, my lord.
Supposed to be a
Who asked you
farmhouse.
not to?
My lord, that in front of my lord, house, my lord, there is a, they are buried, my lord. I produced the photographs also.
That is not a reason.
My lord, it is, my lord, dead body is in front of my house, my lord.
ನೀವು ಭಯ ಇದ್ರೆ ಅದು ಬೇರೆ.
That is, my lord, residing with the son in Bangalore now, my lord.
Nobody can live around Harishchandra Ghat then.
No, my lord.
That is not
Immediately, my
something
lord,
that you can,
exactly in front of house, my lord, here, they are buried, my lord, without his consent.
there's not a equitable argument which is available for you. You can argue the legal issues. Legal issues, yes, what you argued makes sense. That's what we are asking. You can't say, I can't occupy the, you are free to do so. You can't say, I can't occupy. If you don't want to occupy, that's your problem. Nobody is preventing you from occupying.
It is petitioner's property, my lord, then nobody is
Always
preventing.
do that.
Section 88 of the Panchayat Raj Act. Section 88 of the Panchayat Raj Act.
Yes.
Closing of places for the disposal of the dead. If the Gram Panchayat is of opinion that any place in the Panchayat area which is used for the disposal of the dead is in such a state as to be or to be likely to become injurious to health, if may forward to opinion with reasons therefore to the Assistant Commissioner, the Assistant Commissioner may thereupon after such further inquiry, if any, as he shall be fit to cause to the made by the notification direct that.
Devraj, you had argued this is in the area which is used for the disposal, andre, it is designated. The designated area, those are different. This is an undesignated area.
Yes, sir.
How
Yes,
do
I'll-
you handle undesignated area?
Lords, I'll verify whether is there any guidelines or are there any directions from the Panchayat under section 95 and 96 to all the Panchayats. And if there is none, my lords, we'll advise them to.
Do that, so that, because in this case, whatever the other procedure is to be followed for exhumation and shifting
Please.
the body to wherever is located.
Please.
Now that 20 guntas have been handed over, that you will have to tell us what you are going to do.
Please.
Number one is if there is an area designated, then only that designated area has to be
Could be
used.
used.
Two, no other area to be used as a corollary of it. Three, if any other area is used, then what is to happen? Because that is not here in the statute, because the statute says prohibition and closes it.
Please.
If there violation, the statute is not speaking of. So that gap you will have to fill by your executive legislation, and since the legislature has not taken that into account, probably they thought once we prohibit, nobody will do it.
Nobody will do it.
But unfortunately, that is not so.
Yes.
So you have to fill that gap by executive legislation, or we'll have to fill it by judicial direction until you fill it up with executive legislation. As to what happens if a person does that. And if it could be penal consequences, it could be the civil consequences of what happens to the body.
Yes.
So the whole thing is there. Now you'll have to look not only at burial, you'll have to look at cremation,
Whether proper cremation was done to the body.
because that is even more dangerous. At least exhume madbiಟ್ಟು, if investigation is to be done, investigation could be done. If cremation is done, then you will have nothing.
Please, in fact, I was doing some research for this matter, my lords. I found a Supreme Court judgment pertaining to a police encounter in Kashmir, where 4 terrorists were killed, and a father demanded that the body to be exhumed for him to perform the religious rites of the son. So Honorable Supreme Court explains, my lords, under what circumstances the body can be exhumed. And what my lords pointed out is also considered when the religious rites were performed on the body, whether it would be appropriate to exhume the body and then do it again. So even those things.
We are not on the religious part
Please,
of it at all.
Please.
We are only on, can a third party come and bury some
No, other persons.
in somebody else's
Yes,
property?
yes. This the law doesn't seem to have looked into. Please.
Nobody can do that.
Yes. What would be the consequence?
It goes against all
Please,
tenets of logic,
Please.
law, everything. It goes against all tenets.
please,
So if something like that happens, which has happened in their case,
please.
what is to be done? What is this remedy? He is saying we don't need to do anything. Assistant Commissioner. Assistant Commissioner says it comes under Gram Panchayat.
I follow my lords. My lords may
So
kindly
between
grant
both of them, one nice football match is going on.
this. Also maybe because there's no clarity in the, it's a
That's
gray
why
area.
executive legislation that we asked Mr. Bopaya to check if there are any circular, SOP, anything.
I'll also have a,
This you'll have to see.
how this can be. I will.
Ms. Pratima Onnapura, the Additional Advocate General, submit that she would be assisting the court on behalf of the state. She seeks bond is granted
2 weeks at least,
2 weeks' time to make a submission. Relist on 24th February.
please. Great.
Let's close it on 24th February.
Yes, please.
Number 40.
Yes, Anu?
Senior is appearing in this matter. Can we seek short pass over, my lords? This is the same matter where.
Well, that's one request in this matter. That your lordships have written an order on a similar subject, which I received just now.
ಏನಪ್ಪ ಇದು?
Registration of complaint. Registration of complaint. Writ petition ಹಾಕಿರೋದು.
Non-registration.
Non-registration of complaint.
Non-registration. Rejection and non-registration.
Refusal,
ಇದು non-registration or
rejection
rejection?
ಬಗ್ಗೆ
ಇದು non-registration.
I just want to go through it and
How long do you need to go through that?
a short accommodation.
My lords, there are multiple events which has happened pursuant to this, my lords. I kindly seek short pass over, my lords. Senior will be appearing in this matter.
Paso, it won't reach. He is asking for adjournment.
Or tomorrow, my lords.
Not today. If it goes, it will go to 19th or 23rd.
My lords, Monday at least, my lords. Ready in the matter, my lords.
Okay, Monday.
Sir,
Monday.
my lords is here.
Monday.
He wants to go through some judgment and make a submission. We'll have it on Monday. At the request of counsel for respondents, sir, Monday. Please.
41. Sagarji Shastri, connected matters.
On the last date of hearing, my lord,
The
my lord
forest
had lord, had taken time to take instructions on two questions, my lord. Whether the
Where's Mr. Manmohan?
last date's order is 8th of December 2025, my lord.
Yes.
Whether the lands belonging to the petitioners as regards their established title would be acquired by the respondent state before or along the final notification. Second, how the landowners who have established the right can be compensated if the final notification is to be issued.
Yes.
These two questions, my lord. Now, my lord, received a response from the state government.
My
Lord,
lord,
the
my
stand
lord-
is,
My lord, if I may, senior is
that-
held up in some other court hall, a short pass over.
I'll just take my lords through it. Now, my lord.
He can join. Later.
Please.
Lord, this is the, actually from the additional chief secretary to the government, Lord, forest, ecology and environment. Reference to the subject, you had requested for instructions in WP number and connected matters on the file. So and so daily order sheet, observation of the honorable court. In the letter with reference to Principal Chief Secretary, Chief Conservator of Forest, Head of Forest Force, has submitted a detailed report on the matter, stating that 5 writ petitions on this matter have been listed and are being heard together in the Honorable High Court of Karnataka in respect of the forest areas of Murkand Gudda, Section 4 in Sakleshpur Taluk of Hassan District. Daily order sheet dated so and so, requested to give opinion in relation to the said cases, and the PCCF Head of Forest has forwarded the following. The question of land acquisition does not arise as grants themselves do not have any legal backing, as the grants are after Section 4. Then question of compensation to affected parties does not arise as these grants do not have any legal backing. Accordingly, same.
Not what
So
we
now,
asked for.
no, my lord.
Yours the grants. If the person had a right in the property, which is what they are claiming.
Correct.
That's the disputed question. They are claiming they have a right before the notification. You are saying that there was no right. That we'll see what is to happen. Now, if there is a right which is there, and you, their contention is for 100 years, the no final notification has not happened. Now, if you were to issue a final notification, would they be compensated?
Correct.
Because it cannot be that you issue 100 years ago and a and a final notification now, and they will be left with that. If you take this stand, then that will be a dishonest stand.
No, my lord, I'll just, why this stand is also taken, I'll just, we had filed a memo on 8th of December 2025. Because how the state itself has treated these notifications. Now, I am told, my lord, there are 1,000+ notifications which are in section 4 itself, my lord.
At that stage only.
Yes, and
Nothing has proceeded.
the extent of land in the state is 2 lakh hectares. Now, so any order or this will have a far-reaching consequences, my lord. Now, the reason why the state has now taken a stand is that post section 4.
When you appear, it has to be far reaching.
Or before this court itself. My lord, my lords will see the document which we have filed. My lord, is the circular of the Government of India, Ministry of Environment and Forest, dated 20th of August 2004. My lord sees the last 3 lines. All such proposals for conversion of forest villages into revenue villages and deletion of section 4 area shall be processed by central government only after the concerned state/UT government obtains permission of the Supreme Court or after final decision in the case. This is one such circular which says that there is no question of dropping of section 4 notification also. Now kindly, the reason next page, if you, my lords turns, Lord, this is the where the state itself has sought permission of the central government for Ethinole project, where if my lord sees serial number 5, Nadahalli survey number 197 is part of section 4 notified area, my lord, falling within this Murkan Gudda. And then serial number 7, Kadumane, survey number 68. So 5, serial number 7 and 8.
Ethinole is nearby to this property.
Yes. Now, all these areas are covered 5, 7 and 8, my lord. If my lord sees, state itself has sought the permission of the central government for diversion.
For section 4.
Yes, although it is section 4, my lord, state has treated it to be forest. And I have also pointed out the division bench judgment, my lord, in Sampangi's case, where this honorable court has taken a view that once section 4 notification is issued, section 2 automatically operates, notwithstanding issuance of the final notification. So when the state itself has treated this as a forest, my lord, and
When was the section 4 issued in respect of these properties?
today is 106th, 5th
Anniversary.
of February 1920, 106 years ago. Now, my lord, we have Google images that all these so-called developments are only in the last 10 years. And the officers have also identified.
Time-lapse images.
Have also identified, my lord, that some of the 30 petitioners are not even in possession of the property by virtue of even Google map. Now, my lord, all said and done, my lord. Now, when the learned counsel Manmohan argued by saying there is a shifting of goalpost, my lord, and the rights can be acquired, it was put across in a manner that when under the 1963 Act, or if my lord sees 1927 Act, Indian Forest Act, there is no scope for acquiring any rights pursuant to.
After section 4, final notification is under section?
My lord, this is now. If my
17.
lords had also asked, my lord, one other question, that is Mysore Regulation of 1900 and Mysore Act of 1900.
What
Now,
is
my
the difference
colleague has
between them?
pointed out, my lord, ultimately, the notification under which these two came to be issued is one and the same. There's a reference here.
Could you repeat that?
My lord, the Mysore, it is Mysore Forest Act of 1900. It says, Act came into force on 1st of January 1901. Notification number is 7316, dated 24th of January 1900. The regulation which we have, my lord, also refers to the same notification number. So it is one and the same. There's no two different, not that Mysore regulation continues to exist and Mysore Act came to be repealed under 63 Act.
So, but which one will be enforced?
No, Mysore Act itself, it's one and the same. There is no two acts which are in operation today. Mysore Act of 1900 gets repealed in 1963.
They're identical.
Identical. There's no
No
difference
change
of
in the
nothing.
words.
There's nothing. Because both have their origin to the same notification.
Origin
number.
is different. Contents of
No,
the act and
contents
the-
are also same.
Identical.
Contents are also same, identical.
Identical.
Now, my lord, this argument which was advanced, my lord, on the first reading, I also felt so, my lord. But on the second and careful reading, that where the goalpost is sought to be shifted, that's not the intention of the act at all.
See that section 7, forest.
Regulation, I will just pass it on.
Regulation.
Regulation.
Now the section 4
Section 4 is the preliminary notification.
of the regulation.
Of the regulation and under the act, Lord. I will take my lots. Now, one section alone cannot be read in isolation, my lord. Interpretation of the statute, it has to be read by section, sentence by sentence, phrase by phrase, word by word. Now, I'll just briefly take my lots through the regulation itself, my lord.
Yes.
Now, my lords may kindly come to 3, my lord. Chapter 2, section 3. Any land at the disposal of the government may be constituted of state forest in the manner hereinafter provided. Now, the extent here is to the nearly 8,000 acres, my lord. None of the petitioners are saying that their lands were, they were granted prior to section 3 and therefore it could not have been declared as forest under section 4, my lord. That's not their case. Section 4 may seem, my lord, whenever it is proposed to constitute any land a state forest, government shall publish a notification in the official gazette, which has been done, which is 5th of February 1920 in our case, specifying as nearly as possible the situation and limits of such land, declaring that it is proposed to constitute such land a state forest. And C, my lord, appointing an officer, herein called the forest settlement officer, to inquire into and determine the existence, nature, and extent of any rights claimed by or alleged to exist in favor of any person in or over any land comprised within such limits, or to any forest produce of such land, and to deal with the same as provided in this chapter. The officer appointed under clause C of this section shall ordinarily be so and so. My lord, now the gap between B and C itself, the FSO got appointed only recently, my lord. He has concluded his hearing and he has filed a report to the Deputy Commissioner. Now, kindly see section 6, my lord. Now, section 6 was read in isolation of all other provisions. Now, during the interval between the publication of such proclamation and the date fixed by notification declaring the forest to be state forest, as hereinafter provided, no right shall be acquired in or over the land comprised in such notification except by succession or under a grant or contract in writing made or entered into by on behalf of the government or by or some person in whom such right or power to create such right was vested when proclamation was published. And on such land no new house shall be built or plantation formed, no fresh clearing for cultivation or for any other purpose shall be made, and no tree shall be cut for purpose of trade or manufacture except as herein provided. No right of occupancy shall, without previous sanction of the government, be granted in respect of such land, and every right of occupancy granted without such sanction shall be null and void. Now, my lord, second, nothing in this section shall be deemed to prohibit any act done under written permission of the FSO. 3 is again very important. No civil court shall, between the dates of publication of notification.
Even if the government were to grant without the permission of the the last, no right of occupancy.
No
shall,
right of occupancy
without the
shall
previous
without previous sanction of the government be granted in respect of such land, and every right of occupancy granted without such sanction shall be null and void. Now, my lord,
even if it is granted by the government, who is the previous sanction?
no right of occupancy shall without previous sanction of the government. So the any grant made, my lord, has to be with the sanction of the state government itself.
Correct. Now, if the deputy commissioner were to grant,
then
take the situation, we are testing this provision.
Correct.
If the deputy commissioner were to grant a land to X, from whom does he have to have previous sanction? Because deputy commissioner is the state.
My lord, then the business transaction rules recently also. There's one item 38, which again deals with the forest, but that probably came only into force recently. So the state government, in what context? Is it the head of the head of the government would be?
Grant can only be made by a state, not by anybody else.
So any officer of the state is empowered to grant. Now, my lord, he must write, even in the event, my lord, assuming that situation presents, then the deputy commissioner must say that the area that I am granting is covered under section 4. And therefore, permit me to make this grant. Otherwise, section 4 can stand defeated.
Correct. That is why who will have to permit this? What is the?
Who will have to be? Sorry.
If the deputy commissioner were to grant,
whether he can be construed as
the state.
The
Whose
state government.
previous permission does he have to seek for?
No, then no.
Yes. Anyway, continue.
Yeah.
Because their
No, I'll
grant,
clarify that.
their grant
That-
issue will come.
Correct.
So this issue will come up.
This issue
during
will
the course
come,
of
my
their
lord.
argument.
Then
Yeah,
kindly
contentious.
see 3, my lord. No civil court shall, between the dates of publication of the notification under section 4 and of the final notification to be issued under section 17, entertain any suit to establish any right in or over any land or to the forest produce of any land included in the notification under section 4. So there is a bar of civil court's jurisdiction. Now the FSO, Forest Settlement Officer under this act, is a civil court itself. He has all the powers which my lords will notice under section 8. So this section 6, if read in isolation, my lord, probably what they are saying, but on the whole reading of the act, my lord, the intention is just like any other, if my lord takes even 1963 Act or 1927 Act, Indian Forest Act, my lord, there is a bar of accrual of rights right from the date of preliminary notification itself. Now that is, so therefore, it may not be right to say that by mere reading this one line to say there is a shifting of goalpost by saying that during the interval between the publication of such proclamation and the date fixed by notification declaring the forest to be state forest means any rights which have been acquired prior to issuance of proclamation are to be honored or valid. That may not be the right interpretation insofar as reading of the whole statute is concerned.
Right acquired prior to the proclamation will have to be honored. That
No,
is what the inquiry,
No,
the FSO would be
the
doing.
FSO will inquire
Hmm.
with regard to the rights which are in existence as on section 4 notification.
Correct. So,
So section 4
prior to section 4,
prior to section 4, my lord, we are not on that ground.
post section 4 is different.
Correct. So all the petitioners are here post section 4 itself.
Then the
None
question,
of them are prior to section 4, my lord.
then the question would be reasonable time.
Sorry, my lord.
Question would be reasonable time.
Reasonable
Even
time is
under
one aspect, my lord.
1894 Land Acquisition Act or section 4 or 11 of the new act. After the notification, no right could be. But section 4 has been interpreted that after 4, 6 has to be within a reasonable period of time.
No, that is, my lords, to this one. What they have sought is lapsed and abandoned. That is the prayer which they have sought. So if my lords, if the ultimately court holds that it has lapsed, then question of giving this interpretation, my lord, will not arise.
Not arise.
And according to me, my lord, this interpretation on reading of the act would not be a correct interpretation, because if my lord sees the other section, there is a use of word final notification. So in
Yes.
section 6, it does not say between the interval of the proclamation and the final notification. That's not the wording. It's like backwards, reading backwards and forward to say that moment the section 4 notification is issued, all rights gets crystallized as on date of section 4. The FSO who is appointed will only have to determine the rights as on the relevant date of section 4 notification.
Yes.
So that is the object of the act. Now, one other legal argument would be, my lord. Now, this 1900 Act gets repealed in 1960 by virtue of 1963 Act, which comes into force in 1969. Now, there is a repeal and savings clause.
What does that say?
The repeal and savings clause saves the notification issued under section 4, my lord, under the old Act. 117, my lord, repeal and savings. Karnataka Forest Act of 1963. Now, any proceedings.
Section?
117, my lord. Now, if we have to issue section final notification, my lord, it has to be under 1963 Act itself now. Now, Indian Forest Act of 1927, Central Act so and so as in force, Bombay area. Indian Forest Act of 1927 as in force in Coorg district. The Hyderabad Forest Act 1355 as in force in Hyderabad area. Madras Forest Act 1882 as in force in the Madras area. The Karnataka Forest Act, it should be Mysore Forest Act, as in force in the Karnataka area. And the Karnataka Preservation of Private Forest Act 1962 are hereby repealed. Now, my lords will see, provided that the repeal shall not affect any right, privilege, obligation, or liability acquired, accrued, or incurred under any law, so repeal. So, the notification issued under section 4, my lord, is saved. Now, if my lord sees
yes.
Section 6 here again, Section 6, there is a complete bar of accrual of rights. Section 6 may be seen, my lord.
Yes.
Bar of accrual of forest rights. After issue of a notification under section 4, no right shall be acquired in or over the land comprised in such notification, except again by succession or under a grant or contract in writing made or entered into by or on behalf of the government or some person in whom such right or power to create such right was vested when notification was issued. Same thing, my lord. So, from 69 onwards at least, my lord, there is a clear bar of accrual of any rights.
Yes.
So, all the so-called rights today, my lord, that the petitioners are claiming are by grant by officers, may not be state government as such, my lord, because
That is
now,
you will have to answer that.
my lord, now because I'll answer that, my lord. Now, I have also said, I have also placed on record as to how the state itself has treated this section 4 lands for its own project.
That may be with itself.
No.
If there's a grant made by the state with a previous sanction of the state, as that no rider shall be without the previous sanction.
No, not.
If there's a grant made by the state during the, after the section 4, before the section 17 notification, what is the status of the grantee? The state itself grants and says, no, that grant is invalid. That will not be proper.
I'll answer that point, my lord. But by and large, what I'm saying, my lord, if there is no grant by the state government,
correct,
what the state government would be in each of the cases, I'll just analyze those grants, my lord.
Third individual cannot claim, even if under a sale, they cannot claim.
Correct.
It is only the original owner prior to section 4 notification who can get a right. There is no dispute about it.
Yes.
But after section 4, before section 17, if the state were to grant, and thereafter the grantee were to sell to somebody and somebody and somebody, those things, each of them will be covered under that.
Correct.
Difference is the grant prior and post section 4. Can you now take advantage of saying that it has to be without previous sanction of the government if the grant is made by an officer of the government? who is presumed to have the authority.
Correct. I'll find out, my lord, because this is a special enactment. And what grants are made under what enactment, I will make that submission, my lord.
Yes.
And who would constitute as a state government? Because insofar as the government business transaction rules, the head of the government would be the principal secretary and headed by the minister, my lord. And in what context at appropriate time, the state cabinet will also be.
For this purpose.
For this purpose. Because ultimately now, my lord, what I am now trying to stress also is that the rule of law that is being followed by the state, because of the circular that is now issued, which says that no area under section 4 shall be deleted. And it will only be,
at the most say we'll
then it will
appreciate
amount
that.
to, no, what
But if
happens?
private interests are concerned, we'll have to look at it.
So now what happens? I understand there are balancing rights that the court will have to know, but the far reaching consequences is also that the 2 lakh hectares of forest lands are also 1,000+ notifications are there which have not reached its finality. And the keeping the provisions of the statute, it's a self-contained court which also makes the FSO as the civil courts itself. Just like even under the KIDB Act, I'll come back now. There's no time limit insofar as the final notification is concerned.
Section 24
But here,
will not get attracted.
primarily, my lord, primarily the section 3 says only those lands which are at disposal of the state government. So as in this case, my lord, what was misconstrued and submitted is that we have withdrawn the notification. I have stated how 68 acres was sought to be acquired, with those were not lands at the disposal of the government. Only in respect of 68 acres, the Land Acquisition Act was triggered, and that section and that notification was withdrawn. So that 68 acres is kept intact. Rest all, there's a presumption that these were lands at the disposal of the state government, which fact also cannot be disputed. The only question is whether these grants which have been made subsequently will also have to be tested only by the provisions of now by section 6 also. Because of the repeal and the reservation being saved, my lord. Now the section 6 also says bar of accrual of further rights. And my lord, even Lord, ultimately section 4, if it continues to operate, if section 4 continues to operate, there are two scenarios, my lord. By virtue of the division bench judgment, which says that issuance of section 4 is enough for section 2 of the FC Act to come into force, notwithstanding the final notification.
Division bench judgment in which?
Sampangi, my lord, I have given the compilation. May I request the court officer? 8th of December, my lord. Sorry.
Yes.
This is B.R. Ganapati Singh's case. Division bench, lords will see.
Ganapati Singh.
Ganapati Singh.
Page number, that is the first.
The very first judgment.
Yes.
Kindly see, my lord, in the first para itself, last 2 lines, whether the land in question is a revenue or forest land. Further, the Honorable Supreme Court has observed as under, no effective order in this interlocutory application can be passed till a decision on the issue whether the land in question is a revenue or forest land is arrived at. So here also, my lord, only section, if my lord sees 6.3, para 6.3, in this regard, it's necessary to note that the state of Karnataka had issued notification dated 4/8/1994 under section 4 of the Karnataka Forest Act 1963, proposing to reserve certain lands for the purpose of conserving and declaring them as reserve forests. That a final notification under section 17 of the Act had not yet been issued, but a corrigendum dated 4/9/2014 to the notification dated 4/8/1994 was issued. According to the petitioner, as a result, as many as 104 survey numbers in 7 villages were included and included under the corrigendum as reserved forest, including the subject land. Lord, here also, my Lord sees the next page, 6.4, last 5 lines, my Lord. Accordingly, representations were made to the Secretary, Forest Department, and on hearing of the parties, the then Additional Chief Secretary passed an order in appeal number so and so, set aside not only the corrigendum dated 4/9/2014, but also the very notification issued earlier under section 4 of the Act dated 4/8/1994, which was declared as invalid. Now, my Lord, I'll just take to the relevant portion. My Lord sees para 30 at page 19, the court examines all the provisions of the Karnataka Forest Act, my Lord. All section 4 up to section 20, 24, 28, or right from all the section 2 onwards to section 28, my Lord. Then come to para 32 at page 30. My Lord.
32 to 36 you've taken us through.
Yes. So therefore, this conclusion is that it continues to be in para 46, page 35. Further, in the aforesaid context, we do not think there can be any distinction with regard to a piece of land which has been decided to be constituted as reserve forest under section 4(1) of the Act, and land being deemed to be reserved forest under section 17 of the Act, which is like a final notification. The reason being, once the land is constituted as reserve forest under section 4(1) of the Act, it is by issuance of a notification, then claims would have to be made. And it is only on consideration of the claims that an application for exclusion of land constituted as reserve forest under section 4(1) of the Act could be ordered. Merely because the procedure contemplated under the Act subsequent to the issuance of notification under section 4 of the Act is not yet completed, or no notification has been issued under section 17(1) of the Act, in our view, would not make any difference, as the object and purpose of reserving any land is to treat the said land as being constituted a reserve forest. If such a land or any portion thereof is excluded on adjudication of claims, it would not find a place in the notification issued under section 17 of the Act. Such a case, it would no longer be constituted as reserve forest. But till that procedure is not completed by the forest settlement officer, it remains to be constituted as a reserve forest. So, notwithstanding section 17 today, my Lord, it will be treated as a reserve forest, and automatically the section 2 of the FC Act. So, non-forestry activity is not permitted at all.
Is there any decision which has considered
Time
the
limit.
reasonable period of
So
time
that
from
was
section
considered,
4
my Lord.
to 17?
In Sampangi's case, which we have placed at page 47, my Lord, where the Honorable Court notes that there was no final notification, despite the notification having been issued. I think 17 years was the delay. Para 19, my Lord, at page 60. And says that reasonable time would be 3 years. 3 years for passing of the final notification. Now, here, my Lord, the preliminary notification was of the year 1991. 1991. So, yes, even as on the date, the judgment is of December 11th, 2012. So, from 1991 to December 12 would be about nearly 29 plus 12, nearly 21 years.
The court said reasonable period is 3 years.
So
now
it
you are
says
103
3
years.
Then, so the
103 years, sir.
Then the matter was
100 extra. Just a century more.
Now, my lord, 63,
Hmm.
I have, now this was carried up to Supreme Court, my lord.
Hmm.
And then 65, my lord, a preliminary notification was issued under section 4 of the Karnataka Forest Act 1963 on 3rd June 1991. The respondent was aggrieved by this notification, and that is how the present petitions are before us. Be that as it may, a final notification has been issued on 1st of December 2015. In view of the above, the decision rendered by the High Court in pursuance of the notification dated 3rd of June 1991 has become academic. We therefore dispose of the petitions without commenting one way or the other on correctness or otherwise on the order passed by the High Court. Special leave petitions are disposed of. Then liberty was given to the petitioners to challenge the notification before the High Court. There is no such challenges
In that.
no.
So the only decision has just been rendered on time is Sampangi, where 3 years is to be reasonable time.
And the
It has
subsequent
virtually been
judgment,
upheld by the apex court.
and I think in this case also, that is in B.R. Ganapati Singh's case, Lord, I'll just verify and tell my lords whether there's a reference to this Sampangi Ramaya's case also.
Hmm.
But now, my lord, so there's one judgment which says mere section 4 itself will now have to be treated as reserve for us. One of the honorable judges is part of the board judgment, my lord. And my lords are also aware of Nirvane Gowda's case also.
Yes. Nirvana you have produced?
Nirvane Gowda, it's at serial number 95. Page
25.
Page 95.
Yes.
And last para is para 4 at page 97. The trial court, page 97, Lord.
Yes.
The trial court as well as the first appellate court, based on evidence, recorded findings that lands in question were part of the reserve forest. We do not find any good ground or valid reason for rejection, so and so. When lands were included in the reserve forest, the entries in revenue records were of no consequences. And further, mere Sagoli chit did not confer any title on the suit lands. This apart, the revenue authorities were not competent to deal with the property which was part of the reserve forest. And the first appellate court was right in affirming the judgment and decree of the trial court. We find it difficult to sustain the impugned judgment decree, so and so in these two appeals. So despite there being a grant of Sagoli chit, my lord, the Honorable Supreme Court says that once, of course, here section 17 was passed, but now in view of the division bench judgment, there is no difference that you, notwithstanding section 17, if it is to be treated as reserve forest and section 2 of the Central Act is made applicable. And now the Honorable Supreme Court itself is monitoring deletion of any areas from section 4, my lord. Then whether any grant by revenue authorities can be recognized, purely keeping the interpretation of section
The Honorable
6.
Supreme Court is monitoring section 4 deletion.
Deletion also as per
17 or section 14, no, 4?
Yes.
Section
Now, my
17
lord,
or section 4?
No, my lord. Even NBW, National Board for Wildlife also. If there is any deletion of the areas of the wildlife, then it has to be approved by them. And the as per the circular now which I have placed, my lord, my lords will see the circular is on 20th of August 2004. This is again issued by the Ministry of Environment and Forest, my lord. It says, oh, last 3 lines,
Which
all
one?
such proposals for
Which one are you, what are you referring to?
This is the guideline which I am reading, my lord.
When did you file that?
Now just today, my lord.
The 8/12.
8/12, sorry. 812,
Ah.
where ethanol project was one such.
Yes.
Then before that, document number 1, this is the guideline, 20th of
All such
August
proposals.
2004. Now, this is by Government of India, Ministry of Environment and Forest, Principal Secretary. Then I'm directed to bring to your kind notice that Honorable Supreme Court, wide order dated so and so, has banned de-reservation of forests, national park sanctuaries. The same order has been reiterated by Apex Court on 9/2/2004. In view of the orders of the court, and matter was placed before the Forest Advisory Committee on 26th of July 2004. Taking the fact into account that Ministry of Environment and Forest has already filed an affidavit for vacation of the order, the committee decided that all such proposals shall be closed temporarily, and the respective state UT government should be advised to approach the Supreme Court first and seek the vacation of the order banning de-reservation. All such proposals for conversion of forest villages into revenue villages and deletion of section 4 area shall be processed by central government only after the concerned state UT government obtains permission of the Supreme Court or after final decision.
Where
of
is
the
order
case.
date 13/11/2000?
Can I?
13? I'll
Can
place
just
it.
leave
my
and
lord. It
come
must
back?
be continuous
Let's kindly
mandamus.
excuse me for a minute.
Hmm?
Let's kindly excuse me for a minute.
Sure.
Sorry.
Lord, I'll place that order also. my lord.
Because
Now,
this
even
is somebody's interpretation. Does the
No,
order say that?
no, these are the orders which they keep referring in the circulars in the continuous mandamus of Godavarman's case, my lord.
Where on whether it bans de-reservation of section 4.
No, any area, deletion of section 4 area.
That is what the interpretation or the instructions
this
given
case,
by the
I
Assistant Inspector General of Forest is, no doubt about it. But does the order of the Apex Court say so? If the order of the
I'll
Apex
get
Court
all
says
those
so,
orders.
then they'll have to approach the Apex Court. We cannot
Correct.
deal with
That's
it.
all, my lord. That's all. Now, my lord, if my lords also, union can also be made a party, my lord, because the prayer which is now sought will have a far-reaching consequences. That is where the lapse of the section 4 itself is sought. If the court, if this honorable court feels that any clarification is required from the union, because ultimately what happens, my lord, the union will now prosecute even in Sharavati's case, my lord, where 10,000 acres of forest land was granted by the revenue department to the land losers whose lands was acquired for the dam, my lord. And these lands are now being cultivated. And prior to 1980, all that the state government was required to do was pass a notification de-reserve. It did not, my lord. That notification came to be passed in 2019, my lord. And the division bench, Honorable Justice Oka, my lord, set aside all this de-reservation order on the ground that once 1980 Act comes, you will not de-reserve without the approval of the central government. So we approached central government. Central government said until and unless you get permission from the Honorable Supreme Court, there's no question of de-reserving this land, although the lands may have been cultivated for last 1966 onwards. So now state has filed an application on their behalf before the Honorable Supreme Court, seeking
Show us this
permission.
order of 13/11/2000.
I'll place that.
If
I'll
the
place it.
Honorable
All that
Apex
will be
Court
there.
has said categorically that deletion of section 4,
I'll place it.
deletion of section 4 would include a declaration of lapsing also.
Correct, Lord.
So
Now,
that-
my lord, what has happened, if my lords also sees, there is a jurisdiction of the civil court is also taken away.
ousted, yes.
We find n number of judgments of the civil court declaring title as against the notification, which is like virtually contrary to the provision of law itself, my lord, or de-reserving of forest land. Anyway, my lord, my
problem-
lord's judgment also now, efforts are being made to incorporate all this, compile and put it on the revenue so that these lapse of time, my lord, lapse of time.
This is, what is the relief here?
Because I had discussion, my lord. What they say is when the 1,000+ notification and 2 lakh hectares 2 lakh hectares are still. So it will have a far-reaching.
Oh, it will have a far-reaching impact, yes. But how do we reconcile that with the judgment of this court saying the reasonable period of time is 3 years?
So that
You are more than 103 years.
my lord, if that is so, my lord, the Honorable Supreme Court anyway allows the state government to pass notification even after lapse of 27 years. It does not say that you could not have passed it. In a way, my lord, to look at it, though that judgment clearly says that they have not commented either way, but they have allowed the state government to go ahead and
But
pass
they have reserved right to challenge,
with the liberty to challenge.
leaving all contentions open.
That's all.
So that could not have been decided without a
I have not
challenge
found-
being there.
I have not found any other case law which has prescribed the time limit for passing of the
The
final
only case law on that is 3 years
simply because
by a coordinate bench of this court. So we'll also be bound by that. How do we reconcile that? 3 years if it is said, and then
no, my lord,
for
3 years.
de-reservation, it has to go to apex court.
3 years is the judgment carried up to Supreme Court. Now the order of Supreme Court will also have to be read into it. My lords will also have to take the Honorable Supreme Court's judgment,
now-
where during the pendency, the Supreme Court recognized, of course, gave
Correct.
liberty, but it did not say.
Now in this matter, you still have not issued section
We
17.
have not, in the process, we have completed now the inquiry, and final notification will be issued.
When?
Now,
Another 100 years?
my lord, in any event, my lord, about almost 5,300 acres are recorded forest.
Insofar as this matter is concerned.
This matter
we're
itself.
not, none of the other matters are before us.
No, no, in this
Insofar
matter,
as this matter is concerned.
Mutkan
we're not-
Gudda itself, my lord, total extent is about just short of 8,000 acres. 5,000, 6,400 acres is already reflected in the revenue records as recorded forest. So even notwithstanding, my lord, I'm just saying that now the Honorable Supreme Court, even in 2024 says, the definition of forest has now been expanded to say that if 1 hectare has 10% of density of green canopy, then irrespective of the ownership, the preservation of the forest because of the depletion that is taking place. And I have pointed out as to how this area is critical of the hill range itself, Lord, was known as where it absorbs water during the rains and releases throughout. So there are perennial streams. Now, if left, my lord, of course, the population is also so high, my lord. I cannot turn blind eye to it. But these lands also will not be available. No amount of land, for example, petitioner, though he has 5 acres, he has encroached another 9 acres to carry out resort activities. So,
encroachment
no
you can
amount of
always
land would be sufficient. in terms
Encroachment
of-
you can always remove. We are only concerned with the grant. Now, did you take out that order of the Supreme Court, 1311?
I'll take it out.
Don't
In
have.
fact, there's one book, my lord, I'll try and, where all the orders of the Godavarman's case have been printed. That, unfortunately, it was not continued.
Then place it. And
I'll
then-
place that, my lord, I'll place that.
Monday.
Monday.
Let's finish these matters. When will you
Yes.
finish?
Lord, instead of Monday, my lord, may I request on 11th, my lord, so that I'll get all the copies. I'll place all the orders, important orders passed in Godavarman's case.
11th. The request of learned additional advocate general released on 11th. So 11th probably will sit after 4:45.
Yes,
And
I
we
just
finish
have to
this.
place, there's nothing more.
Whatever you want to place it on that day, both of you. Manmohan is also not here. So you finish it on that.
Yes.
My lord, 11th senior might not be.
11th,
my lord.
10th won't be possible. 11th, 12th.
25th.
You have an interim order. So we won't extend it if you ask that kind of.
12th. 12th, my lord, subject, my lord.
12th.
Grateful.
Interim order maybe.
Yes, interim order extended. File your synopsis of submissions also.
Yes, I'll-
That day or.
By then, I will. Grateful.
This reconciliation, if depending on what that order says, if the order of the apex court says even section 4 is seized by the apex court,
Correct.
then we won't have jurisdiction in these matters.
Then their remedy would only be to, my lord, even the HMT factory, my lord, about 500 acres of land, which was given for the factory, my lord.
Section 4,
Ah,
the distinction is section 17 and section 4.
Then it.
Section 17,
but now,
definitely
my
there's
lord,
no
that
issue at
distinction
all.
has vanished. That
That-
thin line, because
Again,
section 2.
because there's a 3-year limitation for you to take action.
No, my lord, that I would, because if my lord sees the subsequent judgment of the division bench itself, where one of the judges is part of the board judgment, section 4 itself is treated as a reserve for us.
One matter, similar matter, my lord, I've given the number to the court officer, a latecomer to the batch.
Latecomer to the batch.
But the,
Connect with zones.
I have given it to.
Yes.
Please, ma'am.
Serial number 42.
My lords, I appear for the petitioner. The parties have settled, my lords.
So no need to go to arbitration.
No need, my lords. My lords,
You
the
have to
party.
just take it on record.
Yes, my lords, the parties will come in a span of 10 days to sign before this honorable court.
We have to make it a part of the order.
Yes, my lords. My lords may record it.
And counsel for the petitioner submits that the dispute has been settled before the mediation. He seeks for 10 days, he seeks for the matter to be listed after 10 days to enable the parties to appear before this court for recordal of the compromise. When will they come?
It's 25th.
25th at 2:30 PM under the caption reporting settlement.
Serial number 43. Girish B. Bandare, connected members.
ECS is on VC mode. ECS is on VC mode. Allow Mark.
Yes, Mr. Kataria, good afternoon.
Yeah, good afternoon, sir. How are you, sir? Sir, this issue, sir, the last time the direction in 2 cases were to roll out the software, sir. So from the department side, sir, phase 1 we have rolled out, sir. I have given the affidavit and also a status report. In the phase 1, sir, I mean, our main issue was basically that all the SLAOs and departments should be onboarded and we should familiarize them about the status of the software, sir. So that exercise we have carried out, sir, almost close to 10 major departments, 53 offices and 142 office users we have onboarded, sir. And almost 700 projects are onboarded, sir. 951 packages we have created, sir, as on date, sir. Phase 2 is the actual phase, sir, wherein we will actually roll out all the activities, live activities, sir. So if you ask me, sir, as on date, what is the status of these cases, I'm in a position to tell that I have 501 packages at the award approval stage, sir. 84 packages at the initial notification stage, 48 packages are at the final notification and 9 are at JMC stage. So that I'm able to call out, sir, as on date, sir. So my our technical team, I had a detailed review meeting yesterday, sir. So 6 to 8 weeks time, they expect us to roll out phase 2, sir. Phase 2 will cover everything, sir. Phase 2 will have all activities.
We'll also, now we have been seeing a lot of other matters where the reference matters have been pending for 20 years.
Sir.
So that is creating a lot of issues. So you could also include all the litigation, including compensation matters.
We have also told, sir, the second phase will also cover not only the ongoing the activities, it will also the post award activities and also
Post
court
activities.
cases. So for the phase 1 of the second module, sir, we require around 6 to 8 weeks time, sir. By this time, hopefully, my entire up to award, all activities, all stages will be captured through the system only, sir. And as you suggested, sir, this is also in the development stage. We had a detailed discussion. So hopefully another 2 months time, sir, after the module 1, phase 1 is rolled out, we will complete this second module also, sir.
Because you know all the other practical difficulties which are there, you could include that here.
Yes,
so
sir.
that those issues could be sorted. Don't
No, sir,
restrict
now we
it
are
to
completely on it, sir.
what
I have
you
a technical team and I have a small working group, so they are working on all the modules, sir, actually.
So now your department has an in-house technical team.
Sir, we have basically, sir, I have Bhumi monitoring cell, which is completely technical team, sir. But since this project is a part of ULMS, So e-governance is assisting it, sir, and a small technical team from my BMC, they are assisting them to roll out the land acquisition module, sir. Because land acquisition, we are, apart from technical parts, sir, we also have SLAOs who are technically expert, sound people who will assist them in various stages, because we are capturing, sir, all acts, sir. It's the old act and the latest 2013 act, as well as the other
Any
acts under
other
which.
connected acquisition acts?
Yes, sir, all acts, sir.
So phase one will be rolled out by?
Sir, phase one we have rolled out, sir. Phase
Rolled
two
out.
has two modules, sir. So phase one basically was about onboarding of all the SLAOs and basic data entry and all that, sir. So that we have rolled out, sir. Phase one is over, sir. Phase two has two modules, sir. Module one will take care about the award stage activities, sir. And what you rightly pointed out, sir, about post-award litigation activity will be module two of phase two, sir. So the module one of phase two will be able to complete, sir, between 6 to 8 weeks time, sir. And
so by end of April it will be done.
Hopefully, sir. Before that, we are hopefully, but I'm expecting, sir, by mid April we will roll out our first module, sir, of the phase two, sir. Once we successfully carry out that, sir, then we'll also capture all the ongoing litigation, sir. All litigation, all references, civil court or high court or Supreme Court, sir.
An affidavit of the Deputy Secretary of Government, Department of Revenue has been filed, which reads as under. Shri Rajendra Kataria, Additional Chief Secretary and Principal Secretary Revenue Department, Additional Chief Secretary Revenue Department, who is before this court, through video conferencing submits that phase one of onboarding all the departments has been completed with by implementing the land portion, phase one of the land acquisition data entry module as a statewide digital governance initiative to improve transparency, monitoring, and efficiency in land acquisition processes. He submits that phase two has now been taken up, which consists of two modules. The first module would enable real-time capture of end-to-end land acquisition workflow activities of all the departments, which would cater to the flow of the acquisition notifications until the award stage. Phase two, he submits, will cater to post-award stage and include aspects relating to claim of compensation, litigation, acquisition, challenge to acquisition, claim of compensation, enhancement of compensation, and the like, before the Special Land Acquisition Officer, other officers of the concerned departments, the land acquisition courts, as also the constitutional courts. He submits that the module one of phase two will be endeavored to be completed in 8 weeks' time. He seeks for 8 weeks' time to file a further affidavit of compliance stroke reporting progress in the matter. Released on 27th.
Sir, one request, sir. Sir, this is a similar case, 100706 of 2023. It's also listed before this, your honorable bench court only, sir, on 9th, sir. So same subject matter, sir. So I would request, sir, if
we'll connect that also.
Yes, sir. If you connect, sir, then I give compliance in both the cases, sir.
27th April, connect with, write down the number.
100706. 100706.
100706 of
23.
23.
Please. That is coming up on 9th.
It will come back.
Harvard bench. Pertains to Harvard.
Oh, that cannot be connected to this then.
We'll file.
Yeah,
there are other
connect
two
one.
compliances included in that.
That would be a different matter.
Please.
Harvard and Bangalore bench cannot be clubbed together.
Please.
Thank you, Mr. Kataria.
Thank you, sir.
For the implementation of this.
Sir, we are also doing, in fact, sir, all the RTC and PODI, we are also merging, because once the SLO does the land acquisition, so we are ensuring that same time there's a change in the mutation, and also POD is done. So farmer land will remain with the farmer and acquired land will go to the concerned authorities, sir, so that we
Then
can minimize
RTC
litigation, sir.
After that, RTC should not be issued, so that
Yeah, yes,
there
sir.
are
So
other kind of litigation which happen once you start issuing RTC after the conversion is done.
Correct, correct, sir.
So that also you will have to look at.
Yes, sir. Thank you, sir.
44. I didn't insist, my lord. In fact, I didn't insist for appearance, my lord.
We have not called.
Please, no. He
wanted to come.
Please, no.
44 is a matter where sanction is granted for a set of offences, charge sheet is filed. The Lordships have directed me to prepare a chart. The offences, I'm filing a chart, my lord.
Yes.
Please, my lord, let the cost, my lord, and liberty to proceed with the fresh amendment.
So there is no sanction.
There is no
Please,
sanction.
my lord.
Now, my contention is even the fresh order does not save the charge sheet because charge sheet is filed for section 37 of the IPC, which is now not included in the fresh order of sanction as well. The chart would depict, my lords.
What are you challenging here?
I'm challenging the earlier order of sanction, the charge sheet, and the order taking cognizance.
So you challenge the earlier order of sanction.
Yes, my lord.
That you will have to defend.
Please,
Earlier
my
order.
lord, please, my lord, I'll get, anyhow, we get the fresh sanction order, or proceed with the fresh sanction
Insofar
order.
as the charge sheet is concerned,
Please, my lord.
that will have to go.
Go.
But insofar as sanction order, what is your submission? That also can go?
No, the amended chap is.
Their contention is by virtue of the fresh order of sanction, the earlier sanction is withdrawn, but
you are not challenging that.
That is issued now, my lords, during the pendency of this petition.
So you should amend it, right?
Your lordships may reserve liberty. Your lordships may quash the charge sheet and the order of cognizance, reserving liberty because fresh grounds will have to be urged. The earlier order of sanction, this fresh order of sanction makes no reference to the earlier order of sanction. They don't even say that there's an error. It is passed as if it's a fresh order of sanction, which could not have been done in my response.
Yes.
Yes.
But now the earlier order of sanction, quashing the charge sheet because it doesn't have the sanction is one part of it.
Yes, my lord.
The aspect of quashing the order of sanction, you have to address the argument why that is bad.
Lords, the earlier order of sanction no longer survives in view of the fresh order of sanction.
Is it in addition or in substitution?
Does not say so. The order does not say so.
You'll have to show us that if it is in addition, then it will continue.
It's not in addition. Lordships may see the fresh order of sanction.
Page.
It's produced by the learned government advocate along with the memo on the last date.
We don't have it here.
On the last date in open court, it was handed over.
Yes, here. Yes.
This is an order by the Commissioner of Department of Education. At reference number 3, page number 1, E-Kacheri Samasankhya Abhiyojana Manjurati Adesha Dinanka 17/1/2025. This is the earlier order of sanction. But the entire body of the order of sanction does not refer to reference 3. And at the end, page number 4, the order is dated 11/12/2025. Shri C.R. Timmaraju, that's the petitioner, Sayaka Nirdeshakaru Mattu, Shri Nagbhushan HP. Insofar as another person also now sanction is granted.
Yes.
Column 408, 409, 465, 477A. Now they include 408 and they include 34 of the IPC under 197 of CRPC.
Since there is a reference to the earlier sanction, this can only be an addition because they are not saying it is substitution.
Yes, ma'am. Therefore, my request is this petition can be allowed insofar as charge sheet and the order of cognizance, reserving liberty to challenge this fresh order of sanction.
And the earlier, what happens to the earlier order of sanction?
If it is their contention that this replaces the earlier order of sanction, my challenge insofar as the earlier order of sanction will not survive.
What is your contention? Is this
My
replacing?
contention is, my lord, charge sheet may go on, my lord. As per the first sanction order, liberty may given to the file the first charge sheet and.
No, is this sanction in addition, substitution
No, my lord.
of the earlier sanction?
Because, my lord, there is an error in the typographical error. They mentioned as a 409 408 is not mentioned, my lord.
ಅಲ್ಲಪ್ಪ ಇವಾಗ 17,125 was the earlier
Yes,
sanction.
Oh, yes, sir.
Is that withdrawn? Because nothing you have said
Yes,
about
nothing
it.
will serve.
That is withdrawn.
Withdrawn, my lord. That's why the first
Sure.
sanction is issued.
So we'll record your statement that that has been withdrawn. If that has been withdrawn, automatically everything else goes.
Yes, ma'am.
And liberty to
Challenge.
proceed with this first sanction, my lord.
Petitioner is before this court seeking for the following reliefs. That SCGP submits that the order of sanction dated 17/1/2025 at Annexure D has been withdrawn by the respondents, while the subsequent order of sanction dated
11/12.
19/12/2025.
Yes.
If that be so, if an order of sanction has been withdrawn, the charge sheet on the basis of the said order of sanction and the cognizance which has been taken on that basis cannot be countenanced in law. As such, I pass the following order. Writ petition is allowed, criminal petition, writ petition is allowed. The submission of learned HCGP that the order of sanction dated 17/1/25 has been withdrawn is placed on record. Next, the charge sheet dated 28/6/23 filed by the first respondent is quashed.
In respect of
All
petitioner
insofar
only.
as petitioner
In
accused
respect of
number
the
1.
petitioner is concerned. 3, the order dated 19/3/2025 passed in CC number 713 of 25. Insofar as the taking of cognizance and so in respect to the petitioner is concerned, is quashed. Liberty is our reserved to the petitioner to challenge the sanction granted on 19/12/2025.
And also liberty to file the first charge sheet, my lord, on the basis of
ಅದು
sanction.
ನಿಮ್ಗೆ ಲಿಬರ್ಟಿ ಏನಕ್ಕೆ ಬೇಕು?
ಬೇಕಾಗುತ್ತೆ. Maybe.
Needless to say, post the order of sanction dated 19/12/25, respondents are at liberty to take such action as a permissible under law.
Could I also be reserved liberty to challenge the
We have reserved that.
fresh charge sheet if they file? Because they'll then say, because
We can't be saying they'll be doing,
I've challenged it on the merits also, that's why.
that's all hypothetical. Today, what is there is only that. You can challenge that.
And the order of sanctions 11/12, my lords, not 19/12.
19/12 is the digital signature.
Yes. Thank you. Grateful.
230 mood matter. Sir Anandishwara.
Petitioner in this case. Annexure A is the impugned arm passed by the second respondent issuing the communication to the third respondent for demolition of buildings at page number 16, typed copies.
Who formed this layout?
So that is the one Ashwatthappa has formed the layout, my lord.
Huh.
He has obtained a conversion order, my lord. Thereafter, Annexure D is the conversion order, my lord.
Conversion order, Annexure E, page
D,
number?
D, my lord. Annexure D, page 36, my lord.
Yes, survey number 117.
And the
Layout plan sanction?
plan has been sanctioned by the for third respondent EO, my lord. That is page number 13, Annexure E. Page number 39.
ಎಲ್ಲಿದೆ ಇವ್ರದ್ದು ಸ್ಯಾಂಕ್ಷನ್? ಕಾರ್ಯದರ್ಶಿಗಳು.
ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳು ತಾಲೂಕ್ ಪಂಚಾಯತಿ ಮಧುಗಿರಿ.
Khata has been issued.
Please, my lord. Thereafter, my lord, the PDO has issued a notices, my lord, on the basis of annexure for not to annexure L and M, my lord. That is page number 51 and 50. Against which he filed a writ petitions, my lord. Writ petition came to be allowed as per annexure P and Q.
This is only with respect to 117/1B1.
Please, 117(1)(b)(1), my lord. Wherein I have purchased the property sites in question in the said survey number, my
But
lord.
Annexure A is in respect of 1B1, B2, B3, 69,
It is entirely
26.
different, my lord. I am is concerned with 117,
One only you
1B1.
have produced the documents. The other documents are not there. So we'll restrict the order only to 117, 1B1.
So conversion order is clearly says that it is 1B, my lord. Page number 38.
1B1 ಮಾತ್ರ.
Please, ಅಷ್ಟರಲ್ಲೇ ನಾವು ತಗೊಂಡಿರೋ ಸೈಟ್.
Annexure A ಅಲ್ಲಿ
ಹೌದು.
ಇನ್ನ ಬಹಳ ಸರ್ವೆ ನಂಬರ್ಸ್
ಅವರೆಲ್ಲ ಬೇರೆ ಇದೆ ಸರ್, ಅವರೆಲ್ಲ ಬೇರೆ.
ಅದಿಲ್ಲ.
ಇಲ್ಲ, so far as the petitioners are concerned ಮಾತ್ರ.
And AGA is directed to accept notice for respondent number 1 and 2 Madhugiri,
Najugarappa.
A. Nagarajappa for respond number 3 and 4.
Please.
Considering that there is a conversion order in respect of land in survey number 1171B1 and that respond number 3 is granted a layout plan sanction in respect of the said survey number, land in the said survey number. The operation of annexure A is stayed only in respect of survey number 1171B1. Needless to say, the same shall continue to be enforced in respect of the other survey numbers.
Please.
IA 1 of 26 is allowed.
There is an inquiry before Lokayukt, which the endorsement.
Yes, but there is a plan sanction.
Pass over matters. Number 2, serial number 10, VP Sidramaya.
Appearing for petition, my lord. The petitioner is the owner of the property. So land has been converted as per annexure B, page number 21. Sketch prepared for conversion is at annexure D, page number 25, my lord. So, my lord, the petitioner has given an application for approval of the layout plan.
25 ಏನಿದು?
25 is the sketch prepared at the time of conversion of the land. It has been prepared by the taluk surveyor.
Yes.
My lord, there is no karab in the land. My lord will get in the second para of the first portion. Sadari Pradeshದಲ್ಲಿ ಯಾವುದೇ ಕರಾಬು ಇರೋದಿಲ್ಲ. There is a northern side, there is a road. And eastern portion, my lord, Lahi 16/80, it is also converted for residential purpose. Layout plan has been approved by the Tumkur Urban Development Authority.
Yes.
Northern side also layout has been approved. Already has given an application for approval of the layout plan. The Tumkur Urban Development Authority has issued an endorsement at annexure F, page number 27, stating that there may be necessary for formation of road for adjacent survey number 14/3 and 14/5. Hence, the layout plan cannot be approved for a single site. Let the plan may kindly peruse at page number 25. 25. My lord, on eastern side, my lord, the adjacent survey number 14/3 also converted for residential purpose. No such objection has been raised. Layout plan was approved. If they want to demarcate the road for southern side, they could have demarcated the road from the adjacent site also. They have not raised
Can
such
grant
objection.
you the interim relief that you are seeking for. We can only issue notice. Notice ಆಗಿದೆಯಾ?
Fresh matter.
Fresh matter. And AGA accepts notice for respond number 1 and 2. Tuda Yarama?
TP Vivekananda.
TP Vivekananda for respond number 3. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on said counsel. Released on 23rd February.
Serial number 17.
ಫೈಲ್ ಮಾಡಿದ್ರ ಆಗ್ಲಿಂದ ಕೊಡಕ್ಕಾಗ್ಲಿಲ್ವಾ?
ಅನಕ್ಷರ ಒಂದು ಈಗ ತರಿಸಿ ನಾ ಸ್ಟಿಚ್ ಮಾಡ್ಕೊಂಡಿದ್ದೆ, ಒಂದು ಅನಕ್ಷರ ಇರ್ಲಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ. ಇದರಲ್ಲಿ ಒಂದು ಸಬ್ಮಿಷನ್ ವರ್ಷ ಅದಿಯಾರ್ ಫೈಲ್ ರಿಪಿಟಿಷನ್ ಏನಾಗಿದೆ, ಎಂಡಾಸ್ಮೆಂಟ್ ಅನ್ನ ಕ್ವಶನ್ ಮಾಡಿದ್ದಾರೆ. ಆ ಎಂಡಾಸ್ಮೆಂಟ್ ಅನ್ನು ಕ್ವಶನ್ ಮಾಡಿರ್ತಕ್ಕಂಥ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿಗೂ ಇವ್ರು ಅಯ್ಯ ಹಾಕಿರ್ತಕ್ಕಂಥ ಪ್ರಾಪರ್ಟಿ ಏನಂತಂದ್ರೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಬೇಡಿ ಅಂತ. ಸೊ ನನ್ನ ಪಂಚಾಯತಿ ಕಟ್ತಾ ಇದೀನಲ್ಲಿ, ಪಂಚಾಯತಿ ಕಟ್ತಕ್ಕಂಥ ಪ್ರಾಪರ್ಟಿನ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಬೇಡಿ ಅಂತ ಇದ್ರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರೆ. ಸೊ ದರ್ ಇಸ್ ನೋ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್, ಅದಕ್ಕೂ ಸಂಬಂಧನೇ ಇಲ್ಲ.
ಎಂಡೋರ್ಸ್ಮೆಂಟ್
ಅನಕ್ಷರಿ ಇವ್ರು ಬ್ರದರ್ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಕೊಡ್ತಾರೆ ಖಾತೆ ಮಾಡಬೇಡಿ ಅಂತ. ದಟ್ ಇಸ್ ದ ರೀಸನ್ ವಿ ಇಶ್ಯೂ ದ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಮಾಸ್ಟರ್.
ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಏನಿದು? ವಾಟ್ ಇಸ್ ದ ಡೀಟೇಲ್ಸ್ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ? ಅದೇ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ನೀವು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇವ್ರು ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ನಿಮ್ಮ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ?
ಹೌದು ಸರ್. ನೋ, kindly see my objection today. Now the file the objection.
So that will answer. Nim survey number ಏನು?
Probably has not mentioned that. Not mentioned.
My number mention ಮಾಡಿಲ್ಲ. ನನಗೆ
ಹೇಳ್ಬೇಕಲ್ಲ ನಿಮ್ ಸರ್ವೆ ನಂಬರ್ ಏನು ಅಂತ.
ಅವರ ಫ್ಯಾಮಿಲಿ ಅವರೇ ಹಿಂದೆ ನನಗೆ ಪ್ರಾಪರ್ಟಿನ ಗಿಫ್ಟೆಡ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ರಿಜಿಸ್ಟರ್ಡ್ ಗಿಫ್ಟೆಡ್.
ಅವರೇ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ.
ಅವ್ರ ಫ್ಯಾಮಿಲಿ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ. ಸೊ ಅವ್ರು ಏನು ಒಂದೇ ಜಿದ್ದೋಲ್ಲ, ನನಗೆ ಖಾತೆ ಮಾಡ್ಕೊಡ್ಲಿಲ್ವಾ ನಿಮ್ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಕ್ ಬಿಡೋದಿಲ್ಲ ಅಂತ ಅವಾಯ್ಡ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. So ಇದು ಗೌರ್ಮೆಂಟ್ ಬಿಲ್ಡಿಂಗ್ ನಾನು ಕಟ್ಟೋದಕ್ಕೆ ನನಗೆ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ತಗೊಂಡಿದ್ದೀನಿ.
ನಿಮ್ಮ ಖಾತಾ ಯಾವ್ದಕ್ಕೆ ಯಾವ ಪ್ರಾಪರ್ಟಿಗೆ ಬೇಕಾಗಿರೋದು?
It is in this, as per the sale deed, my lord, that property was obtained by the father of the petitioner, my lord. In this regard, judgment of the municipal court can be seen, my lord. It is remained unchallenged, my lord.
No, Mr. Rajaram, first you tell us what is the property details. You have not mentioned the property details anywhere.
All right, my lord.
We don't see the property details in your petition.
It may be taken on Monday, my
Refusing to
lord.
change khata, I applied for khata. Which property?
It may be taken on Monday, my lord. I will give you the complete details, my lord.
So you give us the property details.
Please, my lord.
ಅದ್ರಲ್ಲಿ ಏನು ಡಿಗ್ರಿ ಎಲ್ಲಾದ್ರೂ ಇದೆಯಾ ಪ್ರಾಪರ್ಟಿ ಡೀಟೇಲ್ಸ್?
ಇದೆ ಸ್ವಾಮಿ. That is annexure, my lord. Annexure G, my lord.
Page
55 to 69, my lord.
Yes. So where are the property details? Injunction suit. Schedule is suit schedule on Makavalli, Kikkerli, Mandal Panchayat, KRP Taluk, in survey number ಏನು ಇಲ್ವಲ್ಲ? How do you identify this property?
No, my lord. I make submissions in this regard on Monday, my lord. Give you the detail.
Counsel for respondent has filed a statement of objection. The same is taken on record. Copy thereof and been furnished to the counsel for the petitioner. He seeks for 2 days time to make his submission. Relist on 9th.
Much obliged.
19, Archana Murthy.
Agreeable.
Not at all ready.
That is why we asked you. Somehow there was some doubt about it.
There is deviation, my lords. Because of that, there is deviation, my lords. So they are not at all ready.
Somehow we had a doubt. We would have just accepted your submission. Argue the matter and whatever happens, happens.
Please, ma'am.
So when will you get ready?
I'll file my objections, Your Lordship.
When will you file it?
5 days time may be granted, Your Lordship. 5 days time may be granted, Your Lordship.
Counsel for respond number 4 and 5 seeks for and is granted 10 days time to file a statement of objection. Objections, if any, by 18th, relist on 24th.
Please, Lordship.
21, Justice Vivekananda.
So the petitioner is in this case, my lord. Lord, the matter pertains to sale and proclamation notice. Lordship had directed us to file an application for stay. May be permitted to file that, my lord. One respectful submission, my lord.
Yes.
Even on the last occasion when a recall order, when an order was directing them to recall the order, attachment order, they have not initiated any steps. And now the result is of that is this proclamation notice, my lord. Let there be a direction for them to initiate immediate steps. Let them hold some accountability, my lord.
IA 1 of 26 has been filed seeking for stay of the operation of proclamation and sale notice dated 3/2/26. It is rather shocking that a proclamation notice has been issued when a coordinate bench of this court, by order dated 22nd September 25, had directed the respondents not to precipitate the matter against the petitioner pursuant to the impugned remand notices. Subsequently, the petitioner having been issued some certain short messaging service, bracket SMS, having been sent to the petitioner had once again approached this court when this court had categorically directed the respondent not to take any steps in person of the said SMS, indicating that attachment order would be passed. Now, for the third time, there is a notice sent to the petitioner as regards auction proposed to be made of the property of the petitioner on account of non-payment of property tax, arrears of property tax. When the proceedings have been stayed by this court and respondents have been directed not to take any coercive steps, it is rather shocking, as observed above, it is rather shocking that firstly, an attachment notice and now a sale notice has been issued by the respondent. The counsel for respondent number 1 to 3 submit that these messages are sent by the software
I took
and
instructions.
without any human intervention. Even if a software is, though it is essential for software to be implemented to cater to the administrative exigencies and requirements of the BBMP, it is also required that the software be designed and implemented in a proper manner to cater to all the requirements. One of them being the requirement to adhere to the orders passed by this court. The software cannot be made in such a manner as to not take into account the orders passed by this court and the defense be available to the respondent corporation that the software is automatically sending such messages. And the chief commissioner, GBA, is directed to look, we are using the word directed this time, not request, directed to look into it and come up with a solution for these kind of issues and to incorporate a specific module in the said software to cater to orders passed by courts of law, injuncting, staying, or directing that no action to be taken by the respondents pending consideration of those proceedings, so that once such an order is input into the said software, the software does not generate any such attachment orders or sale notifications. The affidavit to be filed within 10 days from today, relist on 24th February.
One more submission, my lord. Let the registry be directed to release today's order, certified copy of it immediately, my lord, in view of.
Madam,
the
it is
urgency.
4:40 now. We have informed
Or
them.
tomorrow, my lord.
So it won't be released today. The file itself won't go to the copying branch today.
Not at least
The
tomorrow in view of
operation
the
of
extreme urgency.
the proclamation and sale notice dated 3/2/26 is stayed till the next date of hearing.
I have asked the officer also, my lords. They are not
Ask
doing
them.
anything.
If you do anything, then
No, nothing, my lords. I have asked them. It's a computer generated.
not computer generated. We'll generate something. If something more you do now.
No.
Greatly
I have
obliged.
instructed them.
Yes.
37. Kodia, connected matter.
Yes. Illappa. Password.
List number 2, serial number 34. Kevin Narasimhan.
In this matter, my lord, on the last date of hearing, BBMP was directed to next spot inspection. Have not conducted, my lord.
So Vaibhav? Ilva. Login ಆಗಿಲ್ಲ. Password.
35.
My lord, I can respond 2 to 3.
Your Honor,
From Monday, my lord, because
last date was the
No, no.
final date for them, Your Honor.
There is no judgment.
answering counsel is not feeling well, my lord. It's Monday.
You are trying to interpret the same judgment 20 times. Every time we have rejected it.
On last
No permission to do that. Kodi. Petitioner. He is before this court seeking for the following reliefs. By way of the impugned annexures A and B, the respondent have called upon the petitioner to make payment of the ground rental.
Relinquishment.
Ground rental.
It's relinquishment deed.
Surrender the free of cost, Your Honor.
That is another one. The petitioner claims to be the absolute owner of vacant site bearing number 2, BBMPP EPID bearing number so and so, Doddakanalli village, Vartur Hobbli, Bangalore East Taluk. Having purchased the same on a registered sale deed dated 4/6/2025, subsequent to which the e-Khata has been issued and registered in his name. The petitioner intending to put up a construction of a commercial IT, BT and BPO building along with residential building had filed an application before respondent number 2 for sanction of a building plan when the respondent had called upon the petitioner to relinquish stroke surrender a portion of his property for the purpose of widening of the road as shown in the revised master plan, namely RMP 2015, free of cost. It is in that background that the petitioner is before this court seeking for the aforesaid relief. Learned counsel for the petitioner has contended that the issue as regard relinquishment for widening of a road situated outside the property of the petitioner has been considered by several coordinate benches of this court, some of them being order dated 17 January 2022 and WP number 9408 of 2020. Onde kottidira?
Annexure G, Your Honor, 43 page 1.
Only one you are given,
Yes, Your Honor. In that multiple cases.
including so and so. He refers to para 26 thereof, which is reproduced hereunder for easy reference. Relying on Dr. Arun Kumar's case, his submission is that the BBMP cannot call upon the petitioner, the owner of a property, to relinquish any property free of cost as a condition precedent for processing the application for sanctioning of plan. And on that basis, submit that the relief sought for are to be granted. Shri Pradeep, learned counsel for respondent number 2 and 3. Shri KV Manish Kumar, learned counsel for respondent number 2 and 3, had on 2 earlier occasions sought for time to produce a judgment said to be allowing respondent number 2 to relinquish, to call upon the landowner to relinquish. Despite adequate opportunity having been granted, no such judgment has been placed on record. Right, our level. The reason cannot be far to see, inasmuch as there is a catena of judgments of this court, which have held that the respondent authorities cannot seek for relinquishment of land for the purpose of formation or widening of a road which is situated outside the property of the petitioner. The matter is different if a layout is being sought for sanction and under section 72A of the KTCP Act. That land which is within the said layout being sanctioned by the authorities would have to be relinquished free of cost. That principle would not apply to a road situated outside the property of the petitioner who has sought for the plan sanction, and in this case, it being a single plot plan sanction, which does not require any surrender of roads. Of course, the petitioner would have to comply with all other requirements of the building bylaws and the zonal regulations for the plan to be considered by the respondents. In that view of the matter, I pass the following order. Writ petition is allowed. The certiorari is issued. Annexure A, Annexure B are quashed. Respondents are directed to consider the application of the petitioner in terms of directions issued by this court in the present matter, and that in WP number 9408 of 2020, and pass necessary orders within a period of 60 days from the date of receipt of a copy of this order.
Connected matter is there, 2287.
Yaudama connected matter?
2287. Next matter.
35.
Yes, ma'am.
35.1, sorry. 35.1 ಏನಿದು? You are the owner in site bearing number 3, BBMP EPID number 1611009007 para 2. So on, same order.
Yes, that's the previous case, my lords, 34, my lords, I apologize. But
what happened? Inspection done?
My lords, there was some family emergency with respect to the AE. We'll do it on Tuesday, my lords, and Wednesday I'll submit the report.
And counsel for respondent number 1 to 5 submits that due to some family emergency of the assistant executive engineer, the inspection could not be carried out as directed by the order dated 27/1/26. He submits that the inspection will be carried out commencing from 10:30 a.m. on 10th February 2026, and the report be submitted within 3 days thereafter. Hence relist on 19th February.
Highly grateful, my lords, highly grateful.
Serial number 36.
I'm for petitioner in this case.
Lots. I filed my wakalat yesterday. I have seen the order of 22/1/2026 of this honorable court order, my lords. Lords request. Yesterday I filed my wakalat. I have spoken. Yesterday I filed my wakalat.
There are two directions. We had directed
Yes,
Mr.
I have
Pawan
seen
Kumar.
the, please, my lords. Yesterday I filed my wakalat.
That won't be available for you.
Please, my lords. Otherwise, normally I wouldn't shed away my responsibility, my lords. I'll file it.
Respondent number 5 and 6, still they are doing the interior work.
Today,
Yes,
my instructions, today morning, one of the engineer has went to the spot and he has sent me the photographs also, but they said there is nothing work is going on. Inside, my lords, somebody is
You
there.
file your affidavit.
Please, my lords, I'll do that.
Sinchana MR has entered
Directly
appearance for
respondent
respondent number 1 to 4.
seal the property.
Delete the name of Shri Pawan Kumar as that appearing for respondent number 1 to 4. She seeks for and is granted a week's time to comply with the order dated 22/1/2026. Learned counsel for the petitioner submit that despite the interim orders passed by this court, construction work is still going on. Construction activities are still going on in the property. Ms. Sinchana MR submits that she has been instructed that all construction activities have stopped. Be that as it may, in the event of construction activities still going on, respondent number 1 to 4 are directed to ensure that no further construction is going on, and if no construction activities go on, and if any such activities still go on, to seal the premises.
But today my.
Relist on 19th.
Kindly extend the interim order.
Interim order earlier granted is extended till.
But they said some two people are very inside the house. For them, we can't say to come out.
ಅದಕ್ಕೆ seal ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು.
ಇದ್ದಾರೆ, but lock ಆಗಿದ್ರು ಇಲ್ವೋ ಏನ್ ಗೊತ್ತಿಲ್ಲ.
You lock it so that they don't go in.
Please.
This is a problem. Then after that, if we direct demolition, they'll come and say we have invested 50 lakh of rupees, 75 lakh of rupees. They'll invest. They are being advised by whom we don't know.
Extra.
They'll keep on doing it. And your office is also supported. I mean, demolition admil illi they will be, it's a waste of money, alva.
Please, I advise.
Next date. 19th. Oh, bless.
List number 1. Admission serial number 1. NR Jagdishwara.
Serial number 37 only members are there.
Yes, when we call.
I am for the petitioner, my lord.
Yes.
Annexure A is the order, my lord, where the respondent has filed a petition seeking a direction to the corporation for issuance of TDR. Annexure A, my lord, page number 15, the order which has passed by the court.
Notice agideye. Who had appeared for them earlier?
I appeared at the preliminary stage, my lord, the petition was disposed of. Subsequently, when we are.
Point number 1, there's a council, alva.
Respondent 1 is a.
Council is there. Take a notice on that council.
Sanjay Nair.
Counsel for the petitioner is permit take out
Yes,
notice on the
the notice
counsel.
has been ordered, it has been served on them.
ಆಯ್ತು counsel ಇದಾರಲ್ಲ ಅವ್ರನ್ನ ತಗೊಳ್ಳಿ. It's a review petition. We'll have to give them an opportunity. The counsel for the petitioner is permit take out notice on the counsel for respondent who had appeared for respondent number 1 and file his acknowledgement thereof. Released on 23rd February.
Please.
Serial number 4. GG Shastri.
Okay, for the petitioner in this matter, my lord. Before this honorable court challenging lecture A, my lord.
ತಗೊಂಡ್ಬಿಡಿ ಇದು ತಗೊಂಡಿಲ್ವಲ್ಲ ಪಾಸ್ ಓವರ್ ಇತ್ತಲ್ಲ ಇನ್ನೊಂದು ಅದೇನಾ 37 ಏನ ಅದು ತಗೊಂಡ್ಬಿಡಿ ಅದು ಮುಗಿಸ್ಬಿಡೋಣ. Is Mr. Jaykumar Patil come? Yes, please call him. We won't be taking up this. That's a parted matter. We'll continue with that matter.
Very good. Date may be fixed. Short question
All
is
the
about
dates. Yeah, the
site
date-
is below 500 square feet, my lord.
All matters in list 1 which have not reached will be relisted on
26th February.
26th. 56 relist on Monday. 50 relist on Monday.
My lord, this list 1 serial number 4, my lord. Interim order may kindly be extended.
All interim orders will be extended.
Very well. Grateful.
Inconvenience. Let it be taken up.
20, ಯಾವ್ದು serial number?
16 in the first list,
16 in the first list, 25th ಮಾಡಿ.
25th and 26th.
Oh, the 24th ಮಾಡಿ.
Please.
Lord, serial number 3, my lord, serial number 3. Lord said, I thought Lord said not adjourned it in the morning.
ಯಾವ್ದು?
Serial number 3.
Actually, that we are confused. This one was in the RFA matter, not in this.
This is not this matter.
Because we had noted that there is a direction matter today.
This is not a direction.
Not this.
Serial number 18. Can I request?
26th.
Serial number
9th.
17. Can I request on 17? Subject to Lord's.
Serial number 18.
9th February.
Serial number 9th, Lord. I'll have to be in Delhi.
26th February.
Serial number 18.
25th.
One ನಿಮಿಷ.
Sorry.
Yes.
Serial
ಒಂದು
number
ನಿಮಿಷ
18.
ಇರು.
Lord. Serial number 18.
ಏನು?
Short date maybe.
26th, short date.
Senior
Yes,
will
madam.
address that.
It's urgent, your lord.
Yes.
Number 32, it's a writ of mandamus, my lord, just to consider my representation.
We'll consider it on 26th.
Serial number 47, because the demand notice, my lords, once issued is already stayed. However, they issued, my lords, the same demand notice.
Same
now.
tax ದಲ್ಲ?
Ground rent. my lords.
Ground rent.
Ground rent.
Serial number?
47, lords.
47.
Serial number 45, my lords.
Did we ask you anything? Why are you interrupting a counsel when he is submitting?
47.
47 released on Monday.
44, my lords. It may be fixed. There's an interim order.
26th.
Much of it.
Yes.
45.
ಏನು?
So after 26.
After 26th. Yes.
Serial number 7. After the report that the person has died, it's expired. And also made inquiry with the local council. He said that it's true that person has expired, but particulars of legal debts not available. Therefore, I am filing a memo to treat as abetted if the elapse of.
Serial number 7. The sole petitioner having expired, no application has been filed to bring the legal representatives on record. Hence, the petition is dismissed as abated. Memo filed by the counsel for the petitioner is taken up. ಬಂದಾಗ application ಹಾಕಿ.
Your lordship, sorry, serial number 19. my
Just a moment, please.
lord. Sorry, 26 ಬದಲು 5th ಆಗ್ಬೋದು.
25th, serial number 3, 25th.
Great.
Serial number 48, there is some urgency in the matter. There
What is the
notice
urgency?
to demolish the existing building. Already there is a sanction.
48 Monday.
My lord, serial number 46, my lord, we appear for respondent corporation, my lord. Notice is ordered against Pallava for R3.
46.
My lordship, we are the counsel for NCP Mysore City Corporation. The
We-
petition is pertaining to Mangalore City Corporation. We are wrongly being served.
46.
Pallava
Registry direct print the name of Shri KV Narasimhan as that appearing for respond number 3 and delete the name of Shri Pallava R as that appearing for respond number 3. Released on 26th. Huh? 26th. Yeah, 45. Non-filing of papers regarding settlement, contempt action and no. There's various applications. We'll have it on that day.
My lord,
Yes, madam.
list number 1, serial number 4, interim order may be kindly.
All interim orders will be extended.
Thank you.
Madam, serial number 19, madam, early date, madam, because he is having 80 years age.
ಏನು issue ಏನು?
ಏನಿಲ್ಲ ನಮ್ ಇವ್ರದ್ದು the side property belongs to his grandfather, ancestral property that was been mutated without any documents by the
19 relist Monday.
Monday.
Yes.
Serial number 19, madam.
Yes. 9.
19, madam.
19.
ಅದೇ 19 ಅಂದ್ರೆ
Madam.
19 relist Monday.
My lord, serial number 17, 25 date. 25.
26th ಮಾಡಿದೀವಿ.
26 ಬೇರೆ ಕಡೆ ಇನ್ನೊಂದು ಇದೆ. ಬೇರೆ ಕಡೆ ಇನ್ನೊಂದು ಇದೆ.
ಯಾವ್ದು ಸೇಲ್ ನಂಬರ್ ಏನು?
17.
17, 25th.
25th.
Yes. ಕೊಡಿ.
List 2, serial number 37.
May I mention serial number 34 in list 1? It's a BBMP matter. And what's happened in that is my neighbor has put up 3 floors construction in violation of. My lord?
3 is permissible.
It's a small, it's less than 50 square feet side.
50 square meters.
Square meters, sorry. And my lord's own.
Feet alla.
My apology. My lord's own order states that a plan is required for such small properties.
Yes.
In violation of the plan, and the problem is it's been built on a compound wall that's almost crumbling. And when my client is an elderly person who lives in the adjoining building. There's some urgency in the matter.
34 Monday.
Deeply obliged.
Yes.
Number 42 in the first list.
ಹೇಳಿ.
Short date.
ಏನು ಅರ್ಜೆನ್ಸಿ ಏನಾದ್ರು ಇದ್ರೆ ಹೇಳಿ, ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡ್ತೀವಿ.
Urgent, my lord, we have not got the release order. It's the planning of the year 2000.
ಬರುತ್ತೆ ಮಿಸ್ಟರ್ ವಿಶ್ವನಾಥ್, 26th ಬರುತ್ತೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 34 ಅದು 500 meters ಒಳಗಡೆ ಐತೆ, ಚಿಕ್ಕ ಸೈಟ್
50 meters. 600 square feet.
ಅವ್ರು ಏನ್ ಮಾಡ್ತಿದ್ರು, ಪಕ್ಕದ ಮನೆ ಓನರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಬಿಟ್ಟು ಈಗ
34 ಇವಾಗ ಅವರೇ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ ಮಂಡೇ.
34 ಪ್ಲೀಸ್
ಮಂಡೇ
ಪ್ಲೀಸ್ ಮೇಡಮ್.
ಅವ್ರು 34 ಅಂತ ಹೇಳಿದಾಗ
ಪ್ಲೀಸ್ ಮೇಡಮ್
ಕೊಡಿ.
ಆಯ್ತು.
ಎಸ್ ಮಿಸ್ಟರ್ ಪಾಟೀಲ್. Mr. Rao doesn't want to go to, doesn't want to wait for KMF to decide. This KMF is asking for 2 to 3 weeks.
Of course, my lord, not that I am a spokesperson for that, but my information is next week they are holding the chairman office bearer election. Of course, I'm not saying on that ground it should
Understand
be.
is you have to continue with working with them. We can't tell you anything. We are not in advisory jurisdictions. Yes, he is opposing that. You can go ahead. Anyway, the order won't be passed before that date.
Very grateful to your lordships for hearing us today, my lords, and we would very grateful to your lordships for hearing us today, my lords, and we would not have bothered the court if this was not urgent at our end. In fact, my lord, this is a company which is rapidly going down, and I'll explain why. And of course, my lords, I'll make my legal submissions. My lords, we've invested 30 crores, out of which, my lords, around 14 crores was by means of a loan taken from the bank, which we were hoping, my lords, to pay back out of the revenue that we earn from this contract. And of course, none of this is on record. So, my lords, I'm not really basing my legal submissions on this, but I'm only indicating, my lords, the reasons for the urgency. And now, my lords, we're on the verge of being declared an NPA by the bank because, my lords, there's virtually no revenue. My lords, because this contract was supposed to be operationalized from last year. We've not been able to make a paisa in revenue from this contract.
That is why it's better that you tell KMF about that and get some work. If you are not willing to listen to them and not go before them, do you think they'll give you any work?
So my instructions are, my lords, to argue the matter on merits because they've done whatever they could.
Yes. Practically, if you look at it, you won't get the order before their expiry of their term.
So therefore, my lords, one submission that I would make at the end, my lords, of course, subject
Then
to.
it becomes academic.
it may not, my lords, and I'll explain why, my lords. If I'm able to convince your lordship, and if your lordship is able to, my lords, modify the interim order to enable me to produce and to market in Warangal, not in Hyderabad.
And modify, we are hearing you on main.
Yes.
There's no modification. When
Or-
they are opposing it, if they consent to it, yes. Now we have to, if we have to decide, it has to be either
Or
way.
if the interim order is not extended, my lord.
Can it not be extended?
Well, if I'm able to show your lordships, my lords, prima facie that there is no case. In any case, my lords, I'll take
Once
10
we have
minutes.
started hearing, can we do that? We'll have to hear you and pass orders. It could be either ways, we don't know.
Yes.
That's a different thing. Because you still have to make your submission. We
Yes,
have heard Mr. Patil on it. You have to make your submission, you could make it. But practically it won't, the judgment won't come out before the expiry of the term.
My instructions are, my lords, to argue on merits.
Yes.
I'll-
At least next week, if you go, in the interest of your client, what we are thinking was next week, if you go before
My
them,
instructions are,
they
my lords,
may
nothing
give you
will-
something.
My
Fair
lords,
enough,
because
your
these
choice.
are ultimately, my lords, there are other considerations at play.
Yes.
My lords, the issue has really been caused by virtue of Karnataka being a milk surplus state. So, my lords, and that's a good problem to
Good
have.
fortune.
Good problem to have. My lords, so therefore my lords, and that's a matter of pride for the state that we, my lords, export milk and milk products to other states also. And the brand Nandini probably, my lords, after Amul and after Mother Dairy probably has the highest intellectual property value for that brand
Brand
name,
recall is there.
Nandini. Which is why, my lords, it's a much sought after brand. My lords, people across the country, my lords, buy to be distributors of Amul. My lords, as far as how this actually is organized and how it is sold, my lords, there is of course the federation. And the federation, my lords, I'm told has around 19 units in the state of Karnataka. And my lords, the units have territorial limits where, my lords, they collect milk, they process milk, they manufacture milk products, and they supply milk products. But as far as operations outside the state of Karnataka are concerned, my lords, all that, my lords, is within the exclusive domain of the federation, which is based in Bangalore, which is, my lords, respondent number 2 in one of the writ petitions. So, my lords, this is the mother unit, the Bangalore headquarters, my lords, which has the exclusive power to distribute milk and milk products outside the state of Karnataka. And my lords, I'll show your lordships the bylaws which make that clear. So, any activity that any unit takes outside the state is done as an agent or as a delegate of the headquarters, which is, my lords, KMF Bangalore. So therefore, my lords, the issue is very simple. The principle has clarified in no uncertain terms, and this is the reason, my lords, why I made the submission that, my lords, whatever they may do in order to settle the dispute at a larger global level, as a matter of law, they are very clear. The principle has made it clear in no uncertain terms that as far as we are concerned, my lords, the petitioners in the two writ petitions are given rights only insofar as Hyderabad is concerned, not extending to other parts of the state of Telangana. And that position, my lords, is clear. It has been taken in pleadings. There is no uncertainty.
Page.
My lord, in the co-packing writ petition, my lords, the two writ petitions, my lords, one is
CP
22850, which is co-packing,
22850.
and 23487 is market.
Which one do you want us to?
I'll show both, my lords. In both, they've taken the position in both. My lords, in 22850, if I could show your lordships, respondent number 2 is KMF.
Yes.
And my lords, in the statement of objections, if I may invite your lordship's attention to paragraph 7.
Filed by?
Filed by KMF, the headquarters.
Sumant, you have filed. Yes.
In paragraph 7, my lords, I'll just read 7 and 8. That apart, I'm so sorry, my lord has paragraph 7,
Yes.
my lord. That apart, there is no nexus between the tender awarded to petitioner by the respondent number 3 and to the tender awarded to respondent number 4 by this respondent number 2. The tender awarded to the petitioner by respondent number 3 is pertaining to Hyderabad only, and the tender awarded to the respondent number 4 by this respondent number 2 is pertaining to an altogether different, that is Warangal district. Thus, the petitioner, even on this score, fails to maintain this petition. By the above said arrangements, the only fact remains is that neither the petitioner nor the respondent number 4 could disturb the business of each other, and they both have to exercise their tender work strictly with respect to regions allocated to them. Thus, in the above said facts and circumstances, the petitioner cannot seek monopoly of business having got tender only with respect to Hyderabad, and particularly in view of the fact that he failed to participate in the impugned tender proceedings. Well, this aspect I will come on to. But the same position is taken by KMF headquarters in the other writ petition also, which is WP 23-487.
Yes.
Well, it's paragraph 6 may kindly be seen. Thus, the above said order clearly reveals the fact that the respondent number 4 was entrusted the business at Hyderabad market only and none else.
What is the above said order? Para 5.
Well, that's paragraph 5.
Yes.
Thus, the said clause number 3 enables respondent number 2 to modify or alter, add or delete areas of operations of business of the petitioner to suit the market requirement. It is submitted further that the business of Nandini Milk and Curds at Hyderabad was carrying out from the mother dairy. In turn, mother dairy was required to procure milk and curd from other unions. Thus, in the circumstances, in order to ensure smooth and flawless functioning of business, this respondent number 2, deliberating the issues with consent, passed an order dated so and so, transferring the business at Hyderabad market in favor of respondent number 4, which is Hassan Milk Union. It was also resolved to transfer the agreement between petitioner and this respondent in favor of respondent number 4. Thus, the above said order clearly reveals the fact that respondent number 4 was entrusted the business at Hyderabad market only and none else. In view of the above facts and events, the petitioner herein being a WC and FA that is warehousing, clearing and forwarding agent, is entitled to function in Hyderabad market only and none else. Since 28/9/2016, that is the date of passing of the order at Annexure B. The above said decisions had been taken by the respondent number 2, keeping in mind the exigencies and scope of its business. Since it was a policy decision, petitioner cannot question the same that too at this length of time. And then, my lords, paragraph 7 may also kindly be seen. That apart, the petitioner deliberately failed to challenge the said order passed by the respondent number 2 and so, and further communications exchanged between the parties, which would certainly clear the fact the petitioner is entitled to operate only in Hyderabad market and nowhere else. Even this respondent number 2, with the order dated so and so, transferred its business of marketing Nandini Milk and Curds in favor of respondent number 4 only in respect of Hyderabad market and nothing else. My lords, then paragraphs 9 and 10. It is pertinent to note that the impugned communication therefore clearly excludes the market of Hyderabad, which is already under the control of respondent number 4 and the petitioner herein. Thus, the above said communication clearly avoids any overclash or encroachments of market, which is already under the control of respondent number 4 and petitioner herein. Thus, in these circumstances, the impugned communication dated 7/8/2024, which is a policy decision that taken by this respondent number 2, and that too in terms of Annexure B only, neither the petitioner nor any other person for that matter can question the same just to suit their convenience. That apart, there is no nexus between the tender awarded to petitioner and the communication impugned herein. The tender awarded to the petitioner is pertaining to Hyderabad market only, and the impugned communication is pertaining to altogether different districts, that is Warangal, Adilabad, Nizamabad, Karimnagar state. Thus, the petitioner, even on this score, fails to maintain this petition. Paragraph 11, my lord. Thus, in the above said facts and circumstances, the petitioner cannot seek monopoly of business in the entire state of Telangana, having got tender only with respect to Hyderabad market, and particularly in view of the fact that he failed to challenge the order dated 2016. It is pertinent, and that, my lords, I will not read it. It refers to the fact that, my lords,
only they're defending their order.
Yes, my lord. But, my lords, what is clear from this order is, my lords, the sheet anchor of submissions of the petitioner in both cases is these two terms are synonymous. Hyderabad market.
That is what we'll be interpreting. This doesn't further your case any, because they're only supporting this one. Now they have a dispute at the undisputed point of time. There's no dispute between Hassan and KMF. Now there's a dispute. They've issued this. So obviously they'll take this time.
That's correct.
So the conduct during 2015 till 2021 as to what happened has to be seen. This by itself will not be.
Could I just invite your lordship's attention to one more document, Mulaz, and then I'll just make this.
You'll have to explain the use of Telangana
yes.
in all those documents.
Yes. Will you kindly see, my lords, the objections filed by R3
Hmm.
in
which matter?
WP, my lords, 22850.
R3. R3, who is appearing for R3?
R3 is KMF Hassan.
Yes.
Let's, all that I wanted to point out, my lord, is they have produced.
22850, objection of R3.
Yes, my lords, they produced the bylaws. I'm so sorry, my lord. This is not in 22850, it is in 23487. I'm so sorry.
In 23,487, it would be respondent 4. Hassan would be respondent 4.
Sir, ಇದು R3 ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
R3 is Bellary.
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 R3 is Bellary.
R4 has filed objection in that?
R3, my lord, in 23487.
R3.
To be filed on 28th of March 2025.
28th March 25.
Yes.
R4 is not R3, Hassan, right?
Lord Bellary, my lord. Bellary.
Bellary, you want Bellary. Bellary, who is the council appearing for? Nothing is written there. Who is the council appearing for Bellary?
I'm appearing for Bellary.
What's your name?
Santosh, my lord.
Santosh?
Muttalli.
Santosh Muttalli is?
I'm on the Wakalat, my lord.
R4.
R3 in 23487.
Now, who's this one do you want us to see, Pramod?
My lords, this is R3's statement of objections, my lord, in 23487.
And that is what R3 is.
That is the
Hassan.
Bellary Milton.
In 23.
No, R3, R4 in 23487
is Hassan.
R4 is
Hassan. R3 is Shyam Prasad.
He's one of the other.
See, whose name will it be here?
My lord is right. I think it says Shyam Prasad. My lords, the only document I wanted to point out in this, my lords, is
Just yeah, Shyam Prasad, 3425. There's no index, nothing has been written. There's no signature also. Yes.
my lord, they have produced, my lords, the bylaws of KMF.
Yes.
Immediately after the affidavit, my lords. If I can just invite your lordship's attention to just 3 or 4 clauses of the bylaws. Lords, there is a definition of milk union in clause 3.22.
Page, you have to
This
give
is
us a
page
page.
number, my lords, I think. It is page 28, my lord.
28. Yes, 28.
Possibly if one of my friends have a cleaner copy, my lords,
Do you want a specific clause?
clause 3.22, my lord. Member or member district milk union means a district cooperative milk producers society union registered or deemed to have been registered in the provisions of the act and the rules which has contributed towards so and so. So therefore, my lords, this is the union. Then, my lords, 4.9 at page.
Just one. Yes.
Let's page
What is this
34.
definition? Why do you want us to see this?
Well, all the others are unions, my lord, and the federation is different. The powers that are reserved for the federation, your lordships will find at page 34, clause 4.9. In particular and without prejudice to the generality of the foregoing objects, the federation may. So, my lords, these are all powers of the federation. And what is specifically relevant, my lord, is 4.9.15.
Which clause are you reading?
4.9, my lord. 4.9 at page 34.
Yes.
At page 34, my lords. These are the powers of the federation. And the specific, my lords, power which I'm referring to, my lords, is 4.9.15 at page 37, my lord.
Yes.
To undertake export, import, and marketing of milk and milk products to or from other states and abroad, or as an organization thereof, for and on behalf of member milk unions, to facilitate import, export, and market of milk and milk products, shall purchase suitable land, etc., and create infrastructure, or to own on lease, or to make arrangements for co-packing in other states and abroad. So, my lords, this is a power that is conferred on KMF Bangalore. Then, my lords, clause 6 at page 51.
Yes.
These are not powers, Malan. These are duties of a milk union. Clause 6. And the relevant one, my lords, will be 6.3.2 at page 57, my lord. 6.3.2, my lords, at page 57.
Yes.
A member milk union shall plan for the. I'm so sorry.
57, we are 6.3.2. Yes.
A member milk union shall plan for the procurement of milk, raw material, and packing materials, and also plan for the processing, manufacture, and marketing of all its dairy and allied products as per the directions of the federation. However, the marketing of milk and milk products outside the jurisdiction of the milk union shall be undertaken only through the federation. That's the point of reading out these clauses was, my lords, to show that as far as operations outside the state is concerned, that is within the exclusive preserve of the federation, which is based in Bangalore, the headquarters. And whatever is done by the member unions outside is done purely as an agent or as a delegate of the parent union. And the reason, my lords, of reading out in the pleadings of KMF was to show, my lord, as far as KMF is concerned, they were very clear that, my lords, what was entrusted to Hassan was only Hyderabad operations, not operations in Adilabad, Warangal, Karimnagar, Khammam district, etc. This is the position that they have taken. So, my lords, ultimately, my lords, if that is what the principle says.
That is the position they have taken after the dispute has arisen, not prior to that. Prior to that, all the documents have Telangana. Only one of them has Hyderabad. There's a dispute between Hassan and KMF now.
Yes.
So if there's the bylaws being so doesn't mean that there cannot be a dispute, or KMF can ride roughshod or whatever. There's always a possibility of a dispute.
Of course.
There's a dispute now.
Yes.
What uses all these clauses?
The issue is this, Manoj. Therefore, Manoj, as far as the principles, Manoj, two or three positions flow from this. Firstly, Manoj, an agent, which is the milk union, Manoj, who will have to act as per the directions of the union, cannot have powers greater than that is conferred by the principal.
Mr. Pramod, we are not deciding the dispute between Hassan and KMF for you to be referring to this.
Manoj, the issue is, Manoj, these are rights that inhere in the federation. It is passed on to the by the union.
Expand the scope of this writ petition. The scope of this writ petition is only to consider the documents which have been executed by so and so.
Yes.
Those have not been challenged or those have not been cancelled. Those exist as they are.
I'll take your lordships to those documents also, Manoj. Manoj, the point that I was making is that
KMF has not cancelled it. Hassan has not cancelled it. There is no action taken in respect thereto. Only thing that it's a very short issue. Only thing that we have to determine is whether usage of Telangana in some places and Hyderabad in some places would make it Telangana or restricted to Hyderabad. And insofar as that is concerned, as even in one place, if Telangana is used, it will be Telangana. You can't restrict it later. Is the argument of Mr.
That's the argument. Also, I'll make that argument in these ways. Firstly, there's clearly a distinction between Telangana and Hyderabad. Telangana is a state, Hyderabad is a city, and it's made clear, Hyderabad, and it has been used right from the beginning. So, the argument was this is all at a time when everything was very nascent, there was confusion, etc. The very first document clearly shows, that there was no confusion at all. I'll take you lordship through those documents. That is one. The second, is that even when that was done, the contracts, and I'll take your lordship through the language of the contracts themselves say that this is the territory that is entrusted to you, but we always have the right to modify, etc., etc. The third aspect, and this is the reason why, I'm coming to this aspect about how the rights have actually flown, because, the entering into of a contract is done pursuant to an executive power. So therefore, the power exists with the federation. It is delegated to the delegate, which is the union, and then further delegated to the sub-delegate, which is the petitioner before your lordships. So ultimately, whatever right that they have cannot exceed the powers that have been delegated by the principal to its first agent. The sub-delegate cannot say, I actually have more powers than what the principal has given to its own delegate. So therefore, if the principal is before your lordship today and is saying that we were very clear that what we were giving is only rights for Hyderabad, which is probably the biggest market in the state of Telangana, because 70% of the supplies go to Hyderabad, but the rest of the state probably make up 30%. I'm sure the same will be true of Bangalore as well. So when they say Hyderabad market, they were very clear that we clearly used it to mean only Hyderabad and probably its neighboring areas. It clearly did not include Warangal district, which is 700 kilometers away. And it is for that reason that, we were given a tender in 2024, operating from 2024 onwards, to set up a plant in Warangal, which is 700 kilometers away. So, they did not have any operations in the state of Warangal. They did not have agencies there. They did not sell milk in the state of Warangal. And KMF therefore gave us the contract.
District of Warangal.
So, sorry, in the district of Warangal. And therefore, KMF gave us the contract. We, on the basis of that contract, we went and established a plant there. We invested 30 crores for that. And therefore, today, it can't be said that you don't have that right. And in fact, the other point which I should bring to your lordship's attention, in fact, this has been the basis on which the writ petition that I filed, in fairness, has been dismissed. When a contract was given to them, I challenged the tender, and the court said, rightly, that you did not participate in the tender. So therefore, you cannot challenge either the tender conditions or the outcome of the tender. But what is relevant is when this tender was given to me, it was done in an open, transparent manner. Tenders were called for, people bid, and I was selected, and the contract was awarded in my favor. The same principle therefore must apply, which is that if you have not participated in the tender, and the petitioner admittedly did not participate in the tender for Warangal district, they cannot now come back and say
that is a general principle of tender where the person is not. Okay, you can argue it only.
And therefore, a contract that is executed pursuant to that tender also cannot be challenged for the same reason.
Yes.
It would have been different if they had come to this honorable court before the tender was finalized or the bids were open, and they could have come to this court and they could have said that, sorry, they don't have the power to float this tender because these are rights that have already been conferred on me. They don't do that. They don't participate in the tender process. Bids are submitted, bids are opened, and bids are finalized. I am chosen as the bidder, the successful bidder. A contract is awarded to me, and at that point in time, they come before this honorable court and they say that, sorry, you can't give them the tender because these are all rights that I have. And in fact, this honorable court had, in fact, after giving them an interim order on an ex parte hearing, they modified, this honorable court modified the order saying that your rights are confined only to Hyderabad. This is a tender as far as Warangal is concerned, over which you have no rights. So therefore, on that basis also, as far as this co-packing writ petition is concerned, their writ petition is liable to be dismissed for this reason.
So are you selling in outside Hyderabad?
I'm not. I don't. I cannot operate in Hyderabad. I will not.
Outside Hyderabad.
I set up a plant, and I had purchased milk, and that milk, I couldn't in fact sell because there was an interim order by then.
So you said it's modified.
Yes. But after that, what has happened is this. So, there are two petitions. One is co-packing, which is I have a plant, where my lords, milk is brought in, I store it, I cool it, I pack it using packaging material, and from then on, my lords, then it has to be distributed by the marketing agency, which is the subject matter of another contract. So, my lords, the interim order was modified insofar as the co-packing contract was concerned, which is, my lords, I could therefore procure milk, I could store it, I could pack it, but I can't sell it. Because, my lords, in the other matter, my lords, there is an absolute stay. So therefore, my lords, I effectively could not operate.
You should have asked for the same modification at that time.
Well, as we did, and in fact, we sought for impleading immediately, and we sought for modification on the same lines. And we said, Malaj, I don't intend to operate in Hyderabad. I don't want to encroach into their territory at all. But Malaj, please allow me to operate in a place which is 700 kilometers away. I'm not Malaj encroaching into their market. I'm not trespassing into their market. Malaj, Warangal is 700 kilometers away. They are not operating there, admittedly. Malaj, they had no operations there. KMF says so, and therefore, Malaj, that is the reason why they've given me this tender. So today, Malaj, we are in a situation where, Malaj, that is a region where they are not exploiting. They may have done something after the writ petition was filed and after they've gotten into.
What is the status today?
Status today, Malaj, what I'm told, Malaj, my instructions are prior to the filing of the writ petition, there was not there was no agent, there was no operations. But after the writ petition was filed, Malaj, I'm told that they may have appointed probably some distribution agents in Warangal.
But any work happening, any sales happening?
That they will have.
Anyway, their agreement is coming to an end next month.
Malad, this will be evergreen. And Malad, that is a very interesting aspect which your lordships will find in the marketing writ petition, Malad, which is 23487. There is a clause, Malad, which on the face of it is unconscionable. And I'll show your lordships why. Let's kindly have the writ petition filed in 23487.
Yes.
Annexure G may kindly be seen, my lord, at page 22.
Yes.
Well, this is the contract on the strength of which the writ petition has been filed. It is a contract given by Hassan Cooperative Milk Producers Society Union to the petitioner. My lord, may kindly see period of contract. The currency of the agreement as per KMF approval commencing from 1/4/2019 to until further orders. So, Malad, this is not a case where in 2 months' time, Malad, this situation will go, there will be a new set of bids, etc., a new contract will be awarded. This is a contract in perpetuity. The currency of the agreement as per KMF approval commencing from 1/4/2019 to until further orders. KMF has never approved this.
Yes.
And Malad, the law is very clear. Where is that Noida judge? Malad, a clause like this, Malad, is offensive of public policy because Malad, this
is not.
It is unreasonable on the face of it. Malad, there is a judgment. Malad, I won't trouble your lordship at this hour. I'll just write a short note.
No, you have to tell us what it is so
very
that
well.
they can respond to it. If we just leave it, they can't respond. You'll have to mark out the para numbers.
Well, it's I'm just relying, Malad, on the Noida Toll Bridge Company.
The others you don't want to rely on?
Well, the relevant portion is at paragraph 67. At page 748 of the judgment, my lord. That is inked page 32.
Ink page 67 or ink page 32?
Ink page 32, my lords.
Ink page 32, yes.
And page 748 of the SEC,
Yes.
paragraph 67. The High Court, while analyzing the reasonableness of the formula adopted, held that Article 14 of the concession agreement was perpetual in nature and it entitled so-and-so to recover user fees or toll indefinitely. Such a clause, therefore, being opposed to public policy, was unjust and arbitrary and liable to be severed from the concession agreement. So, my lords, if this is the contract which they are relying on to say that I cannot market in the district of Warangal, my lord, on the basis of the contract in their favor entered into in 2019, my lord, that is an argument which does not take them anywhere because on the face of it, applying the law laid down by the Honorable Supreme Court, it's a contract opposed to public policy and under section 23 of the contract, it's void. It's void ab initio.
See, but the problem, please understand, we are only deciding what they have filed. Nobody has challenged this before us. All the things that have happened in their favor is not challenged before us. You are only offering a defense to what they have alleged. By way of a defense, that contract cannot be set aside.
And the defense is this, that they don't have a case. They don't have a case
But
in
the
private
fact
law, they
remains-
don't have a case in public law.
So long as that agreement continues to be there, what was here, it was challenged, right? The concession agreement was challenged.
Well, I'll amend my pleading, my lords, to seek a specific declaration that this particular contract be declared as void as being opposed to public policy in the light of the Noida toll bridge judgment. My lords, that is if I'm seeking a positive relief. But my position before your lordship, my lords, is that the petitioner who has approached this honorable court, who has the burden of proving their case before this honorable court, has failed miserably, my lords, because their contract, which is, my lords, the basis of their prima facie case to say that we have legitimate expectations, we have vested rights, is based on a contract which, my lords, is void ab initio. So therefore, my lords, the petitioners have not made out a case, not a prima facie case, not an absolute case, not a case for grant of an interim order, and certainly not a case for grant of, my lords, final relief in their favor.
That's a very high bar that you're putting into it. It is for KMF to have challenged it. They've just said that and left it at that. They should have issued notices cancelling. We can't say what they should have done. Sorry.
Well, as my respectful submission, my
There's
lords,
so many things which none of you have done, and you are, we don't know. The concerned have done a lot of things.
I quite see, my lords, but
when that is not done, we cannot decide on those things which are not an issue, right?
Well, your lordships can, and this is the way, my lords, it can be decided, and I would respectfully submit, my lords, it should be decided because, my lords, of course, your lordship is absolutely right. My lords, the correct way of doing this was, my lords, I should have filed a separate writ petition, or, my lords, at least sought a relief by way of a counterclaim in response to that.
Not you.
But maybe KMF, my lords, but ultimately, my lords, this is something which, my lords, offends public policy, and that's what the Supreme Court has said. When there is a contract, my lords, which offends public policy, and that contract is relied upon as the source of the vested right and the legitimate expectation to say that we have this contract, please protect our contract, please enforce our contract, please ensure nobody else, my lords, operates because we have the benefit of this
Who can
contract.
challenge a contract, Mr. Nair? Who can challenge a contract? Only the parties to it. You are not even a party to it.
That
You are
is
claiming under some other action of one of the parties.
that is in the realm, strictly speaking, of private law, my lords, where only the parties to a contract, because, my lords, as far as private law is concerned, my lords, private law only allocates rights between two private parties. But in a public law setting, where, my lords, the rights that they have in a contract with KMF Hassan is used as the basis for saying that another entity cannot confer on me rights, my lords, then this is a completely different situation. I have no remedy, my lords. I can't say I will step into the shoes of KMF Hassan and say that the contract that you entered into with KMF Hassan in 2019 is void. I can't do that. So therefore, my lords, if in a public law proceeding, they are using a private contract to say my private contract with KMF headquarters in Bangalore is not tenable because it steps into or encroaches into their private law
The
rights.
contract is with KMF headquarters or with Bellary?
Lords, my contract, my lords, is with respondent number 3, which is Bellary.
Bellary. That is why you are not with KMF. You are with another constituent.
My lord, which according to KMF, my lords, is the authorized holder of powers, which is the authorized delegatee.
Anyway, you complete your argument. Why should we interrupt you? You go with what you were saying.
My lords, I quite see what your lordships, but my lords, I'm in a position where, my lords, there is no way as a matter of private law where I could challenge the validity of their contract. I can only say, my lords, is that if they, relying on a private contract, has come before this honorable court
You
in a
may have
written-
other, this one of damages, all those things may be available to you. Our scope in this writ petitions are limited to what is available before us, is what we are trying to say. All these arguments you are free to address. We'll deal with them. But our hands are tied to deal with those, many of those, some of them we may be able to take into consideration. A lot of them we may not be able to take into consideration. Consideration in the sense we'll consider, but it won't help you.
But my lords, when they're effectively challenging a contract that has been awarded, this is what they have done. My lords, they have effectively done the same thing. They are saying that KMF or KMF's nominated union, which is the Bellary union in my case, does not have the power to award a contract for marketing to me. So, my lords, and that contract has been awarded. So effectively, what they are trying to do then, my lords, in a public law proceeding is that they are saying that a private contract entered into between B and C, to which they are not a party, should not be given effect to because they have a contract between X and Y.
Yes.
Which then,
Which
my lords,
contract
by
has
that
not-
analysis cannot be granted.
Which contract has not been challenged? That is why there's a distinction there. A very subtle, nuanced distinction. Legal distinction is available between both. You might have had a great case if we can't say what. That is not something that we can say. But the point is, what we, last time we'll say this, what is available on record is that the contract between them is not challenged, not cancelled, not terminated. Nothing has happened.
And therefore, my lords,
That continues to be valid. So we'll have to take that contract and interpret everything.
the entreaty that I'm making to your lordships, my lord, is your lordships' powers under 226 jurisdiction are not trammeled. So, my lords, if, my lords, a petitioner approaches your lordships and, my lords, says that we have legitimate expectations, we have vested rights on the basis of a contract, lords, which on the face of it is contrary to public policy, your lordships will not enforce that contract. Your lordships will not, my lords, award them relief on the basis of a contract because ultimately, my lord, their right is purely contractual. Whereas when they approach this honorable court and say that because we have a contractual right, please injunct X and Y from awarding a contract in favor of Z, purely on the basis of this contract, which is contrary to public policy. Well, that's my submission. So therefore, my lords, your lordship is absolutely right. My lords, I should have done something else, or maybe KMF should have done something else.
They
My lords,
should have done.
They should have done that. But my lords, for whatever reasons, my lords, our apprehension is that it may not be done, or it may not be done for a very long time, by which time, my lords, all the damage would be done.
That
But
means-
the only point, my lords, is the fact that they have defaulted, my lords, does not, my lords, deprive this honorable court of powers to say that when somebody comes before me and says that we have a case based on a contract, your lordships is fully entitled to say that, sorry, you don't have a case because the contract which you're relying on to get relief from this honorable court is unenforceable because it is contrary to public policy and your contract is void under section 23. I don't have to declare it here, but this seems to be the law that has been laid down by the Supreme Court. And if this contract,
Give us a judgment to that effect.
my lords, I will
It gives
definitely,
us that power to do
in
so.
terms of, my lords, them not proving their case, even if I don't seek a positive declaration of their
That
contract.
general concept is there. When a contract is not challenged in the, how you are applying it, if there is, because we are finding a little difficulty there to exercise that jurisdiction. Is that to probably go beyond what is, and until we read all the files, read all the judgments, that's a different thing. We'll be asking questions here, or that table tennis will
But
be
if there is a
happening.
judgment, I will certainly place. But my argument is only on the basis of first principles. My lord is absolutely right. My lords, there is a private law remedy. The second is, my lords, your lordships are also entitled, my lords, in a public law proceeding to ask the question whether a person who approaches this court on the basis of a contract which is void, my lord, does that entity, my lords, just because a interested state entity has not challenged the contract, does that entity then have, my lords, unfettered rights on the basis of a contract which on the face of it is void? My lords, all that I'm asking is for your lordships to say that, sorry, you have not established a prima facie case to get the relief that you're asking for in the two writ petitions that you have filed. That's the short point. My lords, if there is a judgment on this point, I'll certainly find it and I'll place it on record. My lord, the work order, my lords, I'm corrected, my lords, is actually issued by KMF Bangalore to me.
Work order?
This is, my lords, annexure. Well, it's annexure J of WP 23-487. It is a work order given in favor of, my lords, us by KMF Bangalore.
Annexure?
J, my lord.
J is produced along with, where is J? In which petition?
My lord, 7/11/24. But I'll just take a minute, my lords. 7/11/2024.
It's filed along with an application. It's filed along with an application. Amendment.
When was it filed?
IA 3 of 25.
Date.
But filed on 12/3/2020.
I'm grateful, my lords. I'm grateful to my
12/3.
learned friend, my lords. It's an IA for amendment that was filed
Yes.
on
It's
12/3,
issued by
2025.
Raichur Bellary Koppal and Vijayanagar district governments. In fact, their work order is by KMF.
My lord is right. My lord is right.
It's the reverse.
My lord is right.
You are Raichur Bellary Koppal. Their work order, Annexure A or B of the writ petition as it was filed is KMF.
My lord is right.
Not even by Asan. Subsequently, they delegated to Asan and go ahead. And if you remember it right, the first one has Telangana there.
My lord, the first.
Annexure
Yes.
A of the writ petition. Annexure A, yes. See, it is Karnataka Cooperative Milk Producers Federation Limited, 18/4/25. Annexure A is by
And therefore, my lords, it couldn't have been
the
that.
petitioner. And if you look at it at the fourth line, entire Telangana state.
Well, that is the first contract, because Malas, there was virtually nobody else then. Telangana state was the first
Even when
one.
they were given second time, third time, nobody else was there.
But Malas, subsequently, Malas, and what was delegated to Malas Hassan was Hyderabad market.
But what has been issued by Hassan at Annexure G is entire Telangana state in terms of the same first one.
Malas, which could not have been done, because Malas, what has happened in this case, Malas, if your lordships will
Because
see
even
the
if the delegation, it's a little difficult, it's far-fetched. Anyway, we are not arguing against each other. You finish your.
And therefore, Malas, if in fact, Malas, they had a grievance that Malas, somebody else is encroaching into our market, etc. Malas, that power is in fact reserved to itself by Malas, KMF and Malas in their contracts also, which shows Malas, that there is no vested right and there is no legitimate expectation to the entirety of.
Absolutely, no dispute about it.
And therefore,
What
Malas,
should KMF have done on that?
So, Malas, the contract itself says that the scope of your operations can be curtailed by KMF for our operational reasons. And that is exactly what KMF has done by saying that your operations are confined to Hyderabad and therefore we are giving to somebody else because you have not been operating in
There is
Warangal.
the correspondence to them on that, where is the notice to them on that? Curtailing. When you are curtailing, there is something which is being taken. So there must be a notice which is.
No, I'm grateful. Which Malas does not seem to have been issued. But Malas, if they are aggrieved, Malas, then their grievance is a purely private law remedy, which your lordship said, in fact, Malas asked my learned senior friend, Malas, isn't your remedy then, because it's a purely contractual violation, that you were not.
We'll be asking you, both of you, uncomfortable
So
questions.
therefore, Malas,
That is our job.
because that is at most, that becomes a breach of contract because the lack of a communication, because Malas, if the contract expressly envisages that the scope of their operations can be curtailed. If this has not been done by means of a written order to them, Malas, their grievance will be that you have not done what was supposed to be done in accordance with the provisions of the contract. But that's a purely private law remedy, Malas. It can't be a public law remedy, and it can't be used as a public law remedy, Malas, to defeat my rights. When I, on the basis of the contract awarded to me, have gone ahead and invested in this infrastructure, I spent 30 crores, I've taken on debt, I've taken on employees, all of whom have been lying idle for the last 1 year. And in fact, most of them are leaving, Malas. And now to add insult to injury on top of all of this, Malas, KMF sends me a notice saying that we gave you a contract. You were supposed to start manufacturing from last April. You have not performed your obligations under the contract, and therefore we are now going to encash your bank guarantee. Malas,
Is that notice?
Malas, it is on the basis of that, Malas, which your lordships had in fact stayed the encashment of the bank guarantee. Just give me that. Malas, we had in fact filed an application before your lordship, Malas, challenging that. Just give me that.
IA number?
IA number?
In which matter?
Well, this is filed in WP 22850.
Filed on?
I'm told this is IA number 4, my lord. And at I number 2, my lord.
This is when we started hearing the matter.
Yes. So my lords, document number 3. Sorry, document number 4, my lord, is a letter sent by KMF Bangalore to the branch manager Punjab National Bank, inviting references. The work order has been issued to Shakti Milk and Milk Producers for co-packing of Nandini milk and curd in the state of Telangana through Raichur Bellary Koppal Milk Union for a period of 2 years with effect from 10/10/2024. As reported by MD so-and-so, the supplier contractor Shakti Milk and Milk Products have failed to execute the service, fulfill the obligations under the contract as per the work order. In the light of the above, please register the full claim and release the guarantee amount of rupees 21 lakhs. So, my lords, my entire investment has gone waste. I am not in a position to service my debt. My workers are all, my lords, deserting the sinking ship. And now, my lords, on top of all that, my bank guarantee is being encashed. And therefore, my lords, my respectful concluding submission to your lordships, my lord, is that we may be allowed to operate this contract. My lords, we will supply only in the district of Warangal in terms of the work order that is issued to us. It is not a territory which is being exploited by the petitioner. My lord, it is 700 kilometers away from their plant. It is, my lords, almost physically impossible to deliver milk over such long distance. Otherwise, my lords, from Karnataka itself, they would have supplied it. So, my lords, the whole idea of having their plant is only based in Hyderabad. My lords, our plant is based in Warangal. My lords, that's the reason why, my lords, we were giving this contract. My lords, we will, of course, my lords, supply only in the district of Warangal, my lords, and we'll limit our operations to that. My lords, this is our respectful submission for this honorable court.
Yes, Mr. Patil. New everybody.
In view of my submission, what I made last occasion, my concentration was focused on getting the solution. Anyhow, I won't seek time, but I may be permitted to file written submission.
Of course, my lord, I would respectfully submit what has been transferred by KMF is available on documents, and thereafter KMF has not taken away that or restricted that at any point of time.
If KMF has the right to do it, that right cannot be disputed.
Please.
It has been done expressly or impliedly. Expressly, it has not been done. There's no doubt about it. We've asked so many questions, they did not come out. Impliedly, by way of issuing this tender and by asking Raichur Bellary.
Impliedly doing it also, my lord, is something I would put it in this way. Even for doing that, they may have to have in their own way something with regard to existing contract and what we are doing. That is something which, as I on the first day itself pointed out, in doing that, minimum that was required to be considered by KMF before doing all these things, that such and such a thing has happened, contracts are existing, but we are restricting it and we are proceeding to do something else.
Annexure H, what you challenged, the objections that they have filed. Now, more particularly, this notice that KMF has issued that they are going to encash the bank guarantee because they are
encashing of bank guarantee, etc. My lord, I would say it is something either for the purpose of creating a ground for vacating of interim order or for
a document of
document of KMF itself. Document of KMF itself is something that is being done because.
Are you making allegations against KMF, Mr. Patil?
I would say this
That-
document
Yeah,
emanating of this
no,
document
We are
and
asking you
this
this because we'll have to deal with it.
emanating of this document is something
Is your submission that KMF has fabricated a document?
not fabricated.
Mate, what is your submission?
Not this even as KMF is a respondent or anything else, when this matter was pending and these orders were there, KMF issuing such a communication is something which is totally outside their authority to do
What
it.
do you have to say about KMF's objections?
KMF's objection, I put it in this way, my lord. They are claiming that it is only KMF which has the power to do it. That is something which is left to Hassan Union to deal with the KMF. But as far as today I am concerned, the petitioners in both these petitions are concerned, I am pointing out this is something existing on an authorization issued by the KMF itself. In modifying it or in doing something, minimum was consideration of these things.
You are not to be considered.
Not
At the
not
most,
me.
it's between
I'm
KMF
not
and
asking
Hassan.
that notice to you.
You have another problem. Between all of you, you have been fighting like this for last whatever 2-3 years. Hassan has not challenged KMF's action.
Hassan is taking its own course in doing that. What I am pointing out is, my lord, as an agency or as an instrumentality of the state, the minimum that was required to be done by KMF in awarding contract or doing anything, something to say these things have happened. No, now it is confined to so and so, we are proceeding to do. So that there
whom
is
should they have
application of mind.
To whom should they have issued? the
No,
notice?
that how they do it is different. What I am saying is that is something which should have been done. Application of mind.
Done in what manner?
In a manner, I think, my lord, the minimum was put it in their committee, take a decision, noting these things, that these disputes have happened at some point of time. Therefore, what we are going to do.
There's no dispute. Who has disputed?
No. Once they tried to do it with Shumoga Milk Union, Hassan protested. They withdrew that order.
Correct. No, Hassan has not done it.
Here again, Hassan has protested, but they have not withdrawn. No, they have not withdrawn because now presently, till at least the another month or so, I am the affected party.
All of you are derivative claimants. You are derivative claimant of Hassan. Mr. Nair is a derivative claimant of Ballari. The derivative claimants are fighting among themselves without the main parties having taken any action. And as Mr. Nair said, this is a public remedy. This is not a private remedy.
Yes, my lord.
In private
On the
remedy,
very
you
first
can
day,
have
your
evidence to
lordships
be
put
laid,
that-
etc. Here
put
we'll
that
have to go
question,
by
my
what
lord.
is there on record and the affidavit as to what it is. We'll have to see who is to take. When the fact that we are asking you this question doesn't mean you have got a bad case or
No,
asking me
it's
is a
not
bad
that.
case. We
On
don't
the
know.
other-
These are
on the
we
other
are
hand,
grappling with these issues because
on
it's
the
a
other
peculiar
hand,
matter.
on the first day itself, your lordships asked that question, and I am mainly relying on ABL and pointing out that even in taking those decisions, a minimum consideration of all these situations, I'm not stretching it to the extent of a notice being given to me. Maybe that could have been done through Hassan. That's a different. The fact situation existing before doing something else.
Essentially, it comes down to if we go down that line, it comes down to the maintainability of the petition and the locus.
Please.
So if that goes, then on that technique, though of course it's technicality, we normally don't go to technicality. But in this peculiar matter, it becomes very important. First, we'll have to decide on your locus to file the petition. And the only problem is whether we can pass this order before your expiry of the idanthara operation, even if successful,
ಆಮೇಲೆ,
patient dead.
of course, apart from
I'm
all other
almost on the
things,
verge of death, my lord, unfortunately.
the,
Unless, that's why we said, go see if you can do a settlement that is faster to happen in the
No,
next week.
that's a political process, my lord, and there is no light at
Not
the
going
end of
to
the
happen.
tunnel.
You've been instructed. We thought that could be done.
We of course, Manoj, did everything that we could, Manoj, to present our case, ask them to view it with sympathy, and we were hopeful. And then, Manoj, we were faced with this thunderbolt of, Manoj, the bank guarantee being encashed, and then we realized, Manoj, that there's no point in going down that route. Manoj, our only relief that we can expect, Manoj, is from this honorable court.
as the things stand, my lord, Bellary Milk Union do not have the surplus milk to supply.
We can't be getting into all
No,
those
no, no.
things. How much Asan has, how much Bellary has. who
ಅಲ್ಲಲ್ಲ
has.
ಅವರದ್ದು it's a their own returns and audit reports point out that.
Heard reply arguments of Sri Hilva. Reserved. No, you want to file your written submission. When will you file your written submissions?
Within weeks time.
We'll list it on, relist on, today is what, 5th. By 13th you'll file it, or week after that?
We'll
When
file by
will you-
13th.
By 13th, so we'll have it on 16th. All the councils submit that they'll file their respective written submissions by 13th. Relist on 17th to verify the filing.
Very sorry to detain you, Lord. It's past 6 o'clock now, and we're very grateful for your patience.
We sit every day, Mr. Patil knows every day it is 6 o'clock only. Because he has to come and argue only after 4:30.
Grateful, deeply obliged.
Grateful.
ಎಲ್ಲ 26 to
Thank you.